Yeah. It's lack of tech. You're fine, Travis. It's fine. Everything's fine. I will figure it out. Everything is fine. Ah, man, some mornings, at least I got some decent sleep last night, so I don't have like the curmudgeonly problems I did yesterday, or at least not as bad. At least I got some solid sleep, so I'm not like beating myself up from just being tired in addition. So I wouldn't go so far as to say I'm well rested, but at least I'm better rested, and thank God for that. Oh, geez, this is jank. Oh, this is the most jank. Oh, this is pretty jank. All right, that's fine. We'll make it work. This is pretty jank. This is pretty jank. All right. Hold on, please. Talk amongst yourselves for a second. Okay. Court TV feed. Okay, great. So I need to remove that feed for a second, and I need to add in a new thing. Okay. Hold on. And then I need to do this. Yeah, that'll work. And then I need to like make it look kind of like this. All right, this is a little jank and might be a little blurry, but we're gonna press on. If this is a little blurry, we're gonna press on. All right. So apparently this is a transcript of the instructions the judge gave yesterday. This is a transcript of the instructions the judge gave yesterday, and the portion in blue is the new portion that has been added. So we will see what it says and see if it provides any additional insight in exactly what's going on. And thank you, Travis, for sending this over. I do appreciate it, Travis. You're the best. So apparently here are the new exciting instructions, or the revised exciting instructions. So in reaching, we'll just read the amended portions, I guess. Reaching a verdict. Please consider the evidence as a whole. Do not make up your mind about what the verdict should be until after you've gone to the jury room to decide the case and you and your fellow jurors have discussed the evidence. Please keep an open mind until then. For each indictment, that's count 1, count 2, and count 3. Those are the indictments. I would have preferred to say for each charge, or each, like how they're labeled on the top, because I think it's, how's it labeled? Count 1, count 2, count 3. So I would have preferred to say for each of count 1, count 2, count 3, depending on exactly how it was labeled on the top of the sheet. Because what is an indictment? What is an indictment? Even the court apparently doesn't have a copy of the indictment. Because remember that from yesterday? They're like, does anyone have a copy of the indictment? And apparently the answer to that question was no, which is super exciting. Like, apparently the question, does anyone happen to have a copy of the indictment? Does anyone have a copy of the indictment? Apparently the answer to that question is no, which is hilarious. So if the court doesn't even have a copy of the indictment, how is the jury supposed to know what an indictment is, right? It's not labeled indictment 1, 2, and 3 on the top of the jury's sheets, I'm pretty sure. I think it's labeled count. But whatever it was, I would just mirror the language of the jury verdict. Because what the hell is an indictment? From the jury's point of view, what is an indictment, right? So not ideal instructions right from the top, but we press on. For each indictment, you must decide where the Commonwealth has proved beyond a reasonable doubt that the defendant is guilty of that specific charge. Again, why not just use the word charge twice, right? Why not just say for each charge, you must decide whether they're guilty of that charge? Why say for each indictment you must decide whether they're guilty of the charge? Fuck me, right? And fuck me if I'm a juror, right? That's just fuck me if I'm a juror, I guess. Your decision as to each charge, and again, your decision as to each charge must be unanimous, meaning all 12 deliberating jurors must agree. You will receive one verdict slip for each indictment. Fuck me. Just call them a charge. Just use the same word. Just call it a charge each time. What is an indictment? It's not labeled indictment on the top of the sheet. What's an indictment? Am I supposed to have a sheet reflecting? Am I supposed to have a sheet that talks about indictments? Where's the sheet? Where's the sheet that talks about indictments? I don't have it. Also, in every case, isn't there only one indictment? Is there a case with more than one indictment? I mean, there can be amended indictments. They can amend the indictment. But is there a case in which there is actually more than one indictment, like simultaneously running? Is that a thing? I actually don't know. Is that a thing? Is that possible? Is it possible in a criminal case for a jury to have a case in which there is more than one live indictment at the time? Is that a thing? Does anyone know if that's a thing? I was under the impression that there's only one indictment. There can be as many charges as you want, of course. But I was under the impression there's only one indictment. Is there more than one indictment? Is that a thing? I don't know. Probably in some jurisdiction there is. Passing on. When all 12 jurors agreed to the verdict for each particular indictment, and again, where is this indictment thing I'm supposed to be talking about? The foreperson should check off the verdict and then sign and date the slip in ink. For each charge, back to that word charge again, if you all agree that the Commonwealth has proved every element of the charge to be beyond a reasonable doubt, then you should find Ms. Reed guilty of the charge. On the other hand, if you all agree the Commonwealth did not prove one or more elements of the particular charge beyond a reasonable doubt, then your verdict must be not guilty. So again, that difference between should and must. So technically, jury nullification is allowed, right? Because she said should. So I would not be breaking any rules, right, as a juror if I thought guilty in my own head but voted not guilty. Because the way it says, right, just read the words on the page, right? If they didn't prove it, you must. But if they did prove it, you should. Right? So if I, as a juror in my own head, thought that the state proved each and every count, I should vote guilty, but I don't have to. Right? So if I voted not guilty, even though I thought, you can call it jury nullification if you want, but the instructions allow for it. So I'm not doing anything wrong. Which I think is interesting, because I think in some jurisdictions they do say must. I think in some jurisdictions they say you must find guilty. But in this jurisdiction they say should. And that difference between must and should is a very powerful difference for a lawyer in particular. In on the joke for $5 with a bunch of questions. Can the jury find them guilty of DWI, OUI without finding her guilty of manslaughter? Yes, they absolutely can. Yes, the fifth item on box two, the fifth item in charge 2 is just straight, no nonsense, uncomplicated DUI, OWI, or whatever the fuck we're calling it. Yeah, it's just driving under the influence. That's it. So yeah, it is a bit confusing because at the top it says count 2, manslaughter with OUI. So you would think that if you're finding her guilty, right? You would think if you're checking one of the guilty boxes, you would think pretty reasonably you must be finding her guilty of manslaughter, because at the top it says count 2, manslaughter with OUI. So the guilty options must be manslaughter, right? But it's not. It's not, because of this weird thing, this weird one trick, because of this lesser included stuff. So I really wish the judge had clarified that. That would have been really nice, because while the jury doesn't need to understand the consequences of its guilty verdict, they should and do need to understand what they are returning a guilty verdict of, right? They don't need to be concerned with what does that mean in terms of sentencing, right? Because that's not important as to guilt, right? Liability and penalty are different things. They're different phases for a reason, right? You don't need to be concerned with penalty. You need to be concerned with liability. So the jury not understanding what does it mean in terms of the consequences is perfectly fine. But they need to understand what it is they're doing, right? What crime am I convicting her of if I check this box? Can you please clarify that? And for some reason, the judge won't do it. I don't know why, because it would, yes, if you check box 5, all you're finding her guilty of is driving under the influence, box standard DUI, OWI, or whatever the fuck we're calling it in the state. Arose by any other name, driving drunk. That's the only thing you're finding her guilty of. But the judge won't clarify that, and so the jury might be confused. Yes, so all those things. Great. Travis says it's possible. Where is he where he said this? Travis said where's the tweet? Travis said something. He said it's possible with the indictment thing. Yeah, it's possible, but they typically do have multiple counts in one indictment. Right, because it's read to the jury at the start. Right. So it is possible to have more than one indictment in the same criminal case that's live. Cool. I've learned something today. I've learned that it's possible to have more than one indictment that's live at the same time. This is a weird thing, but I guess it's possible. Great. All right, moving on. Red Guy 123444321 for $5 says if she's just guilty on OUI, it would be not guilty of manslaughter. Correct. If it's number 5, it is just DUI. It is not manslaughter. Right. So sentencing for the random dead body in the snow should be irrelevant. Under Massachusetts law, that's correct. Under federal law, it's not. But under Massachusetts law, it appears to be correct. So federally, the federal law would allow her to factor in the dead body. The federal law would allow her to factor that in. But the state law does not appear to allow it. So that's really good for Karen Read. So if she's found guilty of the DWI, it appears under the state law that the judge cannot, as part of sentencing, factor in any fact for which she was acquitted. Like, for example, the dead body would be such a fact. The federal law would allow for it. The state law does not appear to allow for it. And the state can provide more rights. That's fine. So there's no conflict. This is fine. So the judge would not be able to factor that in. So she would only be, she can't factor in any fact, it appears. She can't factor in any fact for which she was acquitted. She could factor in other facts that have not been, she could factor in other facts that have not been proven thus far, because you can have new evidence during a sentencing phase, and that's not uncommon, right? For example, just to make it really clear, the most common thing that you will bring into sentencing that you would never bring into liability is your prior criminal history, right? The jury will not know and should not know during liability, that is, did you do the bad thing? Liability is, did you do the bad thing, right? As opposed to what should we do about it, right? So the jury will not know whether or not you did a bad thing in the past, right? They're just trying to figure out whether or not you did this bad thing. So any criminal history you have is irrelevant and will not be presented during the guilt phase. However, it can be presented during the sentencing phase. So that would be new information, right? And the state has to prove that. They have to prove that you've been convicted in the past, but it's only preponderance of the evidence. And of course, proving it is pretty trivial because all they really have to do is show the certified court record that, from the various jurisdiction, they just have to present the certified record that shows the guilt, and that's pretty much the end of that game. So they do present new evidence, they do have to establish it, but they only have to prove it to preponderance. Okay? So the only things that show new information could be brought in to the sentencing, but it can't be information, at least in Massachusetts, for which he was acquitted. So I don't know what that would be in this case. There has been no suggestion at this point as to what that could be. So I don't know if there is any, I don't know if the Commonwealth would want to bring in information, relating to whatever. Like, for example, at least the federal law, and we haven't seen a state law to the contrary. But let's suppose, even though she's never been convicted of it in the past, let's assume that Miss Reed is a habitual drunk driver. She's never been convicted of it. She's never even been charged about it, but she's a habitual drunk driver. The state would be allowed, at least as a matter of federal law, and state law maybe too, but they would be allowed to bring in witnesses who could say that she's a habitual drunk driver and she's drunk drive in the past. And that then they would be, the court would be allowed to use that information in the sentencing of the DUI. So if they could present that to a preponderance evidence standard, that would be allowed. There's been no suggestion of that. There's no information relating to that. We don't have that. But that would be the kind of thing that appears to be permissible. So anyways, that was a very long-winded answer to your question. Anyways, there is another page of this thing. So, so also the other page says, the state didn't ask for the DWI sentence. Well, no, not yet, but they will. If she's convicted, they don't have to ask because we haven't gone that far. So if she's convicted of the OUI, I mean, there may be a sentencing hearing. I don't know how they typically do it in the state. I don't know. Maybe there's a sentencing hearing. Maybe there's not. Maybe the state doesn't want to have a sentencing hearing. Or maybe the defense doesn't want to have a sentencing hearing. You don't necessarily need to have one. So maybe the state doesn't present anything more, and maybe they ask for sentencing, immediately. Some jurisdictions do that too. Sometimes they do it sometimes they do it in serious cases. We've seen it. It was Florida, I think, where they basically did sentencing like immediately in a murder case. I'm pretty sure I saw it. Like, it was a murder case, and the jury convicted, and the judge then like literally sentenced them like immediately. So they didn't do like the pre-sentence investigation. They didn't do any testimony. The judge was like, okay, the jury just found you guilty. I now sentence you to whatever. And that was the end of that discussion. So that sometimes happens too. Sometimes in serious cases, apparently. But in any event, so maybe she sentences immediately. If she's going to sentence immediately, one would presume it's going to be to whatever the bog standard first. It would be the bog standard penalty for a first degree or for a first time DUI, which seems to be like classes of some kind. Seems to be like the bog standard penalty. It seems to be some sort of, alcohol and you bullshit, class thing. So seems to be like what it is. So if there's going to be an immediate sentence, that's probably what it is. But in any event, whatever. When you return to the jury room to deliberate, the court officers will deliver to you all the exhibits in the case, as well as the verdict slips you'll be using in returning the verdict. The foreperson will be given the verdict slip setting forth a charge against the defendant. 12 jurors must agree before you have a decision to any specific charge. This means that to find the defendant guilty, all 12 must agree. I'm not sure how that's any clearer than what she said in the previous sentence, but whatever. You should consider each indictment individually. Again, I would probably go with must here rather than should, because each charge is separate legally. So instead of should, I'd go with must, but whatever. You should consider each indictment and also charge instead of indictment. You should consider each indictment individually and continue deliberating until you reach a final verdict, and then they strike out on each charge for some reason, which, whatever. All that stuff. Oh, he sent me a text. Oh, hold on. Sorry. I've been busy. I'm confused and things are mysteries to me. Yeah, let's punch on with Defense Diaries. Hold on, talk amongst yourselves. Thank you for letting me know. Uncivil is not being observant. All right. By the way, just FYI, you may not see them on screen initially because I'm doing this the jank way. So I have to set it up so that you can see it. So if you just hear the voices for a second, it might take 20 seconds or something because I'm doing this jank. I can do it. It's just a little jank. So, please be patient accordingly. All right, great. Let's pump on with Defense Diaries.
Completely wrong. And like with them like fucking coming back with a hung on that stupid fucking OUI, which the problem with it is
Andy, you got to figure out how to get us so we can.
Yeah, we got like Kurt's back there too.
Andrew Meyer in the chat. That dude's awesome, man. I want to give a shout out to that guy. Andrew Meyer, he's an attorney as well. He has a channel, Law Offices of Andrew Meyer.
Oh yeah.
Yeah, I was on his show one time. He's really, really cool. He's a good dude. He's an attorney as well.
Andrew, if you're on the Twitter machine, hit me up, dude. DM me. I'll throw you a fucking invite. All right, I'm bringing Kurt on too. We're gonna have a partay.
All right.
How you guys doing?
We're checking OnlyFans back here, everybody, so no one get nervous.
I've got OnlyFans spinning in the corner. OnlyFans makes me happy. OnlyFans spins for justice. She's the best. She's the best OnlyFans performer I've ever seen in my life.
Yes, I mean,
and she doesn't even charge me a premium to see her private content. How nice!
I know, it's amazing.
Wow.
She's very giving. She's very giving.
I love it.
So I'd like to know from you guys as like your night progressed and like, I imagine it's hard to like start to drift off to sleep and not have like things that happened yesterday, like just kind of like creeping in. What angered you? What did you get more angry about as the night went on?
I drank myself to sleep last night. So I don't have I don't remember what I was the most mad about, but if I had to pick what made me the most mad, it was the way that Bev just completely disregarded AJ in his argument. Just simply asking her to be clear to the jury, simply asking her to acknowledge the rights of his client.
It's fucking insane. And Kirk, what do you think? Like the writing's on the wall, right? The judge knows the jurors have, just dismissed the collision aspect. Why still be so, I can't, whatever the word is that she's being like, why?
I know the word. I'm just not going to say it.
Well, there's the charitable answer and there's the non-charitable answer. The charitable answer is that she wants to play it like ultra safe. And so she only wants things that have been vetted and approved by the Supreme Court of the state, and the Judicial Commission and so forth. So if it's not a model instruction, if it's not a model form, if it's not a model whatever, if it is not, the tried, trusted, approved thing, she doesn't want to use it because she wants to play ultra safe. That is the charitable interpretation. The non-charitable interpretation is because, can I curse?
Yeah.
Yeah.
Okay, so the charitable interpretation is that she's a bitch, and she would rather have a mistrial than a not guilty, and so she's not going to do anything.
That's pretty charitable.
That's not uncharitable enough. Oh, okay. What is the uncharitable version? I thought that was the uncharitable version.
I'm still not going to say it because Allie's here.
Oh, okay.
Yeah.
Well,
yeah.
But and I also feel like she has got to like prove that she's the boss when she's already wearing the black robe. Like you can only have a minute. What is wrong with her? It's
not going to say it.
Say it diplomatic. Say it diplomatically. Say it with diplomatic flair. You can do it.
I mean, if can I say it in a British accent since it's
Sure.
Oh,
there?
Yeah.
Okay, and
I think we'll get a strike.
We all know.
We know
all
what you're
the
saying.
word.
We know where you're
I
going.
It does,
get it.
is C for cookie? Because cookie's good enough for me. Cookie starts with C. Is that the problem? Okay.
Yeah.
All right.
See
Yeah.
you next Tuesday. That's
Okay.
we know. We
she
know.
is such a cookie. Oh my
Yeah.
god. Ugh.
But she's, the law, from a legal perspective, when the jurors ask a question of law,
Mm-hmm.
the law says the judge should answer.
Yeah. And it would be probably helpful if the jury understands what charge they're convicting her of. That might be nice.
Right.
Like they don't need to understand what that means practically. They don't need to understand what that means in terms of a sentence. But like, what crime are we convicting of her? If we check this box, are we finding her guilty of manslaughter? That seems like a pretty reasonable question to me.
Pretty straightforward too. It's like, and the thing with her talking about that question being a theoretical. It was not a theoretical. I mean, the jurors.
I mean, it's so if, man. It's so if.
What do you mean?
Who knows?
theoretical?
Who knows what that means? Could mean anything.
It's like, because they put if on there, she turned it into a theoretical when it was clearly, all right, we've reached a verdict on 2 of the counts, but we're having an issue with this third one. And how does the fact that we've come up with a verdict on it? Because Allie was reading that in a different way than I was. She was thinking, all right, well, are they concerned that, are they flat out asking what the problem was in trial 1, wherein it's an all or nothing proposition? And I was hearing it as a different take in terms of what these jurors were thinking. Like, because I'm of the mindset that all these folks are from
Great,
that
Andy.
county. All of these folks have some knowledge about this case. Like there's no way they don't. Like, these people are all aware of what this case is about, what's been going on with it to some degree. Like, I don't think there's one person on that juror who's like, I never heard of this shit. There's definitely some kind of knowledge base there. Now, what that is, and we don't know if there were jurors that wanted to get onto that jury. You know how it is with high profile cases. There's always going to be people who are like, I want on that jury. You know what I mean? That are like going to angle if they get the jury notification, they're gonna I'm gonna do and say everything. They're Googling, how do I get on this jury? What do I need to say to make sure?
House to get on jury. House to get on jury.
Right, exactly. So, like, Allie had a really good point. I can't remember if she brought it up, and she brought it up earlier in the live, but she said it either last night or this morning. She's like they're family members because they aren't sequestered. They're going home. They're obviously somehow able to avoid social media and just the media in general, which I find to be impossible as well. But
you're not human if you're on this jury and you're going home and not talking about this.
It's insane. But like Allie was trying to keep it above board, and she's like, that person's like significant other is going to be saying, I'm not going to talk about the case, but you cannot hang. You cannot hang. And
just convict on OUI.
She's way better off if they just convict on the OUI because of the ramifications. If they hang on the OUI, that they can come back on the manslaughter, which is just like
annoying,
insane.
You just run past the bathroom and they're in there and go, don't hang.
I'm probably alone here, but I'm okay with that. But I am strongly of the opinion that any juror that pushes to convict her of an OUI is an asshole because it's so petty. It's 3 years that have been by. Why are we here? We're here for a murder. You're proving that the murder didn't even have, the impact didn't even happen. Right. So what does it matter what she had to drink that night? It doesn't matter. Not 3 years later, it certainly doesn't. So
Will, if you're a juror and you're back there right now and you're taking this, no. Even if it creeps into your mind that if I don't give, she can be charged again for manslaughter. You're going to say no?
Why would she be charged again for manslaughter? Explain that.
Because if they hang on count 2, it's the manslaughter charge. It's a lesser.
No. Okay. All right. Yeah. Let me be more clear. my prediction, and this was my prediction before the jury questions even came in, was they're going to acquit on two of the charges and hang on the OUI charge. The manslaughter charge is acquitted. That's the assumption I'm making.
See,
So
that's the problem, because
They're
that's
in-
what I think every layman and still think. Thank you, Judge Canoni, that the jury is still confused about, because you've
I'm
got
convinced of
count.
it.
You got count 1, 2, and 3, and it's clear from the last question because they use the words. If we have not guilty on 2, and we're left with, but we're not agreed on 1, is she not guilty, or is it a mistrial on all 3, or all of them, or just 1? That they are talking about the counts, the
What that-
murder count,
What
the
that tells
manslaughter
me,
count, and
what
the
that-
leaving the scene of the accident count. But on count 2, if they have one option, right? Not guilty on all, or including the lessers, and then they have to choose. If they don't choose that, they have to choose a guilty. If they don't, count 2, manslaughter on down, is in play for trial number 3, because there's no way, and the law in Massachusetts seems to want it this way. And Kurt, tell me if you're wrong, but we've looked at this every which way, that they want it to be like that. Like, that's it. You can't have you can't say not guilty on the higher offense unless you come to a verdict. So if they don't come to a verdict on the OUI and they're hung on that, the Commonwealth, can retry Karen Reed for manslaughter for everything listed on count 2.
Yeah, the way it is right now, they've got to check one of those 5 boxes on that second page.
Yeah.
Or the whole count.
Or the whole count is back. There's no way for them to express the view on that form that we have not guilty on like something, but not that. They can't do that on that form.
And it's not a strict form issue. It seems to be the Massachusetts wants it that way issue. It's like that.
It's the Bev wants it that way issue, because even Yannetti, when she tried to get validation from him last trial about this, because this is history repeating itself. So she looked for David Yannetti for validation. It was like, this is how it's done in Massachusetts, isn't it, Mr. Yannetti? And he was like, no, bro. Like, what are you talking about? So
Yeah. All right. So, Will, now taking into account that fact, because I agree with you, like, this is a murder case, and them capitulating and giving a compromised verdict of fucking OUI is total bullshit.
it is.
But now understanding that if they hang on this thing, if there's someone in that jury room that is of the mindset of you, like, dude, we're not here on some bullshit OUI case. There was no collision. John was not hit. I don't give a fuck. I am not finding her guilty on jack shit. You're never going to change my mind. But they may not understand that if they hang on it, if they refuse to do the compromise verdict, that means that these sons of bitches can bring it back a third time on a manslaughter charge. Like, so
Would that change your mind?
would that change your mind?
Probably.
Well, no. I still
Oh,
want,
no. No.
still want to fist fight the persons that are insisting on convicting her on anything.
And that's
Therein lies the rub.
horrifying.
Therein lies the rub.
Why-
That's why I'm on one.
And horrifying. Like, dude, like the whole point. I mean, no, I understand what you're saying, but that infuriates me that much more, that I'm being cornered as a juror to convict in a way that I'm being
I
led.
get it.
Right.
Like,
I
I'm
get it.
being pushed to that.
Right.
So
Yes.
this is why. Now, to ultimately answer your question, for this reason, I would have never been picked as a juror in the first place, because I would have been like, this is a fucking sham and everyone knows it. So I would have never gotten picked. But had I gotten picked and this situation was presented to me, I don't know. I feel like my emotions would get in the way, and I would insist to the foreman, like, this is not right. This is not done correctly. We're being pushed to convict her of something.
And Will,
And
you're the juror. That's what we as lawyers want our jurors to be doing in every other situation in the world,
Right.
except this one.
Right,
I'm like, remember when I told you, hold your own, don't give, don't cave, don't compromise, erase all of that. We need you right now.
Now, Kurt, I've been arguing for the past, I don't know, 36 hours that the mistake that was made by the defense team in this was that they asked for that lesser included to be attached to the manslaughter as opposed to count 3, which was the OUI leaving the scene, which carries a much less stiff penalty. Like, I think, and it's a better fit. You know, I mean, that's an OUI, flat out OUI charge. And I think that the Commonwealth would think long and hard before coming again on that charge if the murder and the manslaughter were off the table. I mean, what's your, because I think they could have asked to have it on count 3 as opposed to on count 2, and she would have been agreeable, maybe. You know, what's your position on that?
Well, I'd have to take a look again at the statutory language on count 3 because I haven't looked at it in a while. So can you pull up the verdict form or something so I can intelligently comment on this issue?
While he's pulling it up, do we think, because I've never thought about it before, that it's even something a defense attorney could ask for at this point? Say, Your Honor, we've decided, we asked for this lesser included, and we've decided we want it to be shifted over to count 3. Is it even a question that could be asked? I mean, other than that, I was like, can they say, you know what? We changed our mind. We take it off.
I think technically yes, but even I as a judge would be very reluctant to do that because when you change things that dramatically, I think that just can lead to more confusion. So I would be disinclined, even if I could do it, to do it.
Yeah.
See, at the Galera Institute of Law and stuff, we haven't taken it that far. The way we see it is, if they're going to corner us as a jury to do this, then not guilty on everything. Screw Bev. You know what I mean? Like, not guilty on everything. Like,
I mean,
you know what I'm saying?
Yeah, I hear you, and I feel you. And like I said, in every other situation, I'd be begging for a juror unwilling to compromise, you know, except here. And it's scary because you know a lot about this case. You've got lawyers explaining it to you. You understand the ramifications, and yet because of your convictions and how strongly you feel, you're saying I would still dig in and stay firm, and that could be a whole trial number.
I mean, I would have to be in that position, truly.
Right. I know, but even to have the feeling right now and to be struggling with it.
I get what you're saying. Like, you know, if it comes down to it, like if it's either, hey, we're hung, or we have to convict of an OUI so that there's no manslaughter.
They may never understand that. She will never explain that aspect of it, right?
Right.
Kurt, there's no way she'll give them that piece of information, right?
Probably not. Maybe if they ask just the right question with just the right magic words, maybe she will. But, you know, she's not going to go out of their way unless the jury is, like, you know, very clear and asks for something very specific. And even then, who knows?
Say the words, if we remain hung.
Not that word if. That word if is going to be a problem. If they said something like, we have a verdict as to count 1, count 2, and we have a verdict as to parts of count 2, what should we do? If they ask something that specific, maybe.
And if they said, and we have a verdict on parts of count 2, but want to know whether, I'm trying not to say if or whether, that if it's not guilty only on some and undecided on one, is the entire thing, is the entire count a mistrial? Will she say that's worrying about the ramifications, the consequences?
Yeah, I mean, the way, again, I think my wording is clear. It's just like, we have a verdict as to count 1, we have a verdict as to count 3, we have a verdict as to part of count 2. What do you want us to do?
Right.
In terms of, yeah, that would
what
be.
What do you think the answer would be?
Deliberate harder. I don't know. I can't answer that question.
So
She'd say you have to be unanimous, and if you're not, you're hung. Go ahead.
yeah, you were Ali, you were asking earlier, like my whole thing is the the verdict slip being set up the way that it is. Sorry, I got distracted by chat and I lost my train of thought. I'll come back to it. You guys see.
All right. And we do have the new verdict slip. If anyone wants, Mandy did send it to me. If anybody wants me to,
Yeah, I'm emailing it
Yeah.
now. I'm waiting for.
Yeah,
Jason
so
to come through.
I think Bob, I don't agree with the idea of count 3 because I pulled the verdicts while I've been talking. Offense 3 is simply leaving the scene of an accident resulting in death.
it's not
D-
OUI leaving the scene of an accident.
That's not what it says at the top of the sheet. It's just
Oh.
simply leaving the scene of an accident resulting in death. So
Oh,
DUI is not a lesser included of count 3.
no.
Oh shit, that changes everything. I always thought it was OUI.
Yeah,
No.
we didn't look at it, and we were just. I had it in my mind too that it was an OUI resulting in leaving an accident resulting in death.
No.
So yeah,
I
that
mean,
definitely
if
doesn't.
there
Well,
If there was no accident,
well,
how
but
is he
he's
leaving from it?
exactly.
know-
That's why we think it's not guilty on that. But Bob's was thinking of it wrong yesterday, thinking that that count was driving while intoxicated
And
And-
leaving the scene.
of an accident and causing an accident, leaving the scene of an
No.
accident, causing death.
She simply has to know that she would have to know that the collision occurred. She would have to know that she hit him, and she would have to leave the scene of the accident with that
So
knowledge. Is all that's
wouldn't-
required.
Yeah,
Right.
that changes everything.
So then that
Yeah.
brings me back to my other question of, is it even possible to say, we asked for this lesser, we have changed our mind, tell the jury it's gone?
I don't know the answer. If they wanted to strike it completely, if they wanted to strike item 5 completely from the verdict form, I might allow them to do that. Maybe, but I'd have to really think about it. But
New text.
I'm sort of reluctant to change it in that way. Because if it were me, like with the whole like partial verdicts thing, like, do you want the jury to be able to return verdicts separately as to count 1, count 2, count 3? Like if it were me, it's like you can make that decision, but you have to make that decision when we initially charge the jury. Like you can't. I am not a happy camper. It's like, oh, we want to change things because tea leaf readings. Like you have to make that decision blind. You can't make the decision because of new information. That's cheating.
Right. I've had the situation where the judge sends the jury back, and for whatever reason, then hears my directed verdict argument and directed on one of the counts and brought the jury out and told them, it might not have been that. It might have been after the whole trial, and he had to tell them ignore all this stuff. That actually might have been what happened. I can't remember. Now I'm thinking that might have been what happened, that it was at the end. So he said, just ignore all the evidence you heard on this because that count is gone.
Yeah,
But
that's fine.
yeah.
Another reason, incidentally, that judges will hold that back for a lot of reasons. Like it's like if they were going to give the directed verdict, they'll typically wait for the verdict from the jury anyway, because maybe the jury gets it right and I don't have to do anything, and if they do, then I can just do it at that point. So that's pretty typical.
Yeah. Yeah. He didn't in that one case. I just remember them telling the jury like that's not an issue anymore. Ignore it all. But yeah, I could see him doing exactly what you just said. Well, let's wait because I'm gonna direct it, but let's just see what they do.
16 hours on the jury clock now. 16 hours.
I mean,
It's about 15 hours and 55 minutes too many, but okay.
So here's the thing: when we're talking about this compromise verdict, and the question number 2 of, unless that was 1, I think it was 1. What time is the DUI?
Yeah, that was interesting. I think the defense was legally wrong. I think Brennan is correct. It's a lesser included. So the time of the DUI for the purpose of 2 would be the time of the alleged manslaughter, because it's a lesser of the manslaughter. So the DUI would be at 12:40. That's Brennan was correct.
But wouldn't that dismiss if the jury has decided that no collision even took place, and also the fact that there's no blood alcohol for that time?
Yeah.
So can't they just? Wouldn't that be more of an incentive to vote not guilty all the way down the board?
Well,
So
it depends where they were, but I think that the lawyers, if I'm the defense team,
at 12:45. How can they prove that?
Well,
You know what I mean?
yeah, I think people somewhat misunderstand this issue on DUI because they confuse the way it typically happens with the way it must happen. Like you don't need to. DUI is fundamentally no different than any other criminal charge from first principles. So like you don't need to charge them the day it happened because you don't need to charge any crime the day it happened. You don't need evidence from the day it happened because that's not true for any crime. What you need is evidence from whatever source it is or combination of sources that prove guilt beyond a reasonable doubt. That can be, but doesn't need to be a breathalyzer. That can be, but doesn't need to be a blood draw. It can be other things. It can be whatever evidence would convince a jury. In this situation, they have posited it from the video they showed at the bar. They have posited from eyewitnesses who were there seeing the drinking. And they have posited from the blood draw that was done by the hospital, which, you know, is not an accredited lab for the purposes of that thing, but it's still some evidence by definition, because evidence by definition is anything that makes a fact in dispute more or less likely. So the blood draw from the hospital is evidence that necessarily makes it more likely that she had blood alcohol of whatever at a given time. Now, there are a lot of ways to confuse that, but yeah.
But doesn't the lack of a blood alcohol testing at that time create enough reasonable doubt? Isn't there already enough reasonable doubt whether or not she was drunk at that time?
Well, creating reasonable doubt and having evidence that also could be relied on by a jury to find guilty are two different things. I agree with you. There is enough evidence in there.
I don't know. I'm just asking.
No, but I agree. There's enough evidence in there. If a juror wanted to find reasonable doubt, they could. But
Right.
as Kurt's pointing out, there's enough evidence that if the juror wants to say, I think she's guilty, that the law would say, well, there's enough there to support a juror making that decision. But I think that the lawyers, the defense team, decided to keep it like that because they thought it would help the jurors. All right, some want to say 5, some want to say 12:45. Give it to them both and let them go. Now, under the law, typically that is an unconstitutional verdict because you don't have any way to establish it was unanimous.
Yeah, you're presenting two different times. So how could I mean, it's that right there in and of itself spells reasonable doubt. It's spelling it out, right? I mean,
well, not necessarily in principle, because again, it's like as long as you could all agree that it's one of them, then you're there from like first principles.
I don't think so for unanimous verdict.
There's no way for them to express that on the verdict form, but like in principle, like if they all agreed on the same time, then that makes sense.
Well, correct. If they all agreed on the same time, that would make sense. But this allows them. In any other situation, I, as the defense attorney, would be saying you're giving the jury the option to reach a verdict that's not unanimous, because some are saying she didn't do this event at 12:45, and some are saying she didn't do this event at 5, and you're combining them to come up with the unanimous verdict.
Well, the bigger problem is, even if you assume somehow you just magic it into existence, they unanimously agreed at like 5 in the morning. It's not a lesser included of count 2. So like, guilty, you don't know what time they convicted of. And so you have a problem on appeal because it's an invalid charge because it's not a lesser included. If it were a naked DUI charge, then you could dispute the time, but you can't do that in this context because it's a lesser included. So it's very odd.
With the defense,
I think she made the right decision in the sense that, you know, OUIs, DUIs, whatever you want to call it, are specific in terms of the time that crime was committed. And by way of them not including anything in the indictment as to what time they're alleging that happened.
But it's a lesser included, babe. That's what Kurt's saying.
I understand that.
It has to be the time that carries forward from the charging offense.
For the manslaughter, right. I mean, right. I agree. It would have had to have been the 12:32 or whatever.
But the defense did this on purpose because they want a compromised verdict on OUI.
Yeah, I think that's true. I think that they are trying to expand the range of the DUI because as long as you check box 5, we're happy. So do you think she was drinking at 12? Do you think she was drinking at 5? Do you think she was drunk yesterday? Yesterday is fine for us too. As long as you check box 5, you know, we're happy campers.
Yes. Or 1. We'll take the
1 or 5. Either of those options would be Right.
Right.
Thank you.
Yeah.
But not Will's option, not the Glare's option.
Yeah, it's historically accurate to never go with my option.
No, but
just for the
Will,
record.
that's what's I believe that is exactly what the jurors are doing. You've got at least one or more of you. I'm very confident in that, saying no way, you're not getting me to say guilty to anything. F you, and not realizing like
The ramifications of it.
they think that maybe all three will be in. So that's
Did you say you wanted to fight me for voting guilty? It's like I'll fight you for not voting guilty. We can go outside the back. We'll see who wins.
That makes perfect sense, Ali. It makes perfect sense because I would not. I probably would be so like if there's a strong personality who tends to be emotional on that jury and feels like this was the biggest waste of time and taxpayer money in the world,
Mhm.
you know, they're going to be adamant. You know what I mean? And even if they're smart enough to understand what you're talking about, their emotions are going to cloud that. You know what I mean? Their sense of principle is going to. Mine would.
But
I
if
mean,
there's one juror back there that understands the dilemma,
I would love to say that I'd be like, yeah, I get it, but I probably wouldn't.
see, but that juror that's back there that's fighting for that when they come out and if it's hung and then they find out that she's going to be recharged on the manslaughter and retried, they're going to be fucking killing themselves about it. You know?
Yeah, no joke.
Like, I mean, it's
let me
it's
ask
a nightmare
all of you.
scenario. It's a nightmare. My fucking head is still spinning about count three. I could have sworn that it was OUI.
What?
I'm still.
You have a little false memory going on there.
Yeah, clearly, I have a very, very
It's enough
never
for me
type
to
false memory.
I hopped on. Why do you guys
It's
think-
vivid.
I know. Why do
I
you guys
changed my whole mind about Kelly Dever. Like now I see how fun. It's like I've read it, I saw it. It's like it happened in my head. That's crazy. That's crazy because you're right. If that's not OUI is not part of it, you can't stick it in there. Fuck. So we're stuck with doing this. That changes my evaluation on like how much I think they might have fucked it by adding this thing in there. You know, like with that being the only option, it's like, I mean, what would you like? I think ultimately
I'd ask to
everybody
withdraw it.
agrees this was Karen's decision. They went with her. They gave her all the insight on it.
I'm
and
sure.
They said, Karen,
They made the right decision at the time. It's
a gut call. There's no question.
The
It's a gut
jurors,
call.
what they're hearing from juror Ronnie, they had to take like backup. But why do you guys think? I feel like we're probably all feel or at least felt very sure that they had come to a not guilty verdict on counts 1 and 3. Why the hell haven't they sent out those verdict sheets yet? Somebody.
Because they don't understand the verdict sheets.
Exactly.
It's to
You
me.
think they might be holding them hostage, Kurt, or you think it's that they don't understand, or that they're holding those hostage and trying to get a verdict on count 2?
I'm a little reluctant to tea leaf read jury forms for sort of any value because I think that they can be misleading and we read sometimes more into them than anything. So while I agree that I think the most plausible conclusion is that they are, sort of wrestling with the DUI, I don't necessarily want to take that for a given. I don't know if there's some juror out there who wants to convict on some version of manslaughter or some. I don't know, and I'm reluctant to kind of draw those conclusions. So I don't know what the problem is. I would like them to solve the problem anytime. Be great.
So I think that that's a
we're kind
possibility.
of up to the conclusion that they, just assuming that they've reached a verdict on
They
one.
might have just been asking theoretical questions.
On 1 and 2 or 1 and 3, and that it's 2 that they're hung up on. And I think that the only reason that we think that is because they were asking specifically about that form or that flip. But you're right. I mean, theoretically, they could be trying to be tricky in terms of not giving up any intel to the judge and not giving accurate information as to which thing they're on. And they just wanted to have an answer about that slip too, because it's so fucking confusing. I mean, the other 2 are pretty clear. I mean, like that's your typical verdict slip. It's either guilty or not guilty, and you don't have the issue of the lesser included in there. So it's kind of like it's right there for you. But man, yeah, it's like I feel like and I put it, I did read the tea leaves yesterday. I feel like that's probably what they're debating on. And that's what got me kind of in a little bit of a panic mode about this because of that concept. Like I'm less panicked if they're hung on manslaughter. Like that changes the entire thing. If they're hung on one of the lessers of manslaughter as opposed to just the standalone OUI, I'm still pissed, but I'm in a different way. Whereas she's not getting hauled back into court to try this case again based on them being hung on an OUI because they were really hung on the manslaughter portion of it. But like the thing is that we'll never know. It's going to be the same. It's going to be the same circumstance. If they're hung, they're hung. And if they don't reach a verdict and they don't check any of the 2, 3, 4, or 5, we are not going to know unless one of the jurors comes out and speaks.
All right, and now we can see what Mark Betterow thinks.
Yay!
Do you think it's possible the jurors were just asking, really were just asking theoretical questions, and that they're hung on a bigger count?
No.
He brings us back down. He brings us back.
Good. Mark's where I'm at.
He's leveling us out.
Oh, I mean, anything's possible, but just by the plain meaning of the notes they wrote, if you assume they're moderately intelligent people, they seem to indicate there was a problem with count 2, lesser included offense 5, and then asked a series of questions that would seemingly apply to fact finding on that count. And then you found out there was a 4th note, which probably crossed in the carrier pigeon mail before she charged the jury, that they wanted to know, I think, what if we hang on that? What are the consequences on the rest? So, I mean, you never know what they're really doing, but seems to me that they're all twisted into a knot on a misdemeanor TWI, which after 2 months and 3 years of all this that's great.
I know. And if you heard, I don't know if you were listening, but Will says, like, if he was a juror, he would stay dug in. Even with everything he knows right now, although he gave some wiggle room, but he's just saying, like, in his heart, he feels like he probably would be saying, I'm staying dug in. I'm not going to say guilty. Absolutely not. They're trying to force us to say guilty because she can get retried on this. Now I'm still not doing it.
Yeah, Will's he's the principal of the thing guy. It's like the principal of the thing. There's no way I'm doing it.
Look, man, like all I'm saying is even if this jury, I get that if this jury on a much larger moral level, it's probably better to just agree on an OUI, right? Fine. I concede to that. But any juror that does that is to some degree an asshole, and they need to repent. That's all I'm saying. That's all I'm saying.
Mark, is it legally possible for I haven't thought of it or researched it, for the defense team to go in and be like, hey, we asked for that lesser included. We want to withdraw it.
Yeah, we were just kidding.
I don't think so. And I think it would look terrible at this point. They asked for it.
Yeah,
you got to deal with it. I think also that if these jurors actually believe that if they hang on the misdemeanor, that it could lead to a retrial for up the whole food chain of count 2 all the way to manslaughter, that even if there are some people who think that she's guilty of the misdemeanor, if they have awareness of that full ramification, if they can't agree, then they're duty bound and morally and obligated to acquit, because the idea that yes, I'm advocating nullification in this sense, because if you believe that she's not guilty of manslaughter, but you're willing to convict her of a misdemeanor, but the consequence is you're going to be hung, so she's going to get retried for manslaughter when she ought to be acquitted, and you're going to have a third trial after 2 acquittals, which only would happen in this case, then at that point, I think the people who are guilty of the misdemeanor are morally obligated and to just acquit and say we can't have another homicide trial. You can't have 3 homicide trials after she was acquitted of homicide charges in both prior trials. That's crazy.
And that might likely, based on Will's position, and I'm accepting Will as a possible, mind of a juror in there who's dug in, that's what we're going to have to hope for, what Mark just said, that the people who actually think she's guilty just say, fine, because I sure as shit don't think she's guilty of manslaughter, and I don't want that possibility of her being.
What's wrong with just voting not guilty all the way down the line? Like, you see what I'm saying? Like,
Right.
To me, it's just a simple, okay, this is confusing, and none of us can even explain why we're even here. So, not guilty. If there's a presumption of innocence, what are we thinking about here? What are we talking about?
They may be here because the defense asked them to consider the misdemeanor and the ultimate cruel irony of this whole thing. I guess the real question is, would you have asked for that count given the evidence on the higher charges?
Not in retrospect, but I think I very well might have initially. But obviously, knowing what we know now, I'm sure they're all like, "Oops, that backfired."
No, I'm or obviously retrospect, it's a disaster. Just the fact that this is even being talked about. But I always thought, it's either a car accident or not. I thought they were really strong on the no car accident, nice, clean, and ease it up. I understand why they did it, but I think it's now, if they're debating over drunk driving to the point where it could screw up the whole thing and lead
Terrifying.
The jury instructions are a mess. The jury slip is a mess. Everything's a mess. The notes indicate they're exactly where they were a year ago. I mean, this is, I don't even know what to call it at this point.
It's like it's the worst case scenario. It's like I was talking about it like 2 days ago with the concept that if they hang, as soon as they ask for it, I'm like, if they hang, and I kept thinking until Kurt corrected me that count 3 was an OUI leaving the scene. Like, that was in my head, and I'm like, why the fuck didn't they put it on 3 instead of on 2? Get rid of be as far away from the manslaughter. And the Kurt's like, yeah, no, that's just like straight up leaving the scene. I'm like, oh my God. So they were always stuck, like knowing, and went in knowing that it was going to be attached to that manslaughter. And like, we're talking about some super fucking bright attorneys who all were like absolutely aware of the concept that if they got hung on this OUI, that results in her being brought back a third time with the manslaughter. It's so easy to sit here and armchair quarterback this shit, right? Like, it's like, but in that moment, they go to Karen, and I think we talked about this already, Mark. Like, Karen made the final decision on this. I'm pretty confident in saying that. I think that they went to her and said, look, this is our concept with this. This is, if we give them something to hang their hat on, God forbid, and Judge may hammer you on it. I'm sure that they were very clear about that. You may pay a trial tax on it. She could hammer you on the sentence. Is your choice to add that on as opposed to having them get hung on the manslaughter again.
I think the thing you're sort of not factoring into this equation is the alternative universe. Like, suppose they hadn't asked for the OUI subcharge. Suppose we just had the exact same verdict form that we did last time. Okay, so what would this jury be doing in that situation? And they sort of know at least one hypothetical, because we've been in exactly that situation. Like, we know exactly what that looks like, or exactly what that can look like. We got to convict her of something. We're looking for something. So like, they're like, you're like, well, they're hung up on the DUI because some people want to convict and some people don't. But if that, in the alternative universe where that charge was never presented, we might just be in the exact same situation. It's like, oh, I want to convict her of something, and some people don't. So I don't know, we're necessarily any better off either way.
I 100%.
I don't agree, because that's why this is so fascinating to discuss, right?
Yeah.
It's all these reasonable. I mean, there's no right or wrong answer, obviously, and we are armchair Monday morning quarterbacking after the fact. But this is the only lesser included offense that does not require a collision between the SUV and the pedestrian. And to me, that's the litmus test on the case, right? Put aside the added charge. If there's no impact, she's not guilty across the board. And I thought they just were so persuasive on that. At the same time, I understand the nervousness, the family, you have to do something, but I also thought they gave presented a great defense, an incredible summation that really clarified there was no accident. And, the question, I guess, philosophically becomes, do you trust the jury to get past the possible sympathy and all that and say there's no car accident? See, to me, the whole defense argument is premised on there's no collision. And if you're worried about that, then you're done. I mean, if there's a car accident, you're going to get convicted of something. And when I say something, I mean something homicidal.
Yeah, significant. One of the significant charges, for sure.
Yeah, no, to Mark's point, and that's Bob Sr.'s point as well. It's like the lawyers should have had trust in their own case. They should have had faith in their own case enough. But like you said, you can
critical because I understand it. Right. I think I err on the other side based on the specific facts of the case. But I understand what they're doing. I think the choice they made is entirely reasonable. When it comes to lesser included, it comes up all the time. And really, I think most lawyers, probably you guys too, when you think about it, first of all, you're wondering, God, I hope they don't ask for to take this choice out of my hands because, where I come from, if the evidence supports it and anybody requests it, it can be included or whatever. But normally, if you think you have a defense case, you don't want it. You want the all or nothing. And of course, if you're thinking, well, I'm probably not looking great on this, then you want anything possible to minimize. And I would have thought this one, again, because if they're going to convict you of anything with a car accident, you're screwed.
Right.
And then the only other thing I would kind of question maybe, and this is total Monday morning quarterbacking, is if you're going to ask for it and you want that to be the off-ramp, or at least potentially, why not tell the jury that in the summation? Take 2 minutes and simply say, look, there was no collision, there was no this. She's also not guilty of driving or operating under the influence, but that's a separate analysis and you can convict that, has nothing to do with the collision, and kind of, put the airline lights that they use at the airport and say, take this exit and go there. Right? I mean, because I don't think it's clear to them because they didn't even know they were getting charged on that count until they got the jury instructions after the summation. So they had no awareness of this.
They didn't do that because that's scary as shit.
Yeah.
But that's Mark's point. You put it out there as a lifeboat, an off-ramp, whatever you want to call it, then lean into it as one.
You're going to do it. I think you got to notify them.
Hey, I'm sending you a link in private or in Twitter or X.
Yeah,
Bob. It's a new verdict slip per Ted Daniels.
Ooh, exciting!
Another new one.
Yeah.
Another new one.
Right.
Well, the new one from yesterday, presumably, because I still haven't seen the new one from yesterday.
I haven't either.
Mandy texted to us, babe.
Oh, she did?
Yeah.
I would love to see this new exciting jury slip, which goes on for several pages, I think, at this point.
It does. It's lengthy.
Unless I'm wrong.
Okay.
I'll pull it up.
Yeah, I have it. Yeah, she sent it. That's what I was trying to tell you. She sent it a while ago.
All right, let's do this thing.
Okay.
Sorry, Mandy.
The whole jury slip context, can somebody explain to me why she had discussion with the lawyers about the jury slip after she gave the case to the jury? Like, what are we doing?
Especially given this case. Especially given this case.
How is that not something that comes up when you're discussing, the charge conference and what you're doing before summations? Have you ever seen anything like that?
I have never seen that. Worst case, they have it like, all right, we've got this general feel. We'll deal with it in the morning before it goes with the jury, but never after.
She said something else yesterday, too, kind of a throwaway comment when she was defending this that really scared the crap out of me, or at least should scare the crap out of everyone, when she basically said, well, this is what we do in civil cases. Did you hear that comment?
Yeah.
I missed that one.
What? I mean, that's fine when you're having like a contract dispute over, a few 100,000 shekels and whatever. Not that that's anything anybody wants to lose, but you're talking about a woman on trial for murder.
Just a woman's life.
You're telling a vast experience in civil jury slips. Holy crap. what are you doing?
Yeah, it's scary.
I mean,
that's
I
a
know,
scary proposition.
I know that the Institute of Knowledge that I come from and founded, by the way, is not as
Where?
prestigious as the ones that you all have as well. But I'm of the opinion that the jury should just draw a little square on the verdict form and write not guilty and check it. I'm totally of that opinion.
I have never seen in my life in any jury slip ever, however many I've seen over too many years to count in any kind of case, in any case I've been involved in or anyone I've seen, any filings or whatever, or appellate exhibits and other cases. I've never seen a criminal jury slip that does not have a not guilty and guilty option for every count, every lesser included, one at a time, not some pick not guilty or pick one of these 6 choices for guilty. And somebody showed some of Canoni's other slips in like the 1 or 2 other cases, and it's the same thing. And this is not normal. That's not how juries. They're not supposed to be designed to confuse. They're supposed to be as basic, common sense, simple. Talk to me like a for anyone, and she makes it confusing, and I don't understand it.
All right, here I'm going to pull this thing up. I'm going to make it bigger. So
I've got it in Acrobat. It'll be better.
No, this is Acrobat, honey.
Okay.
All right, so we're all teeny, and the slip is huge. So
Speak for yourself, bro.
hey. All right, so
Channel, Will.
yeah,
It actually is.
Yes.
all right, so let's see. We've got, here's your language. If you find the defendant not guilty of the offense charge or any lesser included offense, stop and sign the verdict slip. So that's our new language. I like that new language. It's helpful. Guilty of offense is charged. Manslaughter while operating a motor vehicle under the influence of liquor. Check one or both of the following. So you got your and/or proposition. Then they added this language again. If you find the defendant guilty of manslaughter while operating a motor vehicle under the influence of liquor, stop and sign the verdict slip. If you find her not guilty of manslaughter while operating a motor vehicle under the influence, then continue below. I mean, what do you guys think of that language? I thought it was.
I mean, it's a little better. Makes it clear what they're supposed to do stepwise, but there's still no way for them to express sub verdicts.
Exactly. That's the thing.
This is kind of dumbed down at least, but what if you, in theory, vote acquittals on the first 4 and hang on the 5th?
Right.
The same problem that the jury was indicating
Exact same thing.
because if there was a not guilty down the line, then you could at least avoid that. And if they hung on the lesser included offense, you would all agree and understand they acquitted on manslaughter and they acquitted on these, and that's the way it goes. That's the way it should be. And to start over and get another crack at manslaughter when this jury is saying, we honest to God acquitted her, but we don't know how to check the slip because there's no place for it. This is the same freaking thing that happened the last time.
Exactly.
Retry for murder when she was acquitted.
Exactly.
Well, but it sounds like that's the way Massachusetts law wants it to be. That if you can't come to a unanimous verdict on the charged offense or the lesser in a same count, that they want them all on the table.
But
Yeah.
the problem is there's this pesky thing called the U.S. Constitution, which is more important than the Massachusetts Declaration of Rights, or they don't even call it the Constitution because that's too complicated, too simple, whatever it is. I mean, how can anyone with a straight face say it would be just, even under Massachusetts law, from the puritanical days, whatever, that if they, honest to God, try to acquit and want to acquit and are saying we did acquit, but we can't decide a freaking misdemeanor that was added at the last second, that they should get a mulligan for the whole manslaughter charge?
Right.
It's insanity.
Well, I mean,
Insanity.
It's crazy.
Just look at the law that Ken Mello weaponized. I know Mark can't weigh in much on this, but look at the law that Ken Mello weaponized against not just Turtle Boy, but multiple people. That law itself is unconstitutional.
Yeah.
I mean, it's so broad, and it's basically a law that explains you can be arrested for things that you have a right to do. It's
talking to a
crazy.
camera.
Like when I read it, I'm like, I can't believe this is a law.
Right. Like, and to your point, Will, like Mark is knee deep in it with Tim, and like, I mean, I am assuming
Tom.
that they have challenged the constitutionality of that particular statute. It's some lawyer in Massachusetts has been, this thing is fucked. This is completely unconstitutional.
We did. It was not, I mean, there were several counts dismissed, not on constitutional grounds, but the reality is, I mean, we all understand this. Usually when a statute that's been around forever and is used all the time as a weapon to silence and whatnot, and you're making First Amendment arguments,
They're not
usually
right on its face.
it's not going to be a trial court normally that's going to take a hatchet to it. And, you know, ultimately it's interesting because, you know, it is a First Amendment thing. So who knows what a federal court would think. The other problem with that statute is, and why, you know, it is hard to have it chucked out is because, you know, there is a state interest and obviously, you know, witnesses not being improperly influenced, and everybody agrees that that's a fair thing. But when it starts being used for people expressing speech through rubber duckies or opining that somebody is guilty of a crime, or even if somebody says something that's offensive that you believe is unfair and not supported by fact, there are remedies. You can sue people for defamation if you
100%.
believe. It doesn't
would you-
translate to witness intimidation just because it hurts your feelings.
Would you mind pulling up the verdict slip again and showing
Oh,
option
You,
number one? Because I have another way to solve this problem. And it's in the technically correct is the best kind of correct. So if you go back up to item number one, please.
Yep.
All right. I love the way this is written, because there's another way to read this that you can solve this problem. If you read number one literally, it says not guilty of the offense charged or any lesser included offense. It doesn't say every. It doesn't say every. So technically, technically correct is the best kind of correct. As long as you find not guilty on any of them, you can check box one.
and that goes into what Mark, your earlier thing, like I'm gonna, you know, petition for nullifying here, but
yeah, no, it's not even nullifying. I'm just following the instruction literally. I'm just following it literally. As long as I find not guilty on any of them, I can check box one. I am technically correct, and I can all move on with my life. It's great. So there's another option for you, Dory. Take that one. There you go.
Yeah. How would they get that to the jury?
Well, put me in, coach. Put me in. I'm ready to help.
Shit, man. Yeah, it's like that would have been something that would have been nice to have heard one of the
well, they
defense
couldn't
team.
make that argument. Really, he's just saying the jurors can lay their hats on it because technically, literally, it's accurate. But no, it's not an actual argument.
I think it is.
No, because then the judge would have fixed it and said to each.
Yeah, I suppose. Yeah, that's interesting, man. Not guilty. Yep.
You're giving jurors so much credit for something that they're not going to pick up.
I'm just here to help to the extent I can. So that's all I had to say about that.
I mean, you're technically right. There's no question.
Right.
I mean, the jury, in essence, is asking these questions to the judge, and she's not answering it that way. I mean, you know, she's not answering even hypotheticals, because that's the other interesting thing is they haven't said we have verdicts on the other two counts. They're saying, what if we do? And her attitude is, well, that's not really a statement, so I'm just going to ignore it, which is what she did. She just literally
I didn't even take it as a theoretical because they didn't say what if, they said if, which doesn't have to be theoretical.
All right, I think it could have been theoretical in the sense that we've got a decision on one, we've got a decision on three, and we have an if we're going to stay hung on two until you answer us on what happens with 1 and 3. You know,
Well, I mean, there's a difference between what if and if. I mean, we're all lawyers and lawyer on TV, you know, so it's like, but words matter. In terms of her deciding that it was a theoretical, really bugged the shit out of me, because I think that a layperson, that's how they'd write it. So if we've come up with verdicts on 1 and 3 or 2 of the counts, then this, you know, then this is our question. What happens then?
Or how about do what, in our experience, judges usually do when they get a note from a jury if the judge doesn't understand it?
Clarify it.
The way this would happen in New York is to say, I don't know what you're telling me, and it's unclear from your note whether you are saying this or that. And then what a judge here would do is not have a colloquy with them, send them back and say, either re-clarify your note or that's it. And then what they would do is they would bang on the door 10 minutes later and say, you know, we do or don't, and then the judge can answer it. But like this kind of cat and mouse game about, I don't understand what you're saying, but I'm not even going to pretend to ask you to define what you're saying. I'm just going to ignore it. What good does that do? Now,
Yeah.
They didn't come up with another note after several hours, so maybe they're satisfied with the general answer she gave. I don't know. But
Kurt, what's the verdict watch at now?
16 hours, 37 minutes, baby.
I mean, what the fuck, dude? Like there is, we are at the point on Wednesday morning, late morning, that it is clear that there is a battle going on back there. You know, I mean, it's like
There's definitely a discussion.
there's definitely a discussion going on.
For sure.
Man, it's I just, because the way that I read it, and I kind of, like I said before you got on, Mark, but like I did read the tea leaves. I'm thinking that they were, and it was really the thing that I used as kind of my trigger in terms of feeling comfortable enough to read the tea leaves, was the fact that they asked about the clips and whether or not those were evidence. When I thought about the clips that Brennan employed in his case, the only one that made any sense in terms of them, because I wasn't taking it as a theoretical, I was taking it as we have reached a verdict on 2 of the counts, which is a big assumption.
I took it that way too.
Right, but like the only one that fit in terms of what was left over of clips, because that meant to me that 1 was gone and 3 was gone, which meant that they decided that it wasn't a collision, right? And that the only clip that fit was the clip of Karen talking about how much she had drank, like that the longest clip that he played, where she's going through, you know, it was the weakest drink I had ever had, and I put then that's what got me feeling like, all right, they're doing battle on the OUI.
You know, not to tell the judge her job, but as she will instruct the jury, they're allowed to make reasonable inferences. So perhaps you should take your own advice, Judge. Perhaps you could take that if and make the reasonable inference. Maybe this is suggesting perhaps that this is in fact the situation. Maybe I should draw that perhaps reasonable inference, and maybe I should do something with it. That might be nice.
Or you can teach the jury the law.
That would be also good.
What do you just do it? Like,
what I
explain
can't understand is why, and again, I think every judge normally would do this, would say, I don't understand your question. I don't know if you're telling me something finally or not, and therefore I have no choice but to send you back and ask you to. I've seen that happen before. It sucks. And, you know, if she doesn't want to assume, I get it. The other side's going to complain and say, what are you doing? But why not just say, I don't understand what you're asking me, instead of saying, well, there is the word if, or it does appear this. Even though, look, I think we all interpreted the note the same way. They're telling you we're twisted into a knot with something to do with the second count somewhere down the food chain. It's obvious.
Why would they twisted into a knot? I mean, the form was so clear.
And why not resort, Mark, why not resort to just the jury instructions? Because the jury instructions answered that question and said you can look at them all individually, da 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 da. And I thought the same with the question about the clips, hit to the point of, if any, that Alan Jackson asked for. Isn't there a jury instruction that says for witness statements you can believe all or none or some?
Yeah.
Listen, when the jury sends a note and says, I mean, Brennan makes the clips the highlight of his case, basically, and the jury note, the first substantive note is,
Are
this
they
ev-
evidence?
I mean, that tells me something.
Yeah. They're like, why are they showing these movie clips?
You know what's crazy is if this
They're
was
like
a
Super Bowl ads. It's weird.
if this
They
was
really are.
a misdemeanor DWI case and you took away the whole collision, this is like a 20-minute acquittal. If it's literally just on proof of driving while intoxicated, either over the 0.08 limit, because that's kind of, fakak the science on this one,
Right.
and even what they call common law, OUI, DWI, based upon her apparent willingness or ability to handle her alcohol, apparently. I mean, she's driving like a champ and has no indication. That could raise other questions in the mind of the jury, maybe. But the
Yeah.
evidence that she was operating in a reasonably prudent way. So
You
this
got
would be
Waze, you got her friend, you've got the people driving behind her.
You're
That's-
doing that on a bench trial, and you're getting an NG on it all day. It's I always saying the same thing. If there's no John O'Keefe dead on the lawn of 34 Fairview, and it's just a standalone OUI, yeah, you're kicking this thing in a half an hour on a bench, and that's it. You're done. There's no way a judge is gonna convict her on it because of they just didn't have the evidence for it.
yeah.
Well, and the only real indications of Karen Reed being drunk
or her state.
are her statements, right? Which I albeit
Video.
very powerful, sure. Also, her purchasing drinks at the waterfall and CF McCarthy's, sure, but really the angry voicemails like at 5 a.m. You know what I mean? Like, but because at the waterfall she wasn't acting drunk. Everyone testified, even the McAlberts testified that she didn't seem drunk.
Yeah.
So, I mean, you know what I mean? So,
If I'm arguing at the bench and and this is going into Kurt's like alternative universe again in terms of like in that case you're not hearing angry voicemails. She's not doing interviews because it's just a standalone OUI and it's just like every other OUI that we handle in that world. But if there is a world in which they're like, wait, man, we really want to get her on this OUI, we're gonna subpoena her phone records and we're gonna listen to her voicemails and all this other shit. And like I'm using that in defense of reasonable doubt. I'm like she was on one. Like she went home and she drank, and
that's what I think. That's what I think.
I think that definitely happened as well. I mean,
I mean, I'm sure. Like she was pissed. I mean, like you would be pissed at me. Like
Yeah, you're gonna go off and party, then I'm gonna party too, asshole.
Right,
Blah, blah,
yeah.
You know what I mean? Like I could see that.
If it's a misdemeanor drunk driving charge too, without all this excess stuff, you're at least giving a lot of serious thought, which something you never do in 99% of the cases of letting her testify to. That changes the whole dynamic
for sure.
of there could be something very interesting to say here about when I got home or what I was doing at any given time.
Right, for sure. And does it scare any of you, or how much does it scare you if it does, that we don't have slip 1 and 3 this morning? That the jurors haven't just sent out their unanimous verdicts on count 1 and count 3?
I don't think they understand. I think that was part of their note yesterday was I agree with all of you. We have essentially put those to the side in the not guilty column, but we don't know what we're supposed to do with this other one. So can we tell you? I think that's what they were asking for guidance yesterday, and they got no answer. So I don't think they know. So I assume at some point this will come to a head if they can agree on whatever's going on with count 2. But I don't think it should worry people in the sense that they've made it seemingly clear they're not paying much attention to the 2 counts that a year ago she was acquitted on as well, but they had the same problem with informant court.
And Kurt and Mark, do you think in light of that, and Alan bristled up a bit in terms of like some pushback as to that issue, in light of what happened the first time, in light of the fact that she didn't employ 27B to inquire as to whether or not they were wrong on all counts, that's a reality. Like that is something that exists in the world that happened. It's why we're here. Again, it's why they were able to try her on murder 2 again. When we all know I feel very comfortable in terms of what I've heard from various jurors that all 12 were NG on the murder too, right? So it's like that that double jeopardy thing is a kind of a fucking big deal for me. And but like, do you guys feel that Alan bristled up enough on that issue in terms of like really trying to? Because I mean, he made a record, right? And he wanted it on the record. He's like, I'm making a record on this. I hear what you're saying, Judge, but like,
You have 1 minute.
like, right, I'm just sitting here right. I'm like, fucking timelines. So, because I know what Allie and I would be doing, like in that situation, like we would be on the verge of being held in contempt type shit, because in light of what had happened, did Alan bristle up enough? Do you guys think that he did? I don't know. Like I felt like I would have really been losing my shit in there.
I think he did what he could, personally. And I'm glad you brought that up, because Bev just gives me the willies. That's my only real worry in this whole thing. She is so unpredictable but consistent in doing things in a venomous nature. The way that she blew Alan Jackson off wasn't just dismissive, it was venomous. And there's something behind that. I don't care what anybody says. In my opinion, there's a motive there that we're not seeing, that we're not aware of. But it's more than I don't like this guy. It's more than
the motive is very simple. Okay, I'm in my own fiefdom in Norfolk County. I'm the queen of the castle.
Right.
And this case was just a regular, interesting murder case. And you, Karen Reed, made it Hollywood. And you literally, from her perspective, brought in Hollywood. And what happened? Here come the lights. Here come the attention. Now everyone's paying attention. And you try to kick me off the case, right? You're holding up poster boards of all these things and whatnot. And she doesn't like it. I mean, I think that's just normal human nature. I don't think it's appropriate, but it's
Yeah, but
obvious.
the jury comes back and
years
says,
later.
right, 3 years later, with the
3
jury, comes back and says, I didn't buy it. You're the only one that bought it, Your Honor. I mean, essentially, you think
Right.
she kind of, take it down a notch after that.
He has accused him of lying to the court. She's accused him of suppressing evidence over the Arcus stuff. Accused him of being
Right.
late yesterday. Accused him a few weeks ago.
Grave
of
concerns.
how dare you and Bob consult, in the furtherance of a mistrial application. Look, it is what it is. That's just calling balls and strikes. She doesn't like them. It couldn't
Right.
be any more obvious.
Yeah.
But it's because he brought this case, hooray for Hollywood. And it's now the biggest case in the country.
Yep.
I don't think it's a coincidence that her brother represented Chris Albert in that manslaughter charge. I mean, these things are, to me, I'm not jumping to conclusions because I don't know, but I just don't find these things to be coincidental because there's too many of them. You know what I mean?
It's just, but that legal community, particularly in that area of Massachusetts, and the politics in 100 years.
Yeah.
I mean,
Yeah.
it's around. It always has been.
I keep getting confused with this trial with European royalty, how incestuous it is.
It's really gross. It's really gross. It really makes my skin crawl. Like,
I mean,
ever
the
since
fire
I
dancer
followed this
says,
case.
I speak 3 languages: sarcasm, I started this, cuss words, or curse as I would call them, and dog. Love y'all this morning. Judge Cannoli equals Lorraine Branco.
Well, the judges are appointed there. I mean,
Yeah.
if you want to
Yeah.
them on, that's part of the problem. I mean, they're
Man.
political
Yeah.
appointees.
That's
Yeah.
scary. Because
I mean,
it
No,
works in
she's
Illinois.
Sing off the public right now, though.
Yeah,
how far does this go? Is it gubernatorial? You know what I mean? Like, how far does it go?
Like, there's going to be no ramifications to Cannoni after this thing. It's like,
Oh, no, absolutely not.
Mark's hearing it constantly whenever he's bouncing around, because everybody, like, lay people are like, well, what can we do about this shit? What's going to happen to Hank Brennan? Nothing's going to happen to Hank Brennan. Nothing's going to happen to Cannoni. Like, just accept
I
that.
think something should happen to Hank for putting on false.
There's nothing
eliciting-
happening to Hank Brennan.
Yeah.
I'll make a gentle person bet.
How many
Not
prosecutors
yet.
are disciplined every year by the bar? Is it like
Yeah.
2?
Right. It's like the only time I've ever seen a like the Rust case where
Yeah.
what the fuck got on the stand in order to make a
Yeah,
record.
that was good. That was good.
Yeah, it was unbelievable. My head almost exploded. I couldn't believe what I was watching. It was amazing, and it's just something that you'll never see. And she's like, "I'm making a record. They're saying it was a Brady violation. I'm telling you, it's bullshit. And I'm protecting myself. I'm going to make a record." And it was amazing. I loved it, and it was like I think Allie and I were at CrimeCon or some shit when that thing was going down. I'm like, "Oh, great! This amazing thing happens with this prosecutor actually taking the stand." When the judge is like, "You sure you want to do that?"
Yeah, you're really sure. You don't have to, right?
Right. I mean, I'm not going to stop you, but yeah, I don't know, man. It's like that concept in Illinois. If a judge has to leave the bench, they then will appoint somebody, but that judge still has to run for election after initially being appointed, kind of in an interim basis. So they like here, but it's like I'm telling people, I'm like, you need to just not go in and vote on party lines when it comes to prosecuting attorneys and judges. Like, do a little research. And Allie was like, give me pushback. She's like, well, what do they do about judges? Like, especially if it's a first-time judge. Like somebody who has not been on the bench, who has no.
I tell them, you know what? Just don't vote then. If you don't know anything about the judges or the prosecutors, you guys stay out of it and let the lawyers in that community who know and the people who actually know something, let their voices be heard.
This judge is definitely making me feel better about myself. I mean, I would be a first-time judge because I've never been a judge before, but I feel like I could give it a go. I probably can't do any worse. It should be fine. It'll be fine. It'll be all right. It'll be all right.
The only vulnerable person here is Michael Morris. That's it.
That's it.
And
He's the common denominator for sure.
He's fucked either way.
the only one who's accountable to anyone who can vote. And you look at someone like Brennan, he doesn't even work in the DA's office. The public literally has nothing they can do.
Right.
He's going to get $1 million of your tax dollars, and when this case is over, he's going to go back to private practice. And the only vulnerability, if that's the word that he has, is are there some people who may be less inclined to hire him? I don't know.
I'd love to know the story about how they decided to hire Brennan in particular. How did that process go? How did that decision process make? What was the flip chart on that one? Walk me through it.
Yeah, to be a fly on the wall for that conversation when they're saying, okay, well, we're not letting Lally do it again. Yeah. Who's our choice?
They should have done a little America's Got Talent show, have a little panel, people come on, do a little song. It'd be good.
This goes back to what you're talking about 5 minutes ago. You have to understand the Norfolk County and Quincy and area. I know this area well, obviously. The political hackorama. Okay, Marcy has never had a non-public servant job in his life. Okay, he has been on the public payroll for probably 30 years.
Government's teat.
In some capacity or another. He was very close to a guy politically named Billy Bulger. You may recognize the last name. Not James Bulger, not Whitey Bulger, his brother, who used to be the head of the Massachusetts House of Representatives. Okay?
Wow.
Yeah, his brother was the, organized crime king of Massachusetts, and killing people and informing.
With impunity.
His brother was actually deemed to be in good standing running the state legislature. At the time, Whitey Bulger, from Massachusetts, this, was famously on the lam for however many years. Nobody knew where he was. And of course, brother Billy, I don't know where he was. I've had no contact with my brother in all this time. And, he was, Bulger was not the gangster, the other Bulger was a political ally of Marcy. The criminal Bulger had Brennan as his lawyer. This is
that sounds like the synopsis for the Showtime show Brotherhood. It was only on for 2 or 3 seasons, but it was really good.
Great, it was a great show.
Yeah, that complicated. And if you want to know how crazy Massachusetts is, so even after the other Bulger, Billy Bulger, was finally kind of shoved aside with all the Whitey Bulger and all the history. And naturally, Massachusetts did what you should do with those kind of allegedly corrupt politicians. It took him out of the legislature, and you know what they did? They installed him as the president of the University of Massachusetts,
Wow.
making him one of the highest in the state. In fact, he may have been the highest paid public employee in the state of Massachusetts for years. I don't know the exact math. This is, many, many years ago, obviously, but this is how incestuous and how gross the politics is. But it would stand to reason that Brennan is a good lawyer. He's a tough guy. He's a pit bull. You see what he's willing to do and how he's willing to confront experts. He's perfect for Morrissey on a case like this.
Yeah. And I think there was that overarching concept of the specter of Proctor being called. And you want a guy like that who lives in the world of crossing cops effectively. And if the concept was, all right, we cannot call Proctor in our case in chief, we're going to leave it to the defense to call him. And what's the most effective way that we can try to stop that from happening? And to me, it's like when, Mark, I saw your tweet and we were in agreement. He was masterful in his cross of arrows. Like in terms of what he was able to do with that very damaging testimony in terms of mitigating it was a masterful cross. If you're looking at it completely objectively, which I do on all this shit, I was like, man, he crushed that cross. And that in and of itself, I was trying to our viewers, I'm like, I don't give a fuck what it was. Like,
I know.
But you think Hank Brandon did exactly what he was hired to do.
It was smart but effective.
But you don't need to
hired to be a goon.
You don't need to make him. You don't need to make him lead for that. If that's the reason you bring him on, you want him to like rehabilitate the cops because he's just crossing dirty cops, and he knows how to do. He knows how to do it in reverse. You don't need him to be the lead prosecutor for that. You get someone else to be the lead prosecutor, and you bring him on as the specialist who deals with that, who deals with those witnesses, and then also his smarmy effect will be less pronounced, right? Because it will be smaller increments. And so that would be the smarter way to play it. So why he's lead is beyond me.
I don't know if they realized he was quite as smarmy. Is he always like that? I've never seen the guy try a case, so it's like
have you tried a case with him, Mark?
No. But the point is, he's coming from private practice. He's not coming in to hold Lally's bag or somebody else's bag. I mean, for whatever reason, he's a well-known attorney in the area.
Right, you're not taking a side chair.
It's always been curious. Why in the hell would you leave lucrative private practice to do this? To take a case like this and frankly, to do it in a way that you do come off entirely smarmy, sleazy, and he is used to cross-examining cops, FBI agents, scoundrels, cooperating witnesses, dirtbags, rats, all that, and he's good at it. So when you take that tone with medical doctors, engineers, and you kind of lost the plot a little bit because you see. I
toned it down with La Posada though, so you had the muscle and like he was very different.
Because he knew it. Because he literally used her in the past. I mean,
exactly.
And you could tell right on she didn't like him. I mean, right out of the gate, she was very snivelly and pissy and sassy.
Yeah. And correcting him on shit, pronunciation.
So the jury has to see because Brennan in front of your mouth. The jury has to see because Brennan is like literally like your cliche weasel, dude. Like he sounds smarmy naturally. You know what I mean? He's got that. He's got
nice background,
nasally voice, and he's got a lisp.
Like
And it's, you know what I'm saying? It makes your skin crawl. Like it has to have the same effect on the jury, and he's doing this to family people. You know what I'm saying? Who spent their lives educating themselves to become experts at something, and he's just minimizing them at every turn with that voice, right? So, you know what I'm saying? Like the jury is just put off by this guy from the start.
Yes,
experienced, high-level attorney who knows how to streamline the case better than the first time, and obviously has done this, seen this movie before, would literally die on the hill that the ARCA guys are unworthy of belief because of something with deleted text and ham sandwiches. When you saw that,
Forget laughing.
that
I
we
will
are,
laugh.
I mean, we
Who knew
really
Signal
are-
was so nefarious? I mean, come on. You guys do Signal? Dun, dun, dun. What?
And to
Red
Mark's
Light was-
point,
Like, what is happening? Rentschler was shocked. I felt so bad for him.
yeah.
It was
And-
crazy.
And Mark, to your point, we as like defense attorneys, you don't take everything to trial. You don't want to lose. Where was his, like all the other things you talked about as well? Like, all right, this isn't, why am I doing this? Why would I leave a lucrative practice for $250,000, whatever? But I could lose because this case sucks. Like, how is that not part of the analysis or factored into it enough to say, you know what, I'm going to pass? What do you think was really going on then? Why do you think he took it?
I don't know, but it's getting serious because it's getting all kinds of Texas in here now down there.
He puts his hat on. Shit's getting real.
Damn straight, baby.
He could pick up this much, and it just did.
Soon he took the case.
Yeah, that's right. I'm the sheriff, and I'm here to bring order to this lawless land.
Yeah.
Was a sexy case, right? Lawyers like big cases. On the other hand, you want to have a little judgment. I mean, look, I know, okay, I almost got into this on the good side. That's exciting. That's good what you want to do.
100%.
But the idea of saying, how'd you like to get in this case, but you're going to prosecute it, I would say, are you out of your mind? I mean, this is just, for so many reasons,
Unwinnable.
Right.
it's wrong. If you care about any sense of your own credibility, which every lawyer should. I mean, I feel like his biggest problem is because he is a skilled lawyer and he has a reputation of whatever.
Yes.
And I wonder how much credibility damage has he done to himself beyond this? Because
For sure, because not only did he piss off like other defense attorneys, like for the way that he did it, and someone put in a comment, like even asking for trying to get all the lawyers' text messages. But now you've pissed off the white hat people because you put in perjured evidence. You tried to buy
Nobody-
the jury. I mean, now people are like,
What a fucking Weasley little liar, dude.
For sure. Nobody likes this guy, bro. Nobody. Like, that's where we're at. Hank Brennan, nobody likes him. The only
There's someone out there
people
for
are the
everybody.
worst people.
yeah,
There's someone out there
You know
for
what I'm
everybody.
saying?
You'll find your person.
Right. There's plenty of folks out there. There's plenty of pro Brennan memes out there. It's like
But they're posted by the worst people, dude.
right, and
well,
people not looking objective.
they are the worst people because these are the same people who would say, "Oh my God, you lawyers have no soul for representing murderous like Karen Reed or a serial harasser like Aiden Carney or whatever." And Alan Jackson represented, Kevin Spacey and Harvey Weinstein, and you're just awful. And then you say, first of all, lawyers, we don't judge like that. We don't. But then you say, where does Whitey Bulger fit into that?
Right, exactly.
I'm thinking like murderer is worse than this or that. But again, they just.
And a snitch. And a snitch. Like,
But I don't. In all fairness, I don't think him representing Whitey Bulger should be part of the criticism. I don't.
It shouldn't, but if that's their mentality, is what you're saying. That's the side's mentality that they'll attack a lawyer for that. But hello, it's like Hank Brennan. Why'd you use a 50-pound, the 50 percentile dummy? Well, why'd your expert do it?
Yeah, he got caught on that, didn't he?
Yeah, he did. All right,
Yeah.
Kurt. Now I haven't had I've asked Mark. I know what Mark's position on this. I'm gonna go back into the case itself. In terms of, I was a huge fan of the way that they decided to try this one. Obviously they had an opportunity to have ARCA do some more testing. They were able to buff up and bulk up their science in terms of what they were going to be able to produce to the jury. But would you have called the Higgins?
No.
Called, because that's like Mark's. I correct me if I'm wrong. Mark still of the mindset. I would
here
have
we are again.
down there.
I think Proctor is interesting. The problem, as I've sort of come to appreciate is that Bev would have allowed the most bus cross, of all time. I am quite sure, and Brendan would have, asked all the questions. He would just testified. I mean, not that cross examination isn't already that, but more so. More so, and he would just fed him all the answers, and he would have had the most robust cross, and it would have just been really annoying. So I think they probably made the right call on balance, although it's a tricky call. I don't know. I'm still not sure on that one.
There's no wrong answer. There's no wrong answer, but think of the argument they made where they tied Higgins in the summation, not accusing him of murder, but saying, man, there's a lot of suspicious stuff that this corrupt trooper didn't even look at. Okay, now you put Proctor and Higgins in there, that argument becomes 1,000 times more powerful that you're not even looking at this guy and you're playing that video. And there's nothing Higgins is going to say about that waterfall video that's ever going to sound good. There's nothing he's going to say about, destroying his phone into multiple pieces and separate garbage cans on a military base, getting a lawyer, selecting text messages through his FBI friend, driving cars drunk around the Canton police. There's nothing.
Snow when the sun's late, and then parking your car right at the end of the driveway.
Let Brennan testify through these guys. There's nothing those guys were ever going to say. I think that was going to help.
And
them.
of course, they're going to object to everything. And Brennan, with respect to the direct, they're not going to be able to get what they want out of Higgins and Proctor because they're going to object to everything.
And going to sit there looking oafish too, looking guilty as hell, but oafish on top of it. So,
I did feel.
Yeah, no. I'm actually agreeing with you, Mark. I mean, in theory, I don't see how Higgins could look good.
Part of what was missing for me was Higgins, and not from a third-party culprit standpoint. You don't even need to go there. Just from who the hell was in the Sallyport with the car, Kenny, and then he deleted his text messages. Just a couple of little things like that would have, I thought, just kind of brought it home. But it sounds like they didn't need it if we're reading the tea leaves right.
I don't think they need it. I mean, again, I think they made a fair, reasonable, excellent choice. We're really just splitting hairs. Mm-hmm. But if the thrust of the defense is put it on the girl right away in those text messages, Higgins becomes the poster child of just ignoring things that any reasonable investigator would at least consider. Again, it doesn't mean you have to find him having committed a murder, but just to investigatively have no interest in any of these oddities, I think would look powerful if these two people were forced to testify. But I get totally why they did it. I think it's reasonable that they didn't. I think they handled it well in how they summed up on it, and I don't think the case is going to turn on it by any stretch.
Do you think because they put this, you call it the off-ramp, whatever the hell you want to call it, the OUI standalone, that's why they decided not to put into context, use the completion doctrine to put into context some of the recordings, because they wanted that to be kind of like you're saying, use the lights. And why do you think they didn't then?
Because I think the recordings were not good, and
but some of them. There was the one, for example, when he used the clip of her saying, I know I said, did I hit him? Or I know I said I hit him, blah, 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 blah. And then later he argued when Russell said that's trauma response. He's like, a year later? No. Oh, fuck you, Brennan. She was not saying that then and there. She was not still saying that a year later. She was explaining what she might have said had she said it a year ago.
How are you putting that in context where it outweighs more damage of playing it again?
Yeah.
I mean, to me, I think they did the right thing with the clips. They just kind of shrugged their shoulders, and it is what it is. It doesn't prove anything. It's not a good look. She does not look good. Like a water buffalo on the plane. I mean, that's unfortunate language, but it doesn't prove anything. No. And I think the best example is the note you got yesterday. Is this even evidence? Right. So I think I don't have a problem with them ignoring it in essence and focusing on the science and no collision. That was fine. I thought.
I have a question for my league
Nick.
colleagues. So this might be a really stupid question. Disclaimer, by the way.
I'm sure
But
perfect.
do you think do you think that maybe is it think that there's a possibility that the defense putting that OUI out there as that option did that? Excuse me, sorry. Do you think that that could have been possibly a strategy to let the jury know, hey, she's willing to take accountability for something? You
They
know?
don't know he put it. They don't know who suggested it.
Yeah, that's true.
No, fair enough. But I mean, they're assuming. Well, okay, yeah, you're right. So they would
Why not?
know that Karen's defense team.
It just goes back to what 30 minutes ago. Then why not tell them that information and lead them to that possibility with the error? Yeah, come over here, and you can still argue
Yeah.
he's guilty of this, but it has nothing to do with a car accident. This has nothing to do with a car accident. And if you find that she was drinking, don't get caught up in the car accident. You can still do this. I mean, I think they put it there, I think, for that reason, but I'm not sure why you wouldn't advertise it. That's all.
And Mark,
But
we
it's totally-
talked about
Yeah, no, that makes perfect sense.
Yeah, we talked about this before you got on. But so my issue, so obviously I believe that the defense team wanted it to be either 12:45 or 5 a.m. on the DUI time because they're trying to get a compromise verdict. But technically, I still see and I'll get to Kurt made a great point, but that's you've got a unanimous verdict issue here. You can't have 6 jurors say, I think she was not guilty of a DUI at midnight, but I do think she was at 5, and another 6 say, nope, she was not guilty at 5, but she was at 6, and under the Constitution, legally have a valid unanimous verdict. Obviously, this is a strange case for the juror. The defense is like, I'll take him however you can get him. I think one of Kurt made a joke like, if you think she drove drunk yesterday, check it off. You know, but that's
It's listen, I had a wrongful conviction on a murder case years ago where, it was like, order from column A, B, or C on what theory, and the DA was arguing multiple theories in summation.
Yep.
And we're sitting there saying, how the hell are we even sure that 4 of them didn't convict at the trial, which I was not a part of, on this theory, another 6 on this, and like there's no unanimity in actually what are they deciding. And yeah, I mean, they don't have a clear time. Obviously, the jury doesn't know. The DA did not plead it in the indictment, the time. Obviously, the defense, for whatever reason, didn't, get a bill of particulars and kind of forced an answer on that, which I suppose they could have done, although I don't know that that was the biggest thought on their mind back then. They presumed that it would have been related to the time of the murder, so 12:30 or whatever. But, in hindsight, yeah. But, I mean, I thought the judge actually gave the right answer on that one. I mean,
well, it's helpful to the defense because they can get a non
totally.
right.
Yeah.
But Kurt's point was that he thinks Brennan was right, and I think he makes a very strong point. It's a lesser included, so it should follow the time from the manslaughter, technically.
Yep.
It probably should, but I still think, I mean, look, if you want an acquittal here, when she
Right.
says, I'm not telling you and I have no freaking idea, and that's for you to decide. I mean, that feels like reasonable doubt all over the place with what they're agreeing.
That's exactly what Will said. Like that answer right there just hones in reasonable doubt because we don't know. You tell us.
Yeah. I mean, I kind of like the answer she gave on that. to tell you the
Yeah, I
truth.
thought it was good, but constitutionally, it would have been an issue in almost every other situation.
It's
Like-
legal error. It's legal error. It has to, because you're adding something. You can't do that with lesser included. You can't add anything.
Well, if she gets convicted, I mean, she'll have a point of appeal, I suppose.
Yeah.
on that, even if it worked against her. But unclear is unclear. How do we know what the jury was thinking?
All right, which dovetails perfectly into the question of whether or not. So if they do come back with the conviction on the OUI, and I want to hear from everybody, is she going to? What's the trial tax going to be in light of everything that this case is?
I don't know.
some jail time.
I
I don't
don't-
think 2.5, but maybe some.
I don't really.
I was gonna say, what is the max if they can
2.5.
OUI?
2.5 years.
Yeah.
Does anybody here think Bev would throw that at her?
No, but I think, put it this way, somebody gets convicted first offense, DUI, almost anywhere.
No,
No
joke.
no. Again, there's no accident here. Presumably, no one goes to jail. But the way I see this judge handling it is almost like what you see in federal court and those nasty FATCO hearings and acquitted conduct being used as a sentence enhancing her. And I could see her saying, "You set a chain of events into play, even though you're acquitted of all this."
But it might have been 5 a.m. and that had nothing to do with it.
You could have called 911. And I'm telling you, I just feel that there's going to be not only just a trial tax in general, but
Words
that
of
whole
first saying, I'm disregarding the jury's verdict. I'm saying you're guilty. Basically.
But it's just like Bev went full ratchet, full nurse ratchet.
If she
Like,
does what
I mean,
he
is
just
anybody
said, that's for
denying
sure.
that? Like, I just hear Murphy like being like, she likes a rigged game. You know what I mean? Like that fucking nurse, man. She's giving me that full nurse ratchet vibe at this point. You know, like who knows why she's doing it? But she is just taking every jab she can at Karen Reed in her defense. It is so bizarre.
If she got 2 years or something like that, if you think that this case is scandalous now, if she gets acquitted of every other crime other than what amounts to a ticky-tack DWI, OUI conviction, and she throws her in the can for 2 years, if you think it's bad now,
Yeah.
there'll be pitchforks and lanterns out in front of the courthouse.
Yeah, I mean, if all was right in the world, and even the slightest sense, she'd be treated like any other person. And like in the back of my mind, I still hold out hope. The judge will do what she do for any other person. But my hope is that if she gives her jail time, it's something like 30, 60 days, day for day. But even that's more than what she deserves, and it's more than anyone else would
You know what would be a savage move? You know how lawyers like to analogize and use case illustrations and comparatives and whatnot? Chris Albert,
No.
drunk driving, left leg, killed someone, convicted, disappeared today, got 6 months. Now, granted, that's a long time ago, and yes, there's a connection with the judge's family, which is all part of the problem with this whole thing Will talked about. But granted that case was from the 1990s and may not fall,
So the judge represented Chris Albert or an Albert?
The judge's brother represented Chris Albert, and he killed in a case where he killed somebody and fled the scene.
Lawyers talk about like, is this case within the heartland without it? Maybe it's so far afield. Again, I'm going on like federal sentencing and all that stuff. But I mean, you throw that out there as like the high watermark and say, in this case, she wasn't found guilty of killing anyone. She didn't flee. She didn't do this. I mean, that is putting the judge in a tough,
Dude,
as well as
the clerk has a DUI, dude. You know what I'm saying? Like, come on.
Well, I'd like
let me
to.
tell
Oh,
you,
go ahead. Finish your thought.
maybe the judge should be better off praying there's no conviction, because I'm aware of the clerk thing. I'm not going to talk about that. I don't know what happened with the case. Now's not the time, obviously. But what
Sorry.
if these lawyers?
My bad.
No.
No, you're fine.
No. What I'm saying is, if she gets convicted and Brennan's smacking the table for 2 years, a year, whatever, they start making these arguments, say, let's talk about justice in Norfolk County and who gets what.
Right.
And that argument is above
Prosecution,
board
selective sentencing.
and fair. And if you have a situation where, the lawyers on behalf of Karen are arguing about, why did Chris Albert get this preferential treatment? Why did other people in the court system get this preferential treatment? You want to talk about must-see TV scandal? I mean, you start comparing all that stuff. I mean, it gets ugly.
So I was doing some.
Time served in probation.
Yeah, I was doing some case law research relating to the sentencing issues in terms of what can be factored in and what can't. So the judge in sentencing can use factors in mitigation and factors in aggravation, and those factors can be newly presented evidence that would be presented. The most obvious example of which would be a criminal history related to a different suspect. So obviously, for liability purposes, no evidence relating to prior convictions will be presented. At sentencing, they will be, which in the case of that is pretty easy. You just show a certified, certified conviction, and Bob's your uncle, and you can use it. Now, what was interesting is that Massachusetts seems to provide more protection than federal law. So one of the questions I wanted to know was, if they only checked box 5 on sheet 2 and they acquitted on counts 1 and 3, could the judge use the death of John O'Keefe as a factor in sentencing? The answer appears to be no. Under federal law, the answer is yes. Under federal law, the answer is yes. So there was a U.S. Supreme Court case called U.S. versus Watts from 2000 or 1997, and the U.S. Supreme Court said that you can use a fact from an acquitted charge as long as the judge finds it by preponderance of the evidence. So, as a matter of federal
team cited that case.
Yeah, as a matter of federal law, they could, but under the
federal hearings in federal court, you see this. You get killed with acquitted conduct. It's terrible.
But under state law, the answer appears to be no, because there was a Supreme Court of Massachusetts case called Commonwealth versus McGravy from 2000, in which it appears the answer is no. So
they said they're not lockstep with the U.S.
Well, yeah, they're providing more protection, which is always valid. States can provide more protection, no problem. So under Massachusetts, it does not appear that can use any acquitted conduct. So she would not be able to use the death of John O'Keefe. So as we're considering what she can do legally, because it's an abuse of discretion standard, it's like she would have to justify any sentence that would be more than the norm based on factors that would be presented. I'm not aware of what those factors are that would be permissible. So I don't know that she can really do much more than standard. So if I read the guidelines correctly for first offense, they use this term intermediate sentencing, I think, which is like this probation-like stuff. Yeah, well, I'm trying to do some legal analysis here.
I mean, I get it, and you're right. You're like, and it's super. Like, I'm kind of blown away, actually. But as soon as I start to adopt that, I remember Bev's Bev. You know what I mean? And
yeah, well, she
my faith, bro.
What the Court of Appeals is supposed to do is do an abuse of discretion analysis, so she can sentence within a swath, but not infinitely. So again, she'd have to justify any departure based on factors that would be presented. I'm not aware of any such factors that could be presented. So you would therefore say legally her sentences would be like these probation-like stuff and not much more. So I'm not sure Beth really can do the more extreme versions based on the case law.
If you weren't drunk, you would have waited and made sure that he was either inside or out. Or if you weren't drunk, you would have went back to see if he was okay. I mean, I don't know, but that's very good to know that she cannot rely on.
And that seems to be true.
The accident,
Yeah, well, first and foremost, that was an excellent fucking answer, Kurt. Thank you.
Yeah, here to help.
Yeah, so, I think based on what Kurt just educated, I don't think that she can do that. I mean, unless she doesn't give a shit about being overturned on appeal, and I think that raises the question because I'm assuming it's day for day there, I mean, she's going to get good time. If she were to sentence her to 180 days, she's going to do half of that. I mean, you're not even getting an appeal pushed through in that period of time, so it's like the concept of whether or not she's going to take into consideration, all right, I'm probably going to get dinged on this and they're going to kick it back at me. But does she give a shit if the time frame that she's willing to go in terms of a trial tax, is it a calculated risk that she's willing to take? And that's kind of where because Will's the everyman, right? Will's the fucking enraged.
Will's the one holding this verdict up right now.
Are you suggesting Judge Bev may consciously disregard the law?
I mean,
preposterous.
I mean,
right?
Yeah,
that can't be true, surely.
No, that's.
But maybe that's why I'm saying maybe she'd find other sort of outrageous ways to take it away from the accident and still somehow say, something like what Mark was saying, well, if you hadn't been drunk, you would have watched to make sure he went in the house correctly, or you would have done something different and he could have been discovered sooner. And that would,
I mean, if she takes that step, she's She's violated Massachusetts law.
No, I'm saying
Only a drunk listens to you too.
no.
That's
I'm
what
saying
happened.
she figures out a way not to rely on the, on the acquitted conduct,
Right.
so not the actual accident, not
Aggravating
act-
circumstances.
right, but coming up with other ones, and
Well, how does her saying, "Well, you should have waited back to watch him go into the home," and in
no, when
way,
he's drunk, and
I don't see the aggravation in that.
I know it's
Yeah, how's that make the DUI worse? Because she has no duty to watch him go inside.
yeah,
So
I was
how's that a factor?
Yeah, I don't.
It's a grown ass man,
You
exactly.
could use the storm as a.
Oh, the very light dusting snow enough to track a cat.
Yeah, I guess so.
Which, by the way, was my favorite new statement that I was unaware of.
Yeah, apparently that's a technical determination now. It's okay, right?
You know what? It's magical though, because it's so on point. That's exactly the amount of snow. Like when he said it, I knew exactly the amount of snow that he was talking about. Because obviously, if it's too much snow, you're not going to see the tracks. So it was like, yeah, like a quarter of an inch. It's like that's how much you need to track a cat.
Also, there is no cat. So how about dogs?
Bigger paws, Kurt, bigger paws. Sometimes. So, all right. I mean, what are they doing back there? Like,
That's
at
what I'm
this
wondering.
point?
Almost like I thought they might say something before lunch. Since
You think they just really want that free lunch? That's what it is. They just really crave.
I was hoping
free
they would
lunchtime?
say something before lunch, knowing, like, I guess that the judge cuts all communication off during that hour, that they'd come out before it.
Does it qualify as a bribe if I say they come to a verdict, any verdict, I will personally them lunch so that we can move on with our lives? Is that a bribe?
I'll allow it.
'Cause we're not getting the notes, so I mean, if they're in an impasse, we haven't gotten the first note relating to that, and I think in my mind, it became clear during the first trial in respect to what was going on back there that they were dug into their positions pretty early on. And then they tried to fight their ways out of it, and there was no making any headway. People were just unmovable in their position, and so because what day was it that we got the first note? You guys remember? No. I'm talking not a question. I'm talking about a note. Different things. So I can't remember how many days into the first deliberation.
It was like 20-something hours. It was like 20-something hours, I think. Yeah. My friend Annie texted me, and she's like, so does anybody here, like, I got to ask lawyers this, does anybody here feel like this is already, has it gotten to the point where it's taking too long, in your opinion?
Yes.
It's gotten to the point where if I'm the defense, I'm nervous. Because it's like I was talking about it yesterday. You have kind of this role. It's like every trial. If you've tried a case and you're waiting on a jury to come back, it's a roller coaster. If you get a question, you're trying to read through the tea leaves. Like Allie and I, anytime we get a question, we're running back to court. We're like, what is the question? Because you can glean information a lot of times from these questions and kind of where they're leaning.
You're getting closer to verdict.
You typically, and like here, like I felt really, really positive about the concept that they had, found her not guilty on the murder too, and more likely than not guilty on the leaving a scene, and that left kind of the fucked up slip hanging in the balance. And, but I felt because of the clips, like I said, the one that seemed to work the most in conjunction with their question was that one where Karen's kind of giving a blow by blow of the amount of alcohol that she consumed or had poured into her drink during the course of the night. So I'm like, all right, it seems to me that they're bickering about the OUI. And, but now, how fucking long can they bicker about an OUI? Like,
Ask Will.
That's a good
Well, it depends.
Will.
Is Glazer
I
on
will
our
go
jury?
as long as it takes, dude.
Kurt, what did you say, Kurt?
I said it depends. Is Glazer on our jury?
Right.
Yeah.
concern I would have about how long can they bicker over an OUI may not be whether there's reasonable doubt over the OUI or not. It goes back to the questions they've been asking the judge. What happens
Right.
if we do this? Are we going to have her sent away on manslaughter time? Are we going to have a whole new trial for manslaughter? And, you know, I was talking about this last night with someone else.
Yeah, that's fair.
I don't even know if the deliberation at this point is involved in what a deliberation should be, fact finding and reasonable doubt, or
I'm trying to figure out the god law.
right. And we, you know, last answer we got wasn't exactly great. Now, they could ask if they were bothered. That's true, and they haven't, at least since yesterday. But yeah, you have to think that there are people who could be dug in over, again, a ticky-tack OUI because they're terrified whether they're guilty or innocent, what it could mean for the bigger picture, a retrial, going to state prison on, you know, much more than a year, you know, something akin with intentionally killing someone. You know, they're worried about those things potentially more than.
Doesn't that warrant another fucking note? Like, if you're sitting back there just like, and it's devolved into, we're not even talking about the facts of the case anymore. What we're talking about is trying to understand how the law operates back here and how to answer this slip. Screw her. She didn't answer our question. Somebody back there has to be saying, I'm writing another note. Like, I don't care what you all say. We did. Yeah,
There's no note, as far as we know, about clarifying the law. And at this point, you know, it's close to 20 hours. There's been no suggestion that these people are ready to pull each other's hair out either.
Yeah.
So they just keep going, and we sit and wait. You know, that's what it is.
And the other scarier concept is that they're battling over a manslaughter. You know, I mean, it's the longer it goes, and when we kind of take into consideration everything that we just talked about, you have to say, like, if you're the defense attorneys, you're starting that thought is starting to creep in, and it's starting to worry you the longer this thing goes. You know, I mean, you can't help but start thinking it just with every minute that passes, and without being another note coming out saying, look, we heard you on whatever you told us yesterday, but here's the deal. Like, your answer to us is what is holding this up, because it just wasn't sufficient.
I mean, you hope you're not having a, you know, 12 angry men in reverse, basically. Yeah. I mean, until the verdict is final, they're allowed to keep going, and you never know. Momentum can change. Somebody raises a point, somebody agrees with it, then three people say, yeah, we didn't think about that, and next thing you know, the needle either way could be tilting. So you would, yeah, I mean, there's no question that after they got the note yesterday, it did sound like that they were tinkering over the OUI, and here you are 24 hours later, and they still haven't finished it. It's natural to wonder, are they now, you know, going back up the chain? Is that a possibility?
Right. That's the
thing. You don't know. I mean, you just have no clue.
Because that's the risk in it all. Like, if the debate on the OUI is what's going on, are they going to meander back up into manslaughter just by way of the conversation?
I mean, any juror has any right to raise the question of, let's go back to this. I mean, any juror could say, well, wait a minute, I want to talk about murder. I mean, you never know. I mean, I don't think that's likely, obviously. Right. But, I mean, they can do whatever the hell they want in any way they want, and, you know, no one's in there, so we just have no clue.
Yeah, man, it's confounding. It really is. But it's like every lawyer will always tell you, and it's the gospel, you just never know what a jury's going to do. You just don't. Like, I mean, we've read it wrong so many times in cases that we've tried where we're like, man, we just crushed that case. This is going to be an NG in like 3 hours, you know, and then they come on convict and we're like stunned, you know.
A lot of it too is unfortunate, you know, as you said, like the kind of judicial draw you get. I don't know about you guys, but I am and Will knows this, a huge proponent of bench trials in the right circumstances. Like, and I have always said that this case, not in the current connotation of judicial assignment. I've always
it worked out well for Aiden just last
well.
week.
I
mean,
I wonder if I had a lot to do with that.
just
the
an
point-
observation. It worked well for Aiden last week.
I'm just observing too, Will. I'm not saying anything. The point is, this case on the law is, and on reasonable doubt, it is a ground ball acquittal in front of a judge who is just like not interested in anything else. Now, I don't think anybody would do that in front of this judge for a lot of reasons, but in front of a different judge, you know, the reasonable doubt here is off the charts, right?
I love this exercise. So Kurt, in a world in which Cannoni's not on the bench in this case, you're presented with these facts. You're deep into discovery. You've gotten all the discovery. You know what's there. Is there any point where you're thinking on trying this one bench?
As the judge?
Forget
No,
no.
as a lawyer.
If you're defense, do you contemplate this? If Cannoni's not the judge, if it's say either of the judges that
Somebody who's fair.
right,
No, he's not the judge, and it's not in the public eye as much because I feel like that adds that pressure to the judge. But
I on a case like this, for a murder case, I don't know. That feels like a lot on to do that. I mean, you're trusting your fate to one person who hopefully is objective and fair, and it seems to me, as I've said before, like the biggest problem for the government. There's a lot of ways to get to reasonable doubt, but like for me, the easiest way to get to reasonable doubt is no matter what you think happened that evening, no matter what you think happened in terms of vehicle position, timing, speed, angle of collision, like no matter what you think happened in those sort of factors, for the state to be right, two things have to be true at the same time. The vehicle collision has to have occurred with enough force to create some kind of disabling injury, whether that disabled him outright, killed him outright, rendered him unconscious, otherwise disabled him, whatever. But the collision has to have occurred to create some kind of disabling injury. And simultaneously, that amount of force created no broken bones, no torn ligaments, and no bruising. That has to be true. Both those things have to be true at the same
and the
time.
damage, and that debilitating thing causes all that damage to the car.
Right. Well, but yeah,
Here you're the biomechanical expert. So
yeah, so like that's the problem for me, because you have to believe that is true beyond a reasonable doubt, because it's essential, right? It's I will agree it's possible, but you have to believe it's true to beyond a reasonable doubt. And I just don't know how you can believe it's true beyond a reasonable doubt if you are an objective person. Like you can believe, you could at least, yeah, that's the biggest problem for me. And if you can't believe that, there's no point in discussing anything else, right? Because
like
you fail.
that analysis be accurate, but we're even burying the lead. Their own medical examiner would not call it a homicide.
right.
Okay, in front of a judge, we're at reasonable doubt if you sit and twiddle notes the rest of the trial. I mean,
Dude, you can take every fact of this case, put it in a hat, and pick one blindly, and
Yes.
you can find a reasonable doubt.
And
Like,
that was another.
I could do it.
I 100% agree. And that was another gaslighting closing moment. Am I making this up, or did Brennan say that that the Emmy did not have all this other information, that she literally testified? Yeah, I heard that. And then he said, and she didn't know about Karen Reed's statements. Yes, I heard that. She said she knew all those things and said she could have changed. There might have been like one thing that she was like, I'm not sure if I knew about that, but almost all of it, she said, I knew. And then he told the jury she didn't know about any of this.
He said that the investigation continued upon the 90 days, up to which the medical examiner could have changed her opinion, and therefore she wasn't informed. That's a great argument to like have in the hypothetical of what do you think happened. The problem is that in a court of law, that's not the issue. The issue is burdens of proof and reasonable
But she
doubt.
testified otherwise, even after the 90 days. She said, I heard those things. And she did say after 90 days she could have still amended it.
So here's the X factor though, and kind of like playing this exercise out, because I am in the same place that Kurt is in terms of this case for me begins and ends with the injuries or lack thereof that John O'Keefe suffered. Because if you're talking about like your typical judge, the judges that Ali and I argue in front of all the time, and when you're coming in, when you insert the taillight issue and the damage to the taillight and the fact these pieces were found in the yard, that you have this issue of, are you trying to convince this judge who are typically, hey, what's up, Aiden? Are we,
Hey, Bob, how are you?
good, man? What's the word on the street, dude?
We're just waiting, man. Everybody keeps asking me, when is it going to be today? As if I have any insight. I'm like, do you think it's going to be today? I thought it was going to. I don't know. I'd like to hear you guys' insight. I just don't understand. It's pretty obvious to me, based on the jury note, that it appears as if they're only debating the DUI charge, and they don't want to. The third question they asked leads me to believe that they didn't want to accidentally convict Karen Reed.
We all agree.
They said the fifth provision of the second charge, if they're worried that if they put guilty on that they are not putting not guilty on the other stuff. And so they're like, which leads me to believe they're only talking about a DUI. But now it's been 24 hours, so they've had like plenty of time to figure that out. And so I'm like, what are they doing in there? Like,
We're literally having that exact conversation right before you jumped on. Like I'm like, because if they're fucked up with the law, if their answer, which it was not sufficient for them to understand what to do with that second count, like we've now had hours going on. Like, wouldn't they have sent another note? But like, look, we heard your first answer. It's insufficient. We need more help from you because we're still hung up on this thing. And like I just think that they would have sent another note out, which gets me worried that maybe the manslaughter thing has re-entered the conversation.
I have an answer for you, Aiden. The answer is Will. Glare says if he was on that jury, he would not want to be forced to compromise on the OUI, and he would stay dug in. And I'm sure that that's what's happening. There's some people unwilling to vote guilty on the OUI, and Mark made the point earlier that, you know what, the guilty people need to, or the guilty people, the guilty people just need to say not guilty and just compromise on their end, because
if they don't think she's guilty of manslaughter and want to acquit, and they have any understanding that if they hang on the OUI, that it could lead to the entire issue, including manslaughter, come back, then those people are morally obligated to nullify on the ticky-tack OUI and make sure she is acquitted on the homicide count and publish that, which is exactly what the last jury didn't do, and why Karen was tried twice for murder. You're going to have this happen again for the third time if they don't do that.
But I do think that's your answer, because Will was being very forthcoming, saying, even knowing everything I know, even knowing it might open up manslaughter to a third trial, I'm dug in, and you're not convincing me to vote guilty. And
if that's the case, then at some point you have to have a conversation where you say that the defense putting that on the roster is one of the greatest blunders of all time. If that's what's actually happening, if that's what causes a mistrial, and they were intending to acquit on everything else, and because of the DUI they caused a mistrial, that will go down as one of the great blunders of all time.
Go ask them to see if they can withdraw it. Your Honor, we don't withdraw it.
What I don't understand is she was never indicted for that. I looked at the indictment yesterday. She was never indicted for that. I didn't know you could just, it's like a buffet. You can just add charges. Like, why not add littering? Like, she left like they're saying, right? Get her on littering.
Why not? It's a little different. A lesser included offense has to have, the elements of the crime time accept the larger one, and there has to be a reasonable view of the evidence that, again, a judicial determination that a jury could find the lesser offense is a reasonable view of the evidence and acquit on the higher one. And the reality is that the OUI is an element of count two. She has to be operating under the influence. So you can't just add littering. You can't add something that's not indicted. Lesser included offenses can be requested by either party. It was them who requested it.
Maybe
But-
they can try to withdraw it now. Go ask them, Aiden.
Not a chance.
I don't know.
There's not a chance. And like,
Yeah.
the way
Can she
that I-
plead guilty to it? Can she plead guilty to OUI?
If they're willing to,
Hank would have to accept the plea.
The prosecution is
Oh,
never
yeah. Hank would have to accept the plea.
dismissing all the murder. And as a matter of politics, even though they know they may be cooked on all the homicide
They know.
counts, if they were to go in and say, you take a misdemeanor plea right now and we'll dismiss all the top counts. This happened in the, if you guys ever heard of the famous New York case, the Central Park, the Preppy murder, you know about the,
Yep.
that, where they, during deliberations, you know, the Manhattan DA's office kind of freaked out and took a lesser plea. It was kind of scandalous. But politically, they could never do it in this case because they would be acknowledging that 2 years and millions of dollars, 3 years and millions of dollars of investigative work and lost reputations and damaged careers. We agree that the right outcome here is a misdemeanor DWI because we're too chicken shit to hear the words not guilty on murder. They can't do that politically. Morrissey can't do that.
And
Never-
there is no motivation for Hank Brennan as he's currently situated to plead her out because where he's at, he understands that if there's not one person on the jury that understands the concept that if they're hung on this OUI, that allows the Commonwealth to come back with this fucking manslaughter charge. If there's not one person on the juror who's in that jury box that's saying, hey man, like this is what's going to happen. If we don't reach a decision on that, Hank has nothing to lose. Like Ian, his concept, I think, was right. Like at this point, Brennan was playing for a mistrial because he understands on count two.
he came in just when you said his theory.
Yeah, I mean, it's literally it plays into his hands because it gives them an opportunity. Oh, speaking of the devil,
Right. Your theory.
I
it
love
gives
it.
him the opportunity or the Commonwealth the potential to try the case again.
Well, and
Murder two will be gone, but manslaughter's still on the table, which is a nightmare scenario.
well, and
I mean,
he can.
yeah.
There's a he's going to make another $1 million off of this. You know they're going to bring him back, right? They have to bring him back.
And they accuse me of grifting. Wow.
Yeah, we've been saying that all morning, Ian, because I thought all of his answers to the jury questions was him begging for a mistrial, begging for a hung
absolutely.
jury. And I was like, Ian was right.
But if the motive, I mean, wouldn't the motive for Brennan to give the plea agreement to allow it, wouldn't it be just that he wants the conviction?
No, that's nothing. That's literally
Why?
Yeah.
garbage. Rip it up and throw it away.
An OUI is a win. Like,
Mhm.
3
Or
wins if
defense,
she
a
gets an
huge
OUI.
win. A like celebrate the biggest win ever is an OUI in this case for the defense.
We're all going out drinking, baby.
Yeah, and it would be the most expensive OUI
Oh.
conviction in the history of the United States, I imagine.
Probably.
Sure. Yeah. Aiden
And
said
do you
that
think
yesterday.
the defense can say, I want to revoke it? I asked for it, and at this point, we want to take it back. Is it even possible?
I don't think the judge would allow it. I don't know if it's like legally allowable, but it would be discretionary even if it is. And
I'd ask for
the
it.
judge would just be like, nah.
I think
sorry,
it would
send
be
it to the jury.
Not a chance.
I would say nah. I'm like, you got to eat the consequences of that decision. Yeah, I'd say
no,
no.
I-
I'd say no.
if the judge wants to have a shred of credibility, hold the jokes and all that, you can't do that. You can't submit a charge, have a screwed up jury come back and forth, give instructions, and then say, you know what, the hell with it. Let's pretend it never happened. And just,
Yeah,
I know. I just keep hoping.
yeah, it's not happening, man.
It's scary, Aiden, and we were hoping that you might have heard some rummages or movement over there. It sounds like no. Is lunch now? Is lunch in a half hour? What do you,
You know,
know?
I'm keeping an eye on it. Like, yeah, I mean, I'm just keeping an eye on it. I do know that on the 4th day last year, that's when they first came back and said we're deadlocked. At
Yep.
some point today, they're going to have to come back and say that. Like
Right.
that has to be. We're not just going to go the whole day with nothing happening. If anything happens, they're going to come back and say we're deadlocked. She's going to tell them to screw, go back, and then we'll do it again on Friday, right? But like this is different than last time because this jury up. That appears to be what's happening here, unless I'm missing.
Wait, we missed your signal sucks. We missed everything you just said.
It's because of all the news trucks too. Yeah.
Anyway, I don't know if you can hear me now.
We can hear you, but you cut out.
Yeah, you cut out. So re-say what
I'm
you were
sorry.
saying.
I forgot what the question was.
You were
About the mood down here. Yeah. So I think that on the 4th day last year, that is when they came back and they said that they were deadlocked. And then she told them to come back. And then the next day, the 5th day, they came back and they said, we're deadlocked. And she gave them the Tui Rodriguez. So we haven't had that yet. So they don't appear to be deadlocked on the meat and bones of the issue, which is the John wasn't hit by a car. They seem to agree on that. So unless I'm missing something, I don't know what they could be talking about in there.
Well, the OUI count is the only one, the lesser of anything that does not involve the need for a collision. So that's a logical viewpoint. They added, a different thought process to this whole thing, and the jury appears to be chewing on that repeatedly. And as Bob said earlier, hopefully not chewing on that and then revisiting other things and saying, well, maybe and going back up the hill because they can do whatever they want. They can go all over the place. No verdicts to publish. They have the right to revisit anything they want.
Yeah, because I mean, in my world, the longer they bicker about this OUI, and the more likely it is it's going to open up the conversation in a much broader way.
Well, my signal sucks. So I'm going to see you guys.
All right, man. Keep us up to date. Yeah,
I was just taking a look at Polymarket to see what they're doing. Polymarket, for those of you who are unfamiliar, is a betting site. So people are just betting money. So that's where the numbers come from. Right now, Polymarket is predicting for guilt on some version of manslaughter or murder, 15% chance to convict on one of those counts. And they are currently predicting a 60% chance to be acquitted on all charges, which leaves an implied 25% chance basically for the DUI/hang. So that's where they're sitting.
And so I think last time you gave us the odds on Friday, I think it was around 80% acquittal, right?
Yeah, so it's at 63% now, and as of yesterday, it was at a peak at 80%. That's right. So it is dropped to 61%. It's dropped 20% since yesterday.
How much money is in play? How much money is in there?
For the guilt pool, it is $153,000. For the acquittal pool, it's $68,000.
Wow, man. So, Ian, where are you at? What are you thinking? Let's get thoughts.
I mean, I'm hoping we don't see the worst case scenario of they hang on the OUI, because that would just be like tragic. I don't know. I don't think those questions really suggested a jury that was thinking that she hit him, right? Because those questions really very much to me said they're looking at the OUI and they're fighting over that. And I mean, it could be tragic if we end up with some juror coming out going, I refuse to budge on the OUI. And it's like, well, now she's going back for a manslaughter. And this is a weird trial because normally a hung jury is a win for the defense, right? Normally, the prosecution has to go, well, are we going to run it again? But this one, the prosecution will go, yes, we'll run it again. We'll drop another, $300,000 on Brennan. We'll drop another $500,000 on, well, maybe not Aperture, but there's got to be somebody else in the market. We'll buy another Lexus. We will, all of these things. And
it's going to be the revenge of Paul. He'll be back.
Oh, God. I mean, that's the other thing that'll be really funny on this one is if they do get an acquittal, I would not be surprised if we see Trooper Paul come back and say, and do a little press comment that says, well, you know what? They should have called me. They should have brought me in because, you know.
That would be like Christmas to me, dude.
In retrospect,
Trooper Paul, if you want to defend your position, like, come on, we'll
About Lally, I hung a jury, and by all accounts, at least on count 2, had a majority to convict on something. You put me on the shelf, you humiliate me, make me sit next to this guy, you know, playing with paper clips mostly for 2 months. And if he gets a full-on acquittal, who's your daddy now? That would be right.
yeah, there was a lot of pouting going on from that middle chair at the prosecutor's table. There's no question about that, man. I would think about that intermittently. I'm like, I'd look at Lally in the back of his head there and just kind of, like, he wouldn't even typically watch Hank work. You know what I mean? It's
Right.
like, because if you watch defense table, like if Alessi's there, you know, you usually have Dave kind of staring at him lovingly, you know, like watching him operate. And you just weren't seeing that with the prosecution side of it. And that whole situation with having Lally sit at the table was such an odd choice. Like, I really don't know, because presumably McLaughlin was just as capable of handling the couple of witnesses. That Lally
Yeah, right.
You know,
I didn't
Like he would step in the courtroom. Give me a break.
I didn't think it was
Well-
possible for Lally to look more defeated, and he does. Like, it's
Right
crazy.
now, he's thinking I did better than Brennan.
Yeah, man,
He did more ethically than Brennan.
He did this time around. He had more teeth. than
Even last time he was more ethical because he brought in all that stuff that was bad for his case.
Facts.
He presented a much fuller story.
Yeah, he did. He did.
We're giving Lally an ethical pass now.
Comparative to Brennan, that's what I'm going with. Yeah.
Put in an inverted video.
Well, he's certainly, wait a minute, he's part of the team. He knows more than anyone. So he's certainly imputed in terms of any
He knew the right
misconduct.
phrase.
Hold on. We're talking about Lally. Well, you think he did the right thing. He elicited testimony from Buchanan at the first trial about the inverted video. You don't think Lally knew and didn't suborn false
That's not
testimony?
what Kurt's saying, though. Kurt's saying that he at least projected the appearance of presenting a case. You know what I mean? Whereas Brennan's entire strategy this entire time has been to try to cut the legs out from Karen Reed's defense.
And
At the
confuse the
first
jury.
trial, does anybody wonder why at the first trial, when Officer Barrows testified as a prosecution witness and testified that there was a crack or something that's not like the condition, that Lally, who was very familiar with the witness, called the witness, prepped the witness, never asked him the money question after, or showed him the photograph and said, does it look like this? And the answer, of course, should have been yes. Why didn't he do that? I would suggest to you the reason he didn't do it is because he knew. And that's why when Barrows learned what a big issue this turned out to be in between trials, threw himself at the defense and was literally punching and thumping his chest saying, I want to be heard, I want to be heard, to clean his own soul and conscience.
Yeah.
Yeah. I mean,
And-
no doubt about it, Lally. I mean, anybody prosecuting this case is acting unethically. There is no case. There's no way to do this case, to present this case, to prosecute this case without fabricating evidence, without lying, without creating an appearance, without trying to confuse a jury. There's no way to do it because this is factually a frame job.
Well, Lally was
So-
good at confusing the jury. That I give him credit for. To
Right.
what Kurt was saying, throw it all out there and
Yeah.
just put it all out there and, you know, act like the Dunkin' Donuts. It's time to make the donuts guy and schluff in and ask a lot of this and a lot of that and put him to sleep. Yeah, I mean, it obviously did something for somebody.
For
I mean, he
somebody.
didn't come off as smarmy. That's true. He presented better. I don't know. I mean, look.
He didn't
I
do
think-
better, but he presented better.
I mean, look, Brennan is a better lawyer.
At least
Can we-
the illusion of a case, you know, he at least presented the illusion of having a case. You know what I mean? Like Brennan didn't even try. I mean, I can't think of I have limited interactions with Bostonian, but I've had a lot in the last year and a half since I started following this case. And I can't imagine a Bostonian on that jury that isn't like shaking their head at this blue paint stuff. You know what I mean? That isn't going like, does this guy think we're stupid? What's
Right.
going on here? You know what I
think
mean?
Brennan looked at his reports at the start of this trial and was like, I have got this case sewn up. And then mid-trial, you can see him start to lose his temper as his case starts falling apart. You can see him start to get more and more frustrated as things
Yeah.
start to fall apart around him. And he realizes that these witnesses he thought were going to be great are actually not so great. Like Welcher just, you know,
But Runkle, he read everything. I read all the reports. I read all the transcripts. There was shit he didn't know and shit he didn't care about. But
I mean, this dude
here's something.
testified like this the whole time. You know what I'm saying? Like, that's not a good look. You know?
And if I'm on the jury, I'm sitting there, and one of the things that would just keep, and it's been bothering me, it keeps echoing in my head, is just Welcher looks at everything and he says, I don't want to do a full speed test with a mannequin or with anything because it might destroy this Lexus that we have to resell. And I'm like, so you've got your reconstruction expert who is so sure of all of this. And he's like, there is no way we can do the Commonwealth theory without destroying this Lexus. I won't even test it because we need the Lexus there. And I'm going, their expert thinks that the Commonwealth theory is impossible. And it's so impossible that he doesn't want to test it because it would cost money and, you know, wreck the case. And I'm going,
Why can't you just
How
build the
do I get to-
why can't you just build the client for that? Because if it's a necessary expense, it's a necessary expense. Why not? Why not just build the
and
client?
this is the thing. If I'm spending this much money on this case and I'm doing it, I'm going, all right, it's going to suck, but wreck the Lexus if that's what it takes, right? And that's because I'm not where the Commonwealth is. Because what I'd be doing is I'd be going, okay, if you run this and the Lexus ends up trashed, I send to the defense, hey, we tried to replicate this and it smashes the Lexus. So obviously we don't have a case here, you know, because look what it did to the Lexus when we
Right.
try to reconstruct this. The problem is that's not what they're doing. They're not approaching this from a perspective of curiosity that really behooves a prosecution of what actually happened. Let's figure it out and let's try to disprove our own theory. You know, how do we show that? Because that's really how you test a theory. If you're saying Karen Read is guilty, you should be going in there going, the prosecution should be thinking, how would we prove she's innocent? And let's test all of those things and close those doors. But instead, they've done the opposite. It's how would we prove that she's innocent? And then let's not do any of that testing, you know, because that would be inconvenient for us. Let's selectively test and not test based on where we think we can guarantee ourselves a result that'll be helpful. And they've blown that up in a few places. Like they've blown this up in a few places where they've said, you know, we're going to test the piece of glass found on the bumper. I'm sure they thought, well, that'll be great evidence. And it turns out that we end up with one of the singular, most unexplainable pieces of evidence if you're thinking that Karen Read is guilty, because I cannot come to an explanation. And I've challenged several of the, anti-people on Twitter to come up with an explanation. Something plausible for that piece of glass on the bumper.
Oh, I can
And I've
think of
not
something.
heard one
come up
yet.
with it either. Stumped Welcher. He was like, wait a minute.
Wait, we're talking about something plausible other than Proctor putting it there.
That's the thing is, once we've eliminated
only thing that
everything
makes
else
sense.
on the bumper glass, we get to Proctor put it there.
Right.
And the thing is once you have a police officer who is messing with the evidence in any sense, everything fails at that point.
100%. Dead in the water.
Dead in the
case
water.
when you have an investigation, in my estimation, when you have an investigation that looks like this, that case is dead in the water. This case should never have been brought. To me, I mean, it leaks back into due process and the lack thereof when you have an investigation this investigation. And I've seen, and I say it all the time. There is no such thing as a perfect police investigation. There's always warts. We're dealing with human beings. They're always going to fuck something up. But when it's at this level of ineptitude, in terms of the things that were not done.
We don't know what happened.
I just don't know how, in good faith, that they moved forward on this case at any point. It's just an unbelievable set of circumstances.
Proctor was the lead investigator investigating Brian Walsh, the Anna Walsh murder. You look at his application for a warrant and read that, and you see every T is crossed, every I is dotted as far as what to do in an investigation, how to collect the evidence, what they needed to build a case. He spells it out. So Proctor knows. So the stark contrast between how he conducted the Karen Reed investigation versus the Brian Walsh investigation says nothing other than the fact that Michael Proctor is corrupt and dirty, not negligent, dirty. Period.
I think that's an excellent point. I think that is definitive proof that he knows how to fucking do it.
Right.
So we have evidence of it. And if you guys don't know what the Brian Walsh case, it's the guy who's alleged to have murdered his wife. You know, he had all the insane internet searches about how to dispose of bodies. And, you know, it was just like he's driving around, dropping shit off.
Totally did it.
Yeah, he totally
did it.
He got the right guy on that one.
So Joe Flipperhead says, look at all these YouTube grifters and Twitter lawyers. Thanks for the invite. Stuck at work. If we're still here Friday, don't put it out there in the universe. I'll hop on. Thank you for all the coverage throughout. And Joe, you've been the topic of conversation in our household and your concepts on our lives since you sent Bob that message about how if they're hung on the OUI and no way to say it, we're screwed. And that's what we are stuck with now. It's horrifying.
Yeah, worst case scenario seems to be potentially rearing its ugly head.
And again, it's because of the glare.
Joe flip ahead. Yeah, it's totally.
Yeah, well, Ian, we had this discussion early on with Will, who's our juror, our prospective juror, our layperson. And, you know, Allie asked him point blank, like, if you're in there, you know, and I think she posed it both ways. Like, initially, you're not aware of the concept that if you're hung on this charge, that means that they can bring this manslaughter charge back and try a third time. And Will was much of the mindset, look, on principle alone, there's no fucking way I'm finding her guilty on anything. I'm just not going to do it. Like, on principle alone, Allie challenged him and said, okay, well, what happens if you're aware of this concept of what the result
I might cave, like, because I'm not there, but
you were being
I'm fighting and I'm trying to get everyone else on my page. Like, it's real easy, not guilty. What's it going to hurt anybody to just let this woman go?
Right.
Like, do you really want to see this woman even, there's a chance that she goes to jail after this sham that we just got subjected to this whole time?
And especially in light of the fact if they're all convinced there was no collision, because then it becomes a much stronger argument. Like, what do you give a shit? Like, the reason we're here is whether or not she hit John. We've all reached the conclusion that she hasn't. Who gives a shit at this point? Like,
it's going to be real hard for me not to call someone an asshole if they're adamant about convicting her.
So we're back to hoping that Mark's, you know, request for nullification comes true. And it's equally as hard to convince other people to nullify, or they read it the way Kirk said, and they find themselves a loophole.
It's nullification, but it's also proper analysis in the sense that if they've acquitted her of manslaughter and are dickering around on a misdemeanor, and there's a possibility that if we don't agree on misdemeanor, we're going to enable them to retry an acquitted manslaughter, then I think you are morally compelled, if nullification is even the right word, to just say, let's pretend there's no misdemeanor, acquit, because it's a worse harm to have her retried for an acquitted homicide count. Again, they've already done it, and we're going down a path where they're going to retry her for another count for the second time.
Yeah, and Lily Shaw, and I think there's others still out there that are still confused and trying to struggle and understand with how, if they're only hung on the OUI but not guilty on the rest, wouldn't it just be for a new trial on the OUI? So confused. And that's what we've been discussing, is that on count 2, now just ignore count 1 and 3. Let's assume they're going to hopefully get information enough that tells them, hand me out the verdict sheets you're done with. And
We
then-
are I'm sorry. Go ahead. Finish. I'm sorry.
Right. And then they're stuck with count two. If they don't sign something, either not guilty on all or guilty on 5, it's hung on the entire count 2, and manslaughter can come back for 3. Go ahead, Mark.
We are heading down a path where if the jury were to come back and say, we have unanimous verdicts on 2 of the counts, 1 and 3, and the judge says, okay, fine, we'll take those and assume it's not guilty. Okay, they're done. We're done with 1 and 3. And they say, but we are hung on count 2, some component. You are going to see a situation where the lawyers are going to go apeshit and say, you have got to ask them, judge, which one have you reached on any of these, and she's going to say we're not allowed to do that, and we are going to have, and this time they're going to be much more aggressive than they were the first time, because they did get retried essentially for acquitted counts, and she's going to have to tell the jury, you need to go back in there and straighten this out. But the problem is, if you look at the slip, there's no way to do it.
There's
Right.
It doesn't allow hung jury on count 5 and acquittal on the other ones, the way she did it. This is such a self-created error by the judge, who had the benefit of the fiasco from the first trial, had warnings from the defense on the jury slips for this trial, and is doing the exact same thing again. This is insanity.
This went to the Supreme Court. This went to the Supreme Court. This is not this. There's no way this is anything other than deliberate on her part.
Which cannot do anything other than lead me back to the question: is she so fucking dense that she doesn't understand it, or is she just being deliberate about it? I mean, I don't know.
She
has
needs to
know, right?
have the ovaries to go outside of the standard jury instruction. It was like Kurt saying before, all right, she's just saying, I'm following the Massachusetts law by the book. I'm doing it by the book. And as long as I do that, I'm fine. She needs to have the ovaries to say, this is not a typical case. The jury is expressing some, confusion and doubt, and I'm going to do something different.
She needs to have a lobotomy, is what she needs.
You just raised a really fascinating point. Everybody knows, there are, pattern jury instructions, and you can just literally, here we are, and does anybody want to add this one? And, they are formulaic. And in most cookie cutter cases, they tend to work. This is not cookie cutter. And you're right. Most intellectual or heavy thinking judges are not afraid of crafting their own instructions, being careful. Certainly on, when you start going outside the box, there can be appellate issues, at least if the defendant's convicted anyway, not the other way. But she's not doing that. I mean, you raise a really good point. She's trying to stay in the pattern instructions. The law says this, and not willing to account for how unique a situation this is, and that I need to first and foremost prevent the possibility of a third trial on acquitted counts, which is on the verge of happening. And she needs to, like you said, have the stones, the ovaries, whatever it is, to do it. And she's just not doing it. And when the defense, even after she gives the slip, says, well, this makes more sense, she still won't do it. And you can't help but go back to why, in the first instance, all of the discussion that she's having about the jury slips occurs after the charge, after the case has been submitted to the jury, instead of before summations, which is when it should have been.
There cannot be a world
down the
in
road
which
from
she
me.
actually wants to sit on this thing a third time. Is it? Can
No.
that be
Oh,
possible?
she wants to sit on this thing as long as it takes to get
I
to a
agree with
You
conviction.
think so?
I agree with Ryan. Dude, she willfully fought for this second trial, dude. Like, she willfully fought for it. And I mean, and she was adamant about the start date, April 1st, April 1st, April 1st. Every bit of behavior coming from Bev is an indication that she wanted this second trial. For what reason, I have no idea. But everything indicates that she was
Trying it out.
for the second trial.
Do you think she wants to sit on a third trial?
Yes.
No,
Yeah.
no.
Yeah.
I can't imagine.
I wouldn't.
think-
I'd tap out. I'll tell you what.
I don't know why,
Yeah.
but I think she does. I couldn't tell you why, but I think
The
she
thing
does.
is, if she taps out, does the Commonwealth proceed with a third trial, knowing that they won't have that judge? 'Cause
Okay,
we
wait.
saw some of the other judges in the same area that seemed much more reasonable.
Well,
I've got a question. I've got a question. Okay, so God forbid, say the unthinkable happens. When is the election? When is Morrissey up? When does that happen?
26.
Oh, fuck. Because, I mean, is there a world that exists where he gets bumped and it's on a trial path? A new
this
guy
could be
comes
an
in and
election
the new
issue.
guy says, I'm dumping this thing.
Even if the election
I
were
hope.
to follow a potential third trial, there's a campaign and he's actually being challenged. And the mere fact that you are pursuing a third case is an issue for numerous reasons that involve an elected DA as opposed to an ADA who
Yeah.
just goes and tries cases. You manage a budget, you manage an organization, and you have to allocate resources to this. And if you do that with limited dollars, you're not doing that to do this. And there's going to be criticism about why are you paying Brennan when you have an office that's capable of doing this? Why are you hiring all these experts? Why are we doing this a third time? My tax money. Why aren't you investing it in public safety over here instead of, going after the great white whale like Captain Ahab with, Moby Dick, and you're just trying to harpoon Karen Reed endlessly and you're never going to get her. I mean, I think, electorally, he's going to get hurt. He's just going to get hurt. So there's a lot of variables which may not allow this to happen. I don't think she wants it to happen a third time. I think it's more about, this is my court. This is how I do it. This is how I've always done it. And you know what? I'm from here. You're not. You're in my courtroom. And if you don't like it, tough shit. And if very well step away if there's a third trial. I would expect the defense to make a motion to toss her off if there's a third trial, whether she grants it or not. But I don't think she wants a third trial. I think she wants to say, I'm in charge.
When there's
I
such
agree.
an easy out,
I know, but
we
hey,
all- there's so-
Rosary Card's point is right. I just checked because we stopped reading the new slip. On count 5, it does say stop. If you find her guilty of this, stop, but it does not say and sign the verdict slip on count 5 of OUI.
Nice.
Wow.
It's missing that stuff. But yeah. I don't know how they keep making little mistakes like this. On to your point, Mark, something
I
that's
don't think they're mistakes. I don't think they're
Because they're
mistakes.
doing it on the fly. They're doing it. You heard yesterday where the judge says to the clerk or secretary or somebody, okay, I need someone's computer so we can quickly change it. Do this shit before the summations.
The language she put under 5 is if you find the defendant guilty of operating a motor vehicle under the influence of liquor, stop, period. If you find the defendant not guilty on this offense and all other offenses, check the first box on page 1. That's her language.
each other one says stop and sign the jury slip. But
Like, just to be clear to the chat, the overarching theme here, the overarching problem is the fact that if they have no way to indicate to this judge the way that this is currently situated, this slip, what they're hung on. And if she is of the mindset that she's not going to, and we have to assume that she's not going to ask again in terms of which one you're hung on out of all the different choices, because and therein lies the problem. Because even if it is enunciated somewhere on this form, does that cure the problem necessarily? Because they're still coming back. Like, they're never going to be able to carve this OUI out independently. You know what I mean? It's like not knowing what it is, because the result is the same either way, even if they know or if they don't know. Because she's not going to do anything if she finds out, oh, well, okay, they're hung on the OUI. I'm gonna dump the rest of the manslaughter charge, and I'm not going to allow. Like, I have no faith that she's going to do the right thing. if she were to find out that there were
There's no
hung on the
reason.
standalone.
There's no reason to give her any grace and benefit of the doubt that she's going to do the right thing at this point. You know what I'm saying? Like, it's fair and it's reasonable. It's actually naive. I would say that it's naive to not assume that Judge Bev is got an agenda. I mean, it's just it's just all of her behavior leading up to this. I can't.
See,
I couldn't tell you what the agenda is, but there's one there.
I just can't get there. I just think it's like you see these judges when you practice and you do it for a long time. You get these judges that have that fiefdom kind of fucking mentality.
That's a lot of
This is my
judges.
house,
That's a lot of
my
judges.
fucking rules. I don't give a shit what you say. This
I
is
think
the way
there's
it
a
goes down.
coordinated effort. There is a coordinated effort to get Karen Reed convicted of something. Now, Occam's razor to the layman would dictate that if you have to go back to one of the defense's motions to dismiss way before, I think even before the first trial, where they're basically saying Michael Morrissey is under federal investigation and he needs this win. So this is the motive. He just wants the win. So a lot of us are thinking that there's the stop to this federal investigation, but if Karen Reed is exonerated, there's all this stuff now on record. There's all of these lies. There's all of this stuff that maybe the feds might have a case after she's acquitted. And maybe this is why they're pushing so hard for a conviction.
See, but here's the thing about the feds. They're in the business of winning. Like if you look at their conviction rate, they're in the 98s. They don't fuck around. It's a completely different beast than state courts and state prosecutors. They because there was that thing like the concept that the FBI investigation was closed doesn't mean that they didn't find plenty of circumstantial evidence. What it most likely means is they just didn't find enough.
They didn't feel confident for a conviction, right?
Yep.
They're not in the business of losing, and that's
I
why
agree.
cases bleed out.
What if after this trial, because we're finding new things out in this trial too, right? We didn't know that the feds questioned Dever, and she said that Higgins was in the Sally Port for a weirdly long time. We didn't know any of that, until she testified. So, what if after this trial there is enough evidence to start handing out indictments? I mean, I'm not saying that there is. I don't know, but I'm just speculating as to what the motive here is for this what seemingly a coordinated effort to get Karen Reed convicted. It's bizarre.
The other question that just sort of runs in my head in terms of a tactical thing is, let's say they come back and they're like, we're acquitting on everything except the OUI. Do you then turn around and appeal the OUI?
Well, we had this discussion in terms of, because what we were talking about, Ian, was the concept of a trial tax here and where she would land in terms of potential sentencing, and both Kurt and Kurt thankfully brought up some law and brought up the concept of, in terms of mitigation and aggravation, what she's allowed to bring in under Massachusetts law, and it appears they're not going to be able to get into acquitted charges, that she can't consider that as a factor. And but I was of the mindset, like, look, the typical appeals can take anywhere from 12 to 18 months. That gives her enough room to where Karen's going to do the time anyway. Like, is she going to give a shit about her having, her sentence overturned if Karen's done the time anyway? You know what I mean? It's like, I don't know how that would play in her head at all.
Don't forget she's getting sued for alcohol-related things. And again, I don't know what they think they are going to do or whether there's any merit to it. But, in the event they think that they have a valid 1983 claim against anyone and everyone, I think the answer is they would try to clean up her as much as humanly possible. They would. Yeah,
I mean, I don't know. All right, so some people say that they're in court. I don't know if they're taking the lunch break. That's typically when they come back in. Does
I
anybody
feel
see
like,
it?
yeah,
I don't
I
think
feel like you
those
want to
are-
do it just for the civil suits too.
absolutely.
It's like, you know, all of the immunities that kick in if she's convicted of anything.
Yeah.
You want to,
I'm
then-
not 100% sure on that. I was talking with another lawyer yesterday. Like, if she's only found guilty on that DUI charge, does that necessarily preclude her from being able to sue for like 1983 violations? I'm not sure it has a completely preclusive effect, so I'm qualifying that. There might be some stuff there. I'm not sure.
It may not be preclusive or not, but I mean, she's a less impressive plaintiff if she
yeah.
was involved in the incident and convicted of being wasted when all this was happening. I mean,
Fair.
I think if she's going to bring 1983 actions, you need to be clean as a whistle.
It helps a lot, yeah.
So
And-
Daniels is saying they're taking a lot. Like this concept of them like not deliberating while they're cramming a ham sandwich down their throat is bizarre to me.
How good are these lunches? That's what I want to know. How are they being catered? Is it Emerald Lagasse? What are we doing over here?
I mean, I don't know.
If they're
a little
not
bit of the
deliberate,
fentanyl is going missing from evidence every time they serve lunch.
I happen to know that the defense eats sandwiches just about every day.
Yeah, we're talking about the
So
jurors.
I don't know what the jurors are
Yeah.
doing, but man,
Yeah.
like it is absolutely absurd that they can't deliberate over lunch, that they can't eat while they deliberate. That's ridiculous.
Are they actually not allowed to? If they're all in the room together? I don't know if they would be. They
It's
could.
insane. It's insane. Like, I mean, like typically when we get a lunch or dinner, it's brought into the deliberation room and they chow down in there, and I'm assuming they're still deliberating while they're eating. Like, I mean, people are capable of multitasking at
Can
that
you,
level.
can you
Yeah,
trade? Can you trade food stuff for verdicts? You know, you rule with me, I give you my chips. Does that work?
Multi-million-dollar deals are made over dinner. You
I
True,
was gonna
true
say, you know
facts.
how many cases I've resolved by like, hey, prosecutor, like let's go and grab a snack after we're both out of court and let's talk through some files. You know, find a place where you can talk where there's, you know, where nobody's gonna hear you, or like go to somebody's office and order food in.
They did it.
And-
They did it in Iron Eagle, dude. Like,
I mean, the thing is
The
people
movie?
tend to be more lethal and more able to discuss things when you're having, you know, I mean,
How did Iron Eagle get into this discussion?
as soon as I
I know
said that,
it's-
I was like, "Oh, this is going to be a curveball."
I know it's not allowed, but I mean, if it was up to me and I was able to like run things notwithstanding the law or whatever, I'd just be like, all right, every one of you is getting one beer. We're not going to give you 6 because, you know, then we might get into problems, but just one for everybody. And it's not, you know,
just to wet the whistle.
yeah, it's never going to actually happen, but we might get more productive juror discussions that way.
Yeah, I mean, it's like I think there was a thought process because I was in the mindset. I thought that we were going to get a verdict yesterday after lunch. You know, like all lawyers like to think that they want that last free lunch because people love free lunch for various reasons. And you know, as we're slipping here into like mid-afternoon Wednesday or early afternoon Wednesday, man, I just I don't know, man.
I have
I try to
news.
keep a positive spin on shit for the chat because people get hysterical and you know, anxiety ridden and all that shit. But man, it's like it's getting to the point where, you know, I mean, we got some pretty bright minds in here, and it's like it's kind of that thing where it boils down to you just have no idea what a juror, you know, what a jury is going to do. You just don't know.
I have a mood lightener if anybody's interested.
Oh God,
Got
yes.
some breaking news.
Yeah, let's hear it.
John DePepe hit somebody's car at the Registry of Deeds parking lot and smashed their taillight.
Like,
Hey.
just
One
now?
of my mods just texted. Yeah, and supposedly this just happened. One of my mods just texted me and told me.
Oh, I hope they're getting on that to like put a breathalyzer in his mouth and just see where that's at.
I hope he was intoxicated.
I expect tweets from Aiden any minute. I
I mean, I could pull up Ian's fight with a anti Karen Reed guy yesterday.
Oh,
Pretty good. I was so close to throwing that, like, you know, I like to use like the llama eating popcorn, but you know, the Michael Jackson eating popcorn meme up there. because I was enjoying it. I wasn't gonna pipe in because Ian had it handled pretty
The thing
well.
is, I like to get into the discussions with people who disagree with me in the hopes that they can present me with something that challenges me, because I'm
100%.
not of the view that I'm always going to be right. And the problem I run into with like the anti-freak, those
Contingent. Yeah.
is that I can never actually get anything out of them. Like sometimes, if I want to go on and say like either, I post something to Twitter that's going to be super controversial, like, take a strong stand on like, abortion or the existence of God or whatever else. And I'm going to get somebody who's going to come in and they're going to have like 3 theology degrees and they're going to be like, well, have you considered this? And I'm going, and then I have to sit and think about it.
Right.
But on this, all I get is people who are just like, well, she's guilty. It's like, why do you think that? Well, you're a grifter. It's like, do you have any ability to actually articulate your point? Because if all you can do is just immediately go to insults, then it kind of suggests that you deep down know your point is garbage. Because if you thought your point was good, you'd want to hit me on, here's all the evidence I've got, let's just destroy you. It's when people start losing an argument that they go to insults.
Totally.
And these people are I'm losing the argument from the beginning of the discussion. And I'm just going, where is the person who has a good argument? Where, like,
I mean, look, we've watched the trial 2 times. There is no evidence. That's the entire point. I mean, when Hank Brennan has to resort to playing movie clips during and that becomes the heart of his case, it tells you everything that you need to know. When he searched high and low for a company that would be able to produce some kind of scientific evidence, and you come up with Blue Man Group,
Dude,
it tells you everything you need to know
that's
about
all you need to know.
here's the other thing, though. Let's say they have a new trial and Brennan is is on for the Commonwealth. Let's say I'm not Aperture or ARCA, but I'm some other organization like that.
You're not.
I'm going to be extremely reluctant to take it because I will see that Welcher got slaughtered saying there weren't any X-rays, and it makes him look like an idiot in a hugely public trial.
Devastating way, yeah. Devastating.
And so if I'm there, I'm sitting there and they're coming in with, we got $500,000, and I go, well, our brand is worth more than $500,000. So no thanks. We can't trust you to give us the information we need to look like idiots on this one. So nope, no thank you. You just got 2 experts from Aperture shredded. One of them will probably never work again.
Well, if there's a third trial, I can only hope that we do the comedic rule 3 thing. So we started with Trooper Paul, and then we elevated to Aperture. So what is the next step up to complete this 3-beat sequence?
I mean, I'm curious to see. Yeah, right. I'm curious to see what the ramifications of not just Welcher, but you can't forget Burgess, man. I mean, like the damage that was done to that company through this trial. I'm going to be curious to see what happens with them, because it's like there's just no walking away from that unscathed if you're Aperture, because if you're an attorney that's in the market for an expert, I mean, are you calling them?
I mean, Burgess, I don't think he can ever be called because he can be asked that question over and over, and he still doesn't have a damn degree.
But
He still doesn't have a degree.
Keep holding on to that dream, baby. Keep holding on.
When you're calling a company like Aperture, I mean, it's their vetting in terms of producing experts for you that you're relying on. Like, that's the entire point of these types of companies. They compile, they get these experts together. You're assuming that the reason that they exist is because they're vetting all these people for you, so that you don't have to do it. Because
They're not just finder companies, though, are they?
No,
I mean,
they're
there
a
are
company-
companies that just help you find experts. They actually are the company.
I basically
filled with a
watched.
bunch of consultants.
I basically watched the defense team, Karen Reed's defense team, vet Burgess. like
Yeah.
at the table, like right there. That's what it happened. Like Alan Jackson just reached over with a note to Alessi, and Alessi was like, "Were you aware that there is no such degree, that Alabama University does not offer such a degree?"
Yeah,
Like,
that's
it
good.
happened right there. You know what
Yeah.
I'm saying? That's what Karen is doing. She's sitting there on a computer, just searching their social media, searching their LinkedIn, searching everything, and
You
then
can- when you
boom.
were in the
Well-
courtroom, you could see all that as it's going on.
I mean,
And
I
the thing
couldn't
is-
see what she was doing. I couldn't see,
See the
the
screen,
table,
but you see her.
but I could see,
doing
yeah, you could see them doing stuff, discussing, whispering, and then I saw Alan Jackson hand Alessi a note on a yellow piece of paper while Burgess was on the stand, and then Alessi dropped that bomb, and it was awesome.
I mean, I'm sure that they did this beforehand, but the other thing is, I suspect that there was a bit of a surprise on this from Brennan, and part of that is that one of the reasons why you go to a company like Aperture is that you expect that Aperture is going to deliver a product, right? If you have McDonald's around the world, and sometimes when you're traveling, like you hit an airport and you're just like, I'm going to go to the McDonald's because I know it's not going to be good, but it's going to be a McDonald's burger, and I'm okay with that. You know, whereas like this other
Excellent
place,
analogy.
and so Aperture, what they should be is that if I've got nothing else, I can go to Aperture and they're going to serve me up an expert who is not going to be a disaster, because Aperture, the company, vets its own people. And Aperture has now very publicly had their brand shattered on that, because if I'm going to Aperture now, even if I'm not looking at Burgess, I'm looking at one of the other like dozens and dozens of people, I'm going to be like, how do I know this guy's
Right.
better vetted than Burgess was?
That's what I'm saying.
And the thing is, I'm sure that
It would be hard
most
not
of
to
the
be
experts
honest.
on Aperture's roster are beyond reproach. They're probably excellent, you know, scientists and whatever else. But I'm going, I don't know that I'm going to get the McDonald's burger when I go to Aperture anymore. And now I'm hiring somebody that I still have to do the vetting. Because, you know, if I hire an expert and it's just like some psychiatrist who works at a, works at a university and so forth, I still need to go and vet them. Like, I need
Yes.
to find their Twitter and be like, did they say something? Because
Right.
And
I
then
can
they
tell you I
turn
had
out to be a Wonder Bread pink dough green pepper burger. That's
Yeah.
what they turn out to be.
Eddie Murphy Raw style.
I had an expert I was proposing to call in one trial. I went and looked through their Twitter, and sure, it was like a year before, but they had said some startlingly racist things.
Wow.
And it was a case where, you know, the race could potentially be an issue. My client's a white guy. He got into a fight with a black guy, and I'm
Right,
going,
so that's bias.
there's no way in hell I'm hiring this guy as an expert. I don't want to have to do that. Like, you go to Aperture so that you don't have to do that, and now
And
you still do.
and so that you're not dealing with it in real time during the middle of the trial. Oh man.
Oh, absolutely. Like,
Brennan had to know some of it because he didn't ask the poignant questions you would always ask. He literally like just
he raced through that qualification of like, because normally that's the part where you linger when you call an expert. It's like, so let me let you tell the jury just how amazing you are.
you protect
You've got a
Right.
degree in
President,
this, right?
you
You've got a
work for
degree.
the Secret Service.
Yeah.
You've
And
got
how
high
long-
clearance.
How long did you take care of your sick grandmother?
Yeah.
Right.
Yeah, that's right.
Aye.
Yeah.
All right, so this is getting, I mean, I have to say it's getting scary. If I am the defense,
Yep.
I'm so this is what I wanted to ask you guys. We all seem to be of the, feel strongly that the defense obviously asked Karen Reed about adding the OUI standalone and that she was in agreement.
Yep.
But do we think that conversation included, by the way, the risk of putting this on if they're hung on it revives and puts back into life the possibility that all the charges on count 2 could be brought again?
I mean, that's exactly what they don't want to tell the jury. That's the issue.
No, I'm saying, do you think that they told Karen that was part of the conversation?
Oh, I'm 100% sure they had a full
Yeah,
discussion.
they had
Whatever.
to. For sure.
That team, like, I have
Yeah, there's
I've
no way.
never seen anything from that team that has given me any reason to doubt them, even when Judge Bev has grave concerns.
Right.
Like, what gives her grave concerns about the defense? I'm like, meh.
Right.
Whereas what gives her no concerns about the Commonwealth sometimes have been like, that was in front of the jury, folks. Like,
Right.
that was a big deal.
That was the biggest of deals.
Karen
I mean-
is running point on that defense team, so she's aware of literally everything that's happening.
Yeah, I don't see a universe in which she wasn't fully advised.
Yeah, I do. And beyond that, I think she was the final arbiter.
Yeah, but I'm just
think she
wondering
made
if
the
she
call.
fully understood that the worst case scenario that's about to happen.
Yeah, there's no way. There's no way that they
Yeah.
didn't they didn't go over that concept with her. You know, and I mean, like even a worst case scenario type situation, I think that probably the conversation would have taken place something in the nature of, look, we're going to try to get her to buff up these slips, especially too. You know, it's our hope, because like when they're going in with that conversation, the slip is what it was going in, and we knew that they weren't happy with it. And you know, we also know that they're acutely aware that she is very reticent to make any kind of changes wherein it makes it seem like she may have fucked up a little bit the first time. And you know, so they know all this, but you know, I mean, they had to go through the mental gymnastics, thinking like,
I
all
just
right,
think
worst
I
case
would have
scenario.
never thought that was a possibility. I would have never thought they could possibly really get hung on the OUI.
I mean, but like, this case is that case.
Yeah.
Like there's this part of me deep down that has always believed that this is a case that will be hung in perpetuity, because it's fucking impossible to know what happened to John O'Keefe. And there's always going to be people that just don't believe science for whatever reason. Like there are people.
I've been
in the
hung on
world-
a standalone OUI.
I get it. But I'm talking about the bigger picture in terms of exactly what Ian was talking about, the way and the method in which Hank went after the bringing the pathos of it with just trying to get into the emotional side of it, hoping to buy a juror or two in terms of selling them on that emotional aspect of it. I mean, we all know. I mean, like it's always a move for the prosecution. I mean, it's one of the things that they have a huge advantage of over us, and typically, especially in cases where you got a victim that's been injured and or killed, they're going to use that, even though they shouldn't, even though it has nothing to do with what's going on in that room. But they will always try to wring the emotion out of a case in terms of, you know, like victim petting or whatever you want to call it. And you know, I mean, he'd hear, like, it was the first things out of his mouth, you know, and you knew that was what he was going to do. So, you know, it's just like, if you look at just the general population, if you just look at Twitter, I mean, I think it mirrors what you're going to get almost every time with a jury. You're going to get like an 80-20 not guilty in terms of if you're able to try the case like this. If you have all the evidence that you need on the science side of it, I think that what we would see in this, if we were able to get information from the jurors, that it had flipped. If it was 8-3-9-4 the other way because of, you know, during the first trial, that during this trial, it'll have flipped on its head, where you might have one or two people that are hung up on some kind of concept of guilt, and where a vast majority are going to be. But, you know, I just like there are just certain cases that exist in this world that I don't think ever can be brought to verdict, you know, and I often wonder if this is that case.
Yeah, I mean, you know, at this point, the Commonwealth should really consider whether or not they really think that they can get to proof beyond a reasonable doubt with any jury, given this case. I mean,
Right.
Do you really think? I mean, how many times do you need to learn this lesson? I guess is a real problem from an ethics perspective, and also how much money you want to bring, and it's time. But you know, there have been cases where the government has brought the case against somebody multiple times. I'm trying to remember how many times it was in that case Flowers, which was at the Supreme Court a couple of years back, where it was like 7 times or something. The same case from Mississippi or Alabama. I want to say something like that. And then they finally gave up after like the 7th try. But it's like sometimes
6
it gets
trials for the same crime.
Yeah, something like that. Yeah.
And apparently it's the record.
Yeah. So
I mean, like that trial 4, which was the Sean Ellis case, which was a Massachusetts case. I mean, they brought it 4 times, you know, and that was a cop. That was a cop that was killed, you know, and it's like, it's just, but to your point, Kurt, like at some point, just the elected official has to realize that, look, we are like disproportionately allocating so much money to this case that you can't, but like, it's not an unlimited fund situation. They have a budget.
Right.
You have to save money to try other cases. Oh, well, you know, we had to spend another $500,000 on an expert on this. So sorry, we can't really pony up any money of any substance to get, you know, any expert that's worthy in this other trial. And, you know, sorry, family of that victim, we're just going to have to kind of, you know, go through the motions here and we'll do the best that we can. You know, I mean, like at some point that has to be going through somebody's head, right? And if it's not, that's where the voters, that's where the citizens have to come in and say, what the fuck are you doing? Like, enough is enough. We get it. We get it. You think that she killed John. Unfortunately, you can't prove it.
I mean, you have the right to petition the government. It's a First Amendment right. So if you were a citizen of this jurisdiction and you want to politely and respectfully write a letter to the prosecutor and tell them that you think that this is a waste of their time and that this is not a good use of justice. I'm not sure the prosecutor themselves becomes a witness, but whatever, right? Do they still believe in the First Amendment over there? I forgot.
No,
I forgot they don't really believe in that.
Mark knows exactly.
Never mind. Strike that. Reverse that.
No. I happen to know of another case where a prosecutor might be called as a witness.
You know what my mistake was there again? My mistake there was actually quoting law. That was my mistake again. I'm so sorry.
Pesky details.
Scheduled a year ago about the disqualification motion, which about the prosecutor, we still have to do that.
Yeah,
you talk about prosecutors testifying at certain cases, but that's for another day.
I think the entire, if they're in Norfolk, that whole prosecutor's office should have been disqualified based on the inverted video alone. The first time around, in my opinion. And now with this, all right, you had a special prosecutor and no inverted video, but, you know, false facts presented, x-rays that don't exist, existing holes in sweatshirts. They need it. It's.
I thought that was for sure. I happened to be in the courtroom for that too, when the jury saw the inverted video, and I saw the jury's reaction, and I was for sure. I was like, "There's no way that this jury is going to convict Karen Read." But then, lo and behold, you know, turns out 9 of them wanted to convict her, which is
with that fact pattern, with all the other problems. So not only did you have all the inherent problems with, you know, the vehicle hitting him and causing the injury or not, as the case may be, but you had all the problems relating to Higgins, Albert, Proctor, Paul. All that testimony was provided in laborious detail. You had much more discussion relating to the flipped videos. You had more discussion relating to ghostly presence on the videos. You had all those things in, and apparently that was distractions or distractors. Distractors. I apologize.
Right.
And that was distractors because don't you know, Karen Read was there, John O'Keefe was there, therefore Karen Read did it. That's how that works, apparently, I guess.
Yeah. I mean, that was always my concern with, and, you know, Lally did that pre-Buttle case where, you know, he tried to get in front of the defense in terms of their third-party culprit and, you know, Bowden shit. But ultimately, at the end of the day, my concern was always like, are you creating a de facto burden on yourself as the defense when you bring forth this conspiracy theory that you have that has some legs? I mean, it's got some smoke all over the place. However, does it have enough to carry the burden that you've created for yourself? And I just found it implausible that you're ever convincing 12 people of it. You know, so that was always my my thing. I'm like, just lean into the science completely, but there has to be the element that the proctor has to be there because the taillight ends up in the yard somehow. So you have to have the proctor, and it's like I know I asked Mark, I think I asked Ian, like, I mean, Kurt, do you think they dirtied Proctor up enough?
No, absolutely not. No, I don't think the reading of the messages with respect to Proctor was particularly effective at all. I mean, I was rewatching Proctor's testimony from the first trial, rewatching the cross yesterday on stream, and just reminding myself like how like laborious and effective it was. Here it was basically like a singular mention, and then it doesn't really resonate. Whereas when it was Proctor on the stand, because he was squirming and all the rest of it, you got to really spend some quality time in message land. So I don't think it was particularly effective. Same problem with Higgins, incidentally. Like as opposed to him being on the stand, when Higgins was reading the message with him being squirmy and evasive and being himself, and he was one reading the messages on the stand, right? That was one thing. In this case, you have Buchanan simply reading the messages, and it just doesn't have the same effect.
Right.
I mean, for my taste, and this is a taste issue, I didn't really like the way they handled Higgins in the closing. So, as long as we're critiquing, I didn't really like that aspect of the closing. You guys might have liked it more. I understand kind of why they have to do it technically, because, you want to give the jury another suspect, because like they shouldn't really care, because again, the standard is, does the state prove it? But like, we got to convict somebody is a real factor. So I understand that, but I didn't really like the way they handled it. And so I thought that aspect was a bit weak. That's why I thought about it.
I thought the way that I took that was I feel like the defense's goal was to basically create boogeymen out of Proctor and Higgins.
Yeah.
Leave a lot to the imagination for the jury, so that they look at them and go, "Oh man, that's really shady. I don't like that. Look at it." Like, if you don't put a lot of detail to and don't put a lot of context to the video footage of him at the Sallyport or him at the Canton police station, it leaves a lot to the imagination, and it looks nefarious. So if you're a juror just looking for something shady, you're going to come up with a lot. You know what I mean? And I feel like that was probably a strategy from the defense to try to achieve that. But that's just me.
I hope we get the murder. Yeah, sorry, go ahead.
To say that's the strategy and clearly what they wanted to do. The question, I mean, I come out on the other side of this. I got to punch the mouth and drag it out and walk him through. Nothing he's going to say. Him standing next to the taillight in the inverted video, which in fact is the right rear taillight, and saying, "I swear to God, pinky promise, I didn't do it, I didn't touch it," isn't going to convince anyone of anything. Him answering those text messages, like Kurt was saying, it's going to be brutal. And him saying, "I'm sorry and I'm a bad person," isn't going to make anybody feel sorry for him. You're a scumbag, and you're going to have to answer to this. They didn't even get out the corruption angle, the gift, all that. You didn't investigate this. You didn't investigate that. There's
Mark
nobody.
and I are more online because that's the argument in our house with Bob. I don't need it to be super third party, but I need this other shady shit. It even supports planting. The planting. It supports the planting.
I need him to say, "I did a fair investigation," which is what he would say.
Mm-hmm.
I had no tunnel vision, but then to tell me factually, when I went down and ordered a tow truck, I had never been to 34 Fairview. I had sent the text that said, "Don't worry, the homeowner is a Boston cop." I had spoke to Jennifer McCabe, and that's all I had done when I ordered a tow truck to take her car away. I need the jury to hear that from him.
From Proctor? I don't know. I might have given up on Proctor with the text getting in. The only other piece I would have wanted was buy the gift for my wife. But
here's the problem with Proctor, and it was, to me, in my estimation, the biggest kneecapping of the defense is when she barred Michael Easter from being able to testify, because like the tie-in with the boat. I mean, dude, Kurt's coolness factor goes up as the stream goes. It was like first it was the hat, now it's the shade. So it's
I was wondering why
it's almost
bottom
drinking
part of
time
me
and
was the bottom part of me feels on fire, and I couldn't figure out why, and now I see.
But I mean, like Easter getting bounced, like just kneecapped them so much, and you just cannot like overlook what Hank would have done with Proctor being able to cross him, which really had to have been the biggest part of that conversation as to whether or not they're going to call Proctor at all. Because I mean, Hank would have done what Hank does, and he would have ran that cross in a way that I think probably, you're never shining that turd completely, right? I mean, Proctor, a turd is a turd is a turd, and you're not going to be able to clean him up all the way. But Hank would have done some damage in terms of mitigating it, I think, to the point where they clearly thought better of it. I mean, because they're like,
Hank
what other
would've-
reason can you think that they didn't call Proctor when you've been kneecapped by not have, like, is it in my world, if you have Easter, fuck Proctor. I don't need Proctor. I'd love if I have Easter, I'm just having Easter on there talking all kinds of shit about all the shit that the guy that they didn't call didn't do.
I would have feeding him answers is the thing, and
That's what I'm saying.
I get the decision. I mean, the thing is Lally on this point was more ethical than but I just hate the situation they were put in. They're put in a situation where there isn't really a good answer,
right?
And they would have had. I agree with kind of both sides on this one, and I would have very much liked to see, I would have very much liked to see more dirt landing on Proctor, or at least, I don't know. I can see the like horror movie villain thing of like, you don't see them, you just see the damage they've done. But at the end of the day, it's better if they've got an actual villain to be like, F this guy. And Proctor really, he's ugly. Like he is, and I don't mean that in like a cosmetic way.
Are you sure?
In every detail about him. And to a certain extent, he's one of those witnesses I want to see try to explain things. The problem is he's not going to try to, things like, okay, so this tail light that you testified in a previous thing that you never got near. All right, well, isn't this you there near it? Tell us what you're doing here, right? Like, well, I'm not doing anything. Okay, so you denied that you were near the tail light. You just happened to be at the tail light, not doing anything. And you got fired for this, right?
I mean, you got a lot of the stuff with Higgins. Really, I felt like less got in about Higgins that was important than was missing.
Higgins, I wouldn't call again, because you're not going to get the very sad. Like Higgins comes off like a sad incel.
I just want to know.
He makes me look suave and like I have game.
I mean, Higgins, but the thing is, if you give him another trial, he's not going to get in. He's going to be more guarded. He's not going to get into that thing where he's like, you can see him like actively pining on the stand in the first trial. And it's like the moment in The Simpsons where you could go frame by frame to see Ralph Wiggum's heart break. He does exactly that on the stand as they run him through all of these things, and they challenge him with, don't you think she was ghosting you? And he's like, snap. You can see that happen to him. That's not going to happen a second time.
Not
right?
right.
The emotional
You're going to get
punch is gone.
You're going to get the Higgins version of Jen 2.0, McCabe 2.0. The blowout, and like she's just
still can't change that he hit his phone into 3 different pieces on a
I'm with Allie on this. I feel like I would have liked to have seen more emphasis on Higgins in the sense that, like, I mean, let's just talk about the simple in-your-face thing that is that video footage at the waterfall where he is literally the only person that actually showed any motive. Like, there's a lot of motive on Brian Higgins, way more motive that outweighs anything Karen Reed might have had. Like the motive that they're trying to theorized
Oh,
Kara Reed
I
had.
didn't even. I was like
is-
looking up.
Aw.
Have we seen this dog? Is this you only have one dog?
No, I have two. One of them doesn't come into my office. So this one,
Oh
Why
my
doesn't the note
God,
let
what
me
a
hold him like that?
lover. Oh my goodness. I'm like over here like watching him walk around getting a occasional butt rub. Oh, what a lover.
5-pound lap, right?
He's adorable. He's adorable. Yeah, I don't know, man. Like to me, I just
Well-
looked at Case, and it's like this concept that Canoni thought that because people watch CSI and all those other fucking shows, that they have a concept of what the import of a chain of custody is in evidence collection and why that. Man, I mean, you have Hank Brennan talking about a debris field in which I have no idea, as we sit here today, where they found any of that shit in that yard. I mean, am I missing something? Does there exist something that I've
We're
just
all
missed through?
we're all missing it.
trials?
The prosecution
Harry.
was missing it. They couldn't even. Brennan shot himself in the foot in his own closing, saying we don't even know when the impact took place. If you can't even point out where it happened, where the crime took place, why are we here? How can you theorize from a template that doesn't exist? Makes no sense.
Yeah, it's crazy. But it's like just the inability to be able to, because, you know, I was somewhat critical of the kind of like, I mean, Bowden, they didn't flex on Bowden because they really couldn't. She limited it to them essentially just establishing on cross that this was a fucked up investigation. And that's what they were left with. And, you know, I mean, they renewed their motion to get him in, which, and I thought that Hank opened the door. And we talked about this the other day. Ian's like, I think
Booted it down.
he kicked
Yeah.
it in, you know, but and you know, but that was like, because like if this thing comes back in the nightmare type scenario, I mean, these are the conversations we're going to be having, you know, like these are like if this comes back NGs across the board, well, you know, we're not having these conversations because whatever they did worked at the end of the day.
Right.
You know, it's like it's
All right,
just
so here's what I need to know. What do you, if this somehow gets to 4 Eastern time and they go home, are we still of the mindset that they're just still fighting over the OUI? I mean, what the hell is going on?
It depends. Are there any notes which could give guidance?
Right.
Which here we are, 1:30, almost no notes, unless something happened over lunch, which we'll learn about.
10 minutes.
And then you have the other wild card, which is they're off tomorrow. And what does that do in this whole process? A day off of literally just ignoring this. And then they come back for a Friday, and then there could be 2 more days off.
I wouldn't want to come back for Friday.
That's a hell of a lot to imagine is occurring over a misdemeanor after this was a murder trial. And unless they don't understand the consequences, but they haven't asked in over 24 hours. So it's getting bizarre. I'll grant you that. It is getting bizarre.
It's getting bizarre. I mean, that we just I just expect a note at this point.
Something,
You know, like anything.
some sign of life.
Yeah. Just let
Right.
us know you're still breathing.
And I
Right.
think, I mean, Mark's got a good point. They're about to be back from lunch, that maybe something happened over the lunch break or just before it, and we're going to hear something. But it's just to not have for this much time to go by, and where we all sort of thought that it was, you know, where things were on this, and for them to not send out the other 2 counts signed off, not guilty, without a question. Like those 2 things combined, I understand you've got I've just making them all the glarers back there that are dug in, but you'd think that all that digging in would prompt at least another question about, all right, now because I think the judge said she was going to put in the letter back to the jurors, this is theoretical, so I can't answer it. Now, if she didn't do that, she did exactly what the fuck Alan Jackson said. You just made them think you can't answer it. Why in the hell would they ever ask it again?
It looked like she
Right.
was. It looked like she
Yeah,
was writing additional
I was
things, so
just-
it looked like it.
Yeah, I mean, I it could just be that simple. that they're still just trying to figure out that that verdict form, and there's been changes made to it today. So maybe they're back to square one trying to figure it out. You know what
No,
I
I'm
mean?
convinced you've got the glares back there. I mean, got the jurors that are dug in, but what I don't get is how it hasn't prompted another question about
Because they're afraid to ask. You know?
Well, and the thing about this case, and I've heard Mark talk about it multiple times, and it's gospel, is that there's no way in hell that these jurors don't know anything about this case. It's different than every other case because this is a case where I am assuming, and I think correctly, that they have a lot of knowledge about this case. So the propensity that there are people in there that came in, dug in, I think is just higher than you're going to get in your normal type of trial. Like, I mean, I think that has to be taken into consideration as a very distinct possibility that you had people that came in, dug in, and what they saw at trial dug them in even more. And that's where we're at. You know what I mean? It's just like, and like, do any of us think that when these folks go home over the weekends and home every night, that they're not running into that? You would have to put yourself literally in a box. Like, avoid your TV, your spouse or your significant other's watching fucking TV in your house. They're on their phone or their iPad or their computer right next to you. It's like, and you live there, which you're getting geolocated, and they're popping all this Karen Reed shit up all the time. There's no way to avoid it. There is no way to avoid it.
It's all that people in Massachusetts talk about.
Yeah.
For over a year.
Yeah.
Yeah. I mean, that's what I'm saying. Man, like the more I talk about it, the more convinced I'm like that it's just gonna, like, they're hung. I mean, I've been worried. Like I said, I've been worrying about this thing getting hung again. Anyway,
Somebody just made an interesting point in the chat. I just happened to look over. I don't see it that often, but just reminded me of something I saw earlier. Come Thursday, Thursday they're off, but come Friday, the temperature is, and in New York too, it's going to be I mean, hot, humid, sweltering, and you factor in they're on day 5 or 6 by then. Getting
you
literally have you have all the 12 Angry Men elements just building up, man. Does that fan work? Would be.
Open the window. Open the window.
Yeah, exactly. The southern courtroom.
Yeah.
The southern courtroom look.
Yeah.
Is it true that on the night in question, like, that always happens? There's never an air conditioning in courtroom dramas that take place in the South. It's really weird.
It's true. It's true. I mean, I like you guys have been in there, Mark and Will. I mean, like to talk about the air conditioning and the fan. It seems like cooling is an issue in that building, particularly in that courtroom.
I was perfectly comfortable every single time I was in there. So, I mean, I don't know
the thing
if
is,
it was different or I just got lucky or what.
This actually ends up being a much bigger issue in courtrooms than people ever expect. Like, if I was doing a courtroom TV show, I'd have a day when, like, just nobody could hear anything when the AC is on. Here in Canada, we have courtrooms that alternate between way too hot or way too cold through like, the entire winter months, because either the heater is going bizarre or else or else it's not on, and you see everybody sitting there shivering. And sometimes the heat is set to the judge's preference, which, keep in mind, the judge is probably wearing a suit, and then on top of the suit, they're wearing the robes, and they're cooking. So they're like, well, let's turn the temperature way down. Then you see the witness on the stand going like,
yeah,
can we?
We get that a lot in ours too. I mean, especially in the summer, they'll have it where it's like bone chilling in there, like during, and I'm talking in the summer months when it's in the 90s, they crank the AC. And to your point, I mean, if you're uncomfortable in an environment, I mean, physically uncomfortable because it's either too hot or too cold, you know, I mean, that does affect things. I mean, it's like at this point, you can't discount anything in terms of what's going on back there and how they're feeling. And it's just, have any of you guys ever served on a jury?
No.
No.
We are not
Thank
allowed
God.
to serve on a jury here.
Interesting.
Like literally precluded.
We're allowed to, but for some reason I can't quite figure. No one's ever picked me.
Yeah, me either.
I mean, the thing is I would pick you, and then the prosecution would be like, "Nope, gone."
Yeah,
I am
exactly.
For sure.
a person. I'm telling you. I
Yeah.
almost got the jury when I was a prosecutor. I couldn't believe that. I'm like, really? Is this really going to happen? But it didn't.
I made the horrific mistake of picking a former prosecutor for Mark. I think I was talking to you about, or Ian, one of the two of you guys. It was like I was using a necessity defense in a DUI case, and it was novel enough to where I felt like I needed a lawyer back there to kind of explain the concept. And
Wrong lawyer.
wrong lawyer, man. She was like done like prosecuting, and I knew her because it was in like one of our main counties. And I'm like, you know what? I'm gonna take a fucking flyer on this. I talked to my client. I'm like, look, this woman's a former prosecutor, man. You know, and I'm gonna ultimately leave it up to you as to whether or not, like, I'm inclined because of the kind of just unusual use of the necessity defense here. And I explained it to him. I'm like, I think she could help explain it to the jury in a way that maybe we win this case. And he ultimately, and of course she turned out to be the foreperson, and of course she came back guilty, you know, but they did deliberate, I think, like 7 hours on this misdemeanor DUI. So, you know, it was a kind of a,
It took her that long to convince all the other 11 people.
Exactly. Yeah, exactly. Exactly.
At 17 hours on a misdemeanor DWI.
Yeah, it's exactly. So that was the one and only time I ever even contemplated having, like, I mean, defense attorneys, I'd choose them all day. You know, I'd be like, hey, these are objective people. We have to be objective. That's like literally in the job description. I'm like, prosecutors are very myopic. You know, they really develop tunnel vision on that person that are trying to convict, and you know, to the exclusion of everybody else. So, yeah, I don't know.
I almost got forcibly dragged back to the courthouse for a. It actually took the sheriff's like disobeyed a court order to not bring me back to the courthouse because so when we run out of a jury panel here, like when that's exhausted, what they'll do is they'll just send the sheriffs out to pick people up off the street. And it's like, congratulations, you are now a prospective juror.
Wow.
So
That's crazy.
That is insane.
my boss at the time was running a trial, and it was, you know, some obnoxious fraud thing that nobody wants to be a juror on anyway. But they exhausted the potential, you know, the potential pool of potential jurors, and the justice presiding was like, I want you to go out, and I don't want you to accept any excuses, any like argument for not being, you know, eligible needs to come to me. And so the sheriffs run into me and they're like, do we grab him? And I'm like, for what? And they're like, yeah, we're out of a jury, but it's your boss right
Dude,
now on
That's
the
when
fence. And
I
was like,
pee in the corner, like right on the street corner. I just whip it out and pee. That's when I do that.
but like I'm precluded because here lawyers cannot serve. And also because I have like a blatant and obvious conflict of interest. Like the defense lawyer literally signs my checks. You know, but according to the judge's direction, and for the justice to you know, to then say, well, yes. So they're like, we just didn't see you. And I'm like, that works for me.
Wow, that's crazy. That is absolutely nuts.
I've never even heard of anything like that happen.
Well,
it doesn't happen often, but you can get kidnapped off the street to be suddenly you're a juror.
Well,
That
that's
is
why I love.
unnerving.
Yeah,
It is unnerving.
yeah. The first time I was on with Ian. I'm like, like the whole concept of hearing how the Canadian system works is fascinating to me because there's a lot of differences, man. There's a lot of differences in terms of, and like, because we were getting into kind of suppression issues that, you know, that they'll bring up there and kind of just how they handle them, you know, is different than how we handle them down here at the end of the day. I just find it fascinating, but you know, I'm a law nerd, so it's like I just find that the differences to be just amazing to me. I think I don't know. I'm really getting worried.
Yeah. I want a verdict. Come on.
Does anyone
Come
know
on,
from the interwebs what time lunch actually was, and if it's up? Like, I'm dying to know if something happens like in the next 10 minutes from lunch.
I thought I saw that they were on lunch from 12:30 to 1:30.
Yeah,
So
that's
it should
right.
be any minute they should be back. Also, I think Andrea is about to join us before she goes
Excellent.
live on Coburger.
Oh, good. All right, here I gotta take Scout to her hitting lesson, so you're gonna have to play.
All right, make sure she texts Kenna because her friends are like confused. Now she had a hitting lesson the day we were supposed to be doing her party. Luckily, it rained.
Yeah, I was gonna cancel it, and then yeah. So all right, I'll see you guys in a minute.
I'm contacting a source. So
Look,
they're typing
Ian's got
back.
his animal too. All right, because it's getting, man, it's getting a little nerve wracking.
Getting a lot
I
nerve wracking.
contacted a source. I'm just waiting for a response, see if there's anything.
What a dog doing?
You made me want to go look for my dog, and then Ian's dog, I don't know, was doing something.
A dog or a moose? That thing sounded like.
I know. Who knows? Who knows? Hey, Ian, was that a dog or a moose?
Apologies. I thought that was I wanted to come say hi, but that was a very much I want to go out right now kind of dog moment.
Mark was wondering if it was a moose.
That's a big one. Sounds like a big one.
He's a big pup. He's a giant dog. It's funny because people see my dogs and they're like, oh, they're small, and then they see them next to me and they're like, what are your monster dogs? we like bigger dogs. It's just a thing. So
All right, the
For my
Claire-
source, there's nothing. They're just sitting around and waiting.
Yeah.
There's nothing.
So lunch, it should be up, and they should be back. I mean,
Send in that post lunch note, post lunch clarity.
the post-lunch clarity. I mean, I was actually doing tried to do a little research. I tried to find one case where the prosecution voluntarily withdrew or dismissed a charge after deliberations started, and I wasn't finding anything. So
Yeah, they say the clock was still running through lunch, so maybe they were still deliberating during lunch.
does anyone know is during lunch?
The
has,
clock isn't
14
official. The clock doesn't
Right.
know.
Yeah, I don't. Yeah, yeah. It kept stopping yesterday. I haven't really invested anything in this law and crime clock that's going and not going. And
Yeah, and Core TV and Long Crime have different clocks, so
45. We gotta have to run for a bit.
thanks for dropping
Thanks,
by.
Mark. We love you.
Talk
Bye.
to you later. Cheers.
Talk to you later. Oh, I hope
I
Andy
love
will let
that
me know if
PP
Andrea comes.
The PP supposedly left a note for the car that he hit on a
is that legal there?
written on a dry cleaning receipt, supposedly.
Yeah, if no one's there, you've got to leave a note. So he it was a light tap and it shattered his tail light or the other. Which?
As soon as I can get some blue grease paint, man, I'll be up there and reenact. that.
Now I just want to know. I want to look up Massachusetts law on collisions that are unattended, because sometimes, some places you can leave a note, some places you have to contact police and attend and all of those and wait for their attendance. So
It feels like something you would go to a trooper and say, "Hey,
you're that close.
because they're all over the place. The troopers
Right.
all over the place. So
As
why
long
not?
as he
just-
left a note with his license plate and his name and his phone number. That I think that's all right. But hey, I'm gonna let Runkle do the research because I don't know shit about Massachusetts. But I know, like, I tapped a door with my door in a parking lot before, and I just left a note. And
Well,
then
apparently in Massachusetts, you could frame a woman for murder. So
not have to leave a note.
you
No,
don't
no.
leave a note.
I mean, Lord, it's scary. It's really scary. I have to think like that the glares initial your like initial feelings that some jurors, the more they are trying to feel cornered by the way they think this looks, like you're making me say guilty when I don't want to because of this, that they're digging in more.
That
And
makes
then-
the most sense. Is if we're speculating and using our imaginations as to what's going on in that deliberation room, that tracks the most. I mean, that you just got people who are like, no, we'll sit here as long as it takes until each person is hitting not guilty. And
What do we think?
where do we write it on the verdict form? Well, draw a square and
Yeah.
check it.
You could try that. You could try that.
The question becomes at the end of the day, does that actually change the law at the end of the day? And legally, is it still on the table no matter what they say because they didn't reach a decision?
I don't know what would happen legally if the jury actually wrote in like not guilty on each of the sub things and tried to return that. I'm not sure what the answer is at that point.
I would love that. It would be like my birthday.
Bob said that yesterday. He's like, just handwrite it in, not guilty. And I was like, maybe they just mind through them. X.
That would mean the world to me if Bev came back and was just like,
So I've got a note from the jury, and apparently they thought it was okay to just draw a square and check it and write not guilty. Unfortunately, that's not allowed. I'm not going to allow that.
and then
They
she would
also
just
drew a picture of Mr. Brennan with an extremely small.
oh my god.
I
Oh my
mean,
God.
do you think that there's any discussions in the, is it district attorneys there, state's attorneys? I forget what it is in Massachusetts. Are they district attorneys, state's
Whatever.
attorneys? Anyone know?
ADAs, I think.
Assistant district attorneys. Okay.
Yeah.
So if the district,
But no, they're special prosecutors in this case, in Turtle's case, because apparently no ADA will take the job.
well, but they do have some ADAs sitting at the table. So, I mean, do we think the district attorney is like there's discussions going on? I don't know.
So I'm wondering what information. I'm wondering what information DePietro left on, or Pedro, or whatever is left on the thing, because I mean, if he didn't leave enough information, then it could be a hit and run.
Right. So what did he need? His license plate, his phone number, and his name?
Looks like the required information, from what the best I can determine, name, residence address, and vehicle registration number.
All right.
He
well,
probably blamed Turtle Boy for it.
send
Yeah.
Wrote, Turtle Boy did it on the receipt left it on the car.
It's like,
send him a message, Will, and tell him my lawyers have advised me that you should. Tell him what to do.
He blocked me already.
Oh,
That's not happening.
All right. I don't know who this person is, so
He's an idiot.
Uh,
I mean, he's on court TV almost every night, trying to push this agenda trying to push this narrative that Karen's guilty, defending.
But
Hank
why
Brennan's-
though? That's the
Right.
thing. But why?
Right.
Sell me.
That's a great question.
and
Like,
I heard Ian saying that too. Look
Yeah.
at your theological debate.
Yeah, you know, going back to like this discussion from earlier, like that we're all like grifters. I don't know how well these people track us collectively, but we have disagreed about things and at different times, and sometimes we even disagree at the end. Sometimes we don't always agree about things because we're lawyers,
well,
and
you're lawyers.
sometimes yeah. So it's kind of like ask 3 lawyers, get 5 opinions. You know what I mean?
right.
So I'm like, if I really thought guilty, I tell you, it's got to be good for the clicks. So it's got to be good for some hate watching. Right?
well, and
So-
the other thing is, people don't really understand this, because when you've got every lawyer out there,
Yeah.
other than like the prosecutor's podcast, who, so far as I can tell, I don't know what's going on with their, yeah, but
I don't think they're a lawyer.
everyone out
If
there,
we're talking about the same Twitter account. If we're
No,
talking
they
about,
are the prosecutors
Okay.
podcast. They are both.
Oh, I think it's something else. I apologize. Go ahead, Ian. Sorry about that.
Everybody out there has basically come to the conclusion that she should be found not guilty. And
Yeah.
the thing is that, like, all right, so it's great to have like a piece of this pie, but wouldn't you be better off having the entire pie of the other side?
Exactly. Right.
Because I'm pretty sure that I could, and like they're like, oh, you're doing it for super chats. It's like, what? You guys don't have money either? Like, you don't think anybody's out there like playing for that? If you were taking the grifter approach, would be like, here's how she's getting convicted, she's guilty, like whatever else. And the thing is I started this trial, like I started on the
Yeah.
I got in, I was disinterested in this until I saw Yannetti's opening on the first trial, and then I went, this is going to be hilarious because it's going to be that they made a huge promise and they're going to get clowned on this, right? And I said, like, there's no way they deliver on this. It's just impossible to me. And
the defense was acting a fool.
I basically said, like, this is too big of a promise, and I don't see it, right? I don't see that this is going to land. And like week 2, I was sitting there going,
Yeah, exactly right.
why is this not stupid yet? Like, why is this
sounding true?
Like, how is it that they bring in witness after witness and they start off with this witness is going to be the one that, that destroys this. And by the time cross-examination is done, I'm going, nope, the defense is still in the game here. I don't get it. And then by the time the defense's case is done, I'm like, I lean towards the defense, having the correct version of events. And I'm going, at the end of it, at the end of the prosecution's case, you should be sitting there feeling, pretty good. And the thing is, as a defense lawyer, most of the time, my arguments are prosecution closes their case. I've done the best I can at poking holes in it. And often I'm not calling any evidence because that's the most common number of witnesses the defense calls is 0. And then I just, well, isn't it possible this is what happened, right? Isn't it possible that this officer who says he saw my client, stealing the bottles of booze in the liquor store, isn't it possible he got the got the person wrong? He says he saw a guy in a blue jacket, and instead they find my guy in a white t-shirt shivering in 30 below weather, and they just find a blue jacket like along the running away like path, and you can see the footprints. But isn't it possible like that the footprints cross some other footprints and they might not have the right guy, and my guy just happened to have gone and bought exactly the same kind of liquor in 30 below weather in like a tank top? Like, isn't that possible? And the judge is like, nah. And like, the thing is that sometimes the judge, sometimes you got something better than that, right? Sometimes they find this guy, they conclude he's the guy because they find him in 30 below weather in a tank top, and they say he must have thrown away the jacket. But, if you take away that they found that they had footprints the whole way, like maybe maybe the chase went through an interior space. Maybe they don't find the booze, or the booze is discarded with a jacket. And it's like, all they've got is that this guy is in the area and in extremely poor weather. And we know that the person who stole the booze ditched their jacket. But this guy could be an entirely different guy who just happened to go outside in crappy weather. And then I'm much more likely to win. And they'll say, sure, we think he's probably the guy. We might even think we're really sure this is the guy, right? Like, but that doesn't actually get us to this, is proof beyond a reasonable doubt. That's the defense position usually, right? That is usually the
Actually, a guy with the same jacket but had one arm.
Right,
Mm.
was the one-armed man.
But to your case, there's so much other stuff.
Right, and to circle you back to the grifter thing, you get a much larger piece of the smaller pie by being like one of the only like real attorneys screaming, "It's so clear it's guilt. It's so clear it's guilt, and I'm going to show you why," and then just saying whatever the hell you want. And joining us now is not only my dog, but the brilliant Andrea Burkhart.
Hey, what's up?
Yay!
How you doing, folks?
Even if the pie was half the size, like half or even a quarter,
I'll be right back.
if you're getting that entire pie, you're doing way better. I don't
Yep.
understand the grifter argument. We're talking about how we're all supposedly grifters. and-
Who doesn't want the whole pie? Like, I'm sorry, it's pie, It's in its
Ax-
nature.
I am totally engaged in this John DePepe stuff. Like, people are sending me, like, I see that I have a picture of the note.
I've got a picture of the note right now, and it
Right.
does not look like it meets legal standards.
Ooh.
So it looks like we may have a hit and run scenario in like live,
I'm looking,
live right
I'm
now.
looking at a video. Somebody videoed him. They're saying that he supposedly tried to walk away until he saw that he was being videoed and then left the note. But he was just going to leave it.
But
I'm
the
looking
note-
at the video right now.
The note just says, "I backed into your taillight. Please contact me." And then he lists his email address. He lists his email address again because it looks like he wrote it very badly the first time. So he maybe thought that it was not clear. And then he puts and then he links his webpage.
Something tells me
He wrote a webpage link on a note.
flooded with a lot of emails, a lot of funny emails. Something tells me that might happen.
But apparently the standard, or at least what I'm finding on Massachusetts lawyers' pages, apparently the standard is you have to leave your name, your residential address, and your registration number. And failure to do that is a problem. So that's interesting. The other thing is vehicles right now vehicles are built very carefully to save your life if you're in the vehicle. They're not built to survive an accident.
Yeah.
And so they're all full of crumple zones. They're full of all of these things. And you can just get a light tap.
Thanks to Ralph Nader, by the way.
Well, I mean, the thing is it's good that you survive. But my wife got into what looked like a very light tap with a parked vehicle. And the other vehicle was fine because it was a trailer. It's not built to save anyone's life. It's just, it's built to survive. But it looked fine. And, I drove it into the mechanic and I took it in. I was like, "So what's it going to cost?" And the mechanic had a good look at it. He's like, "You can't drive this home." And I was like, "What do you mean?" He's like, "Yeah, you've got like some of these crumple zones have minimally crumpled and it's only like a couple of millimeters, but the car's done." I was like, "Well, shit." So we actually had to get that towed, and we took it to get a second opinion, and the second opinion was scrap it.
Wow.
Like, well, shit.
Yeah, I mean, I thought I had what was a fairly minor accident where I ran into one of those bollards, the poles that prevent you from doing that. I swiped one and hit like a quarter panel of my car, and I was like, "Oh, that doesn't look that bad." And the insurance company wound up paying out like almost $10,000. It was like more than the cost of my car. I was so surprised they didn't total it, but they actually paid it out. So
Yeah.
it's like weird.
Nice.
Crazy. I'm gonna
So
have a little poetic ending to the Karen Reed trial, guys. Before last year's trial, okay, like a month before last year's trial, I backed into my husband's truck. I broke my taillight. And so it's just been there. I haven't dealt with it. And the main reason is because, you know, it's like if I'm going to have to fix the taillight anyway, you know, you might as well like get cool taillights on the car, right? But then you got to pick them out, you know, you got to figure all that out. And so it just gets pushed.
Did you leave a note
down.
indicating who was responsible? Did you leave a note indicating who is responsible?
I did
with your
not, but
website?
Jeff knows no matter what, it's definitely his fault.
There you go.
Facts.
His car obviously wasn't supposed to be parked where it was.
Clearly.
But, so yeah, I finally picked out my taillights. I ordered taillights like they're supposed to get here. I get to upgrade my taillights. Very excited about that. It's gonna be a
Wow.
nice way to put a little cherry on top.
Like that's hopefully the actual close and not round 3 on count 2.
Oh God.
So Andrew, what do you think if the jurors send out an actual note that said,
Yes.
Your Honor, we had found her not guilty on count 2, 1 through 4, and we're hung on 5. What do we do?
Mm-hmm.
Would the Massachusetts law still be like, you're hung on count, you're hung on manslaughter. I don't care what you wrote on that piece of paper.
Oh yeah.
Holy.
Yeah, unless there is a formal verdict that's
Probably.
recorded. Unless there is a formal verdict that's recorded, and they made it very clear you're not allowed to do that. You can't record a formal verdict on the lesser included. You can only
That's
do
what
it
I'm
on
saying,
indictment by indictment.
Will's that juror back there. I mean, he's given us some wiggle room now, but who said I would stay dug in on not
I would wanna
guilty
hear
of the OUI.
I would
Yeah.
hear it.
I know. It's wild. It's a really crazy situation. But oh, you want a real rabbit hole? I spent some time going down the like what happens if you get an inconsistent verdict.
Ooh, what is the rule,
Like
Massachusetts?
lots of people wondering what happens if they go in and like write thing. Like what if they just write it out themselves, you know, or what if they just like modify the verdict form and get it to say something, and the freaking nightmare scenario that opens up when they do that, because basically now what happens is you've thrown it back into the court to just decide what it means. They
Right.
get to interpret
Ooh.
the verdict form
Nice.
and decide what they think the jury's intention was. So anything you think is a safety valve in this whole process, it's not. It leads more likely than not back to Bev, back to the court, but almost certainly to conviction or retrial, because guys, it's not that way by accident. If you have any question like how is a law going to apply in any particular given
Goes
situation,
to the
think about
judge.
what would make it easy to convict people,
Right.
and that's probably what the law is going to be.
Right.
There you go.
And I think if they sent out the question, like I asked, her answer would be, you must reach a unanimous verdict. Please continue, unless it's after the Allen charge. And then she say, if you can't reach a verdict, a unanimous verdict on one of the 5 options, then you have not reached a verdict.
Mhm.
So that's it. She's not going to tell them it means we can come back for manslaughter. She's never, I don't think she'd ever
No.
tell them that
I
even
don't think
if
she's going to tell them anything at all, really. I don't think she's going to tell them anything meaningful.
So there's a theoretical possibility that they send the juror form back with a drawing of Hank Brennan with a very small blue arm, and and she goes, "Well, this clearly indicates guilt on all counts." So
right, because it's up to her discretion to interpret what that means.
Yeah,
oh,
pretty
this
much.
is the worst.
Are you surprised that we haven't gotten a question at least, or the count 1 and count 3 signed off on?
Not necessarily. You know, I of course have my interpretation of what happened yesterday. Everybody has their interpretation of it. It seems very clear to me. Jury is not giving any serious consideration to a homicide charge. You know, we're dug in on OUI. It's the only thing that they're asking about. It's like the lowest priority, lowest importance thing on this verdict form. So seems pretty likely that more significant stuff is being taken off the table. So the question at this point is just, is anybody, are they going to be willing to throw the trial? Like they know that there are implications of hung jury. They don't necessarily know what that is, but they know there are implications from not being able to reach a verdict. And so the question is really going to be, are they going to just stick to their guns so significantly over small charge, relatively speaking. OUI, pretty insignificant charge, and potentially risk blowing it up in this nebulous, unspecified, mysterious way that they don't really know what that would be. So I think it's like a game of chicken. It's kind of how I envision it at this point. There's nothing really to gain from more questioning. They didn't really get help from the court. One of the things with jury questions is I think we just sort of we default, I think, assume, we take it at face value that the jury is asking a question because the jury has a sincere lack of understanding about an issue. But I do wonder sometimes if the questions are not necessarily that, but they're almost more of the political process that the jury is engaging in. It's not necessarily I need this information, it's I need something from the judge to be able to batter my opponents with, to get them to come over to my side. And so from that perspective, I think the answers that they got yesterday were extremely unhelpful.
Yeah,
really
willfully unhelpful is what it seems.
Yeah.
Do
They
you think
really don't make it clear, like how the jury is supposed to proceed at this point. What are they supposed to do to resolve this dilemma that they're in?
possible? Because Kurt threw out the possibility, or I don't know, Kurt said something and then the possibility was, I don't want to misquote you, so I'm just saying it was like something prompted by something Kurt said. Like maybe the jurors were just asking those, maybe they literally were theoretical questions, and they were just asking it because they were like starting to talk about, but you guys you do know that if we're hung, they can come back, because that's what happened last time. And some of them are like, that doesn't sound right. They're like, yeah, let's send it out and ask the jury. And maybe that is not what the hell is going on. Is it possible they're actually arguing over substantive charges, not just the OUI?
I'm blackpilled enough to think it's possible. That's
Yeah, you can't say it's not.
The black pill in me is real at this point. Ronnie destroyed me. I have lost hope.
It's
But
possible
if you wanna-
the jury is getting projected into space.
If you want to see something hilarious, there's a clip floating around of John DePetro's show where he says some of the freak-haired Reed people are saying I backed into a taillight and cracked it, and it finishes off with there was no collision.
No. Wow.
What?
Dude.
So
Okay.
you're spreading the rumor. Well,
I listen, dude. All I'm doing is me and Runks here are simply following a development here. That's all we're doing, is paying attention to developments in the John DePepe fiasco of taillight smashing.
It's gonna be hilarious if the only person who gets convicted out of this is John DePetro.
I'm gonna lose it.
so I talked about this yesterday, and we talked about it a little today. As far as the answer to the question about the 2 times for drinking, I'm like, look, in any other case, in every other case, I could go as far as saying the defense attorneys would be screaming and yelling that you can't do this. You don't have a unanimous verdict. You can't take some people saying she was driving under the influence at midnight and some people saying she was driving at 5, combine them together and get a guilty verdict. But here, the lawyers wanted to give the jurors any way to say convict on the OUI, take it however you want it. I don't care. And then Kurt made an amazing point that technically his point was that that Brennan was right because this is a lesser included, so it should follow the time from the main charge, the manslaughter charge.
No, I agree. I think that's a great point. And we talked about, like, it's just one of the odd features of this case is how we're 2.5 years in here now, and there's still things that you never thought of, and it just never even crossed my mind that we would have an argument being made that she's guilty of DUI at 5 a.m. It's got a unanimity problem is part of the issue with it, right? Because if you have some jurors who are like, well, I'm positive she wasn't driving drunk at 12:45, but absolutely was at 5. And then you have, you know, jurors that are like the other way around. You have no idea if they're just like, well, fuck it, she's guilty of something.
This
we'll just
says
convict
people
her.
are being summoned back to court.
Ooh.
Oh boy.
Or I'll stick.
Yeah, Joe.
Yeah.
Joe
And after
Flipperhead
and
just
after
texted me
ju-
and
and
told me.
after lunch notes and after the lunch verdict, we really enjoyed the lobster rolls, but we're ready to quit it.
Lobster rolls very good. Please send Karen home.
Texting Bob headed to court. I don't think
Well-
he's just dropping off. I think he might have had to stay because it's not that long.
That's gonna make it tricky to watch Koberger.
Speaking of which, what is
I knew this is how this day was gonna go. It was gonna be chaos.
speaking of which, since we've been talking about Karen Reed for a while, why don't you catch us up on the latest and greatest in Koberger land?
Oh God, well, Koberger, it's not even very exciting hearing today. It's just a motion to continue the trial, but it's kind of important because they're supposed to start jury selection on July the 30th, and then the trial itself on August the 11th. So if they're going to continue it, it's like kind of the 11th hour to be making those kinds of decisions. They're having a hearing too on alternative perpetrator. Third party stuff, but we don't get to see any of that. We're still in, every probably 4 out of 5 documents that get filed in the case are still coming up sealed. So we don't get to know any of the details yet. That's why the countdown to trial is so significant.
So this is all they still haven't decided if they're going to continue the trial.
Yeah.
And
Yeah, just the motion just got raised at the end of last month.
yeah,
I think.
remember.
It was last month. It was in May.
Also, the judge said they had like deadlines to turn over everything. Did all that stuff get turned over? The stuff about
Oh,
the
they've
leak?
done everything. Yeah, they've discovery deadlines, motions and limine have been ruled on. Jury instruction, like the
No, I mean
questionnaire,
about
like
the leak thing, that whole leak situation.
the leak thing. The judge signed orders that like directed both sides to have to preserve any communications, relating to the leak. And that's as far as we know, like the scope of what's happened. He said if anybody wants to ask for a special prosecutor to be appointed, I'd consider it.
What?
But there hasn't been an order or anything along those lines that we've seen.
They're trying to kick Santa off the case.
What's
No,
that?
They're trying to kick
To
Santa
read
off the
stuffer
case.
to get him off the case.
Okay, what? I couldn't hear. Sorry.
I was saying they're trying to kick Santa off the case.
And I was asking, was it
No.
just to read through the stuff, like a special prosecutor to act as the taint team or something?
Yeah, no, they're gonna have. They want a special prosecutor to come in and investigate. There was a leak to Dateline. Dateline did a big special. I don't know, a month and a half, maybe 2 months ago now, and had information that allegedly came from Brian Koberger's phone. Information about like his web searches and things like that. So caught the court's attention. Somebody would have to violate the gag order, for Dateline to have this information. So he's invited a special prosecutor. Invited them to ask for an appointment of a special prosecutor to investigate violating the
I
gag
wonder
order.
who it could have been.
Yeah, who could it possibly have been? Right? It's $1 million mystery. And then here's the fun thing. Like in the meantime, so Idaho is has been one of the few places in the country that doesn't have a reporter shield law. So if you happen to be like, I don't know, a Dateline producer or somebody, and you're in Boise, you can be compelled. You can be put on the stand. You can be compelled to give up your source. And, you can be jailed for contempt if you don't. However, Idaho just passed a law adopting a reporter shield over in the last session. It comes into effect on July the 1st.
Nice.
So count down, guys.
Wow.
Count down.
Wow.
So some reporters
They
just going to
could
be like,
actually feasibly find out who the source was. If they
Would
were
that apply
interested in tracking
retroactively?
down.
Shouldn't that not apply retroactively? Shouldn't that be for anything? No, I
Yeah,
guess
time that a subpoena is issued. I
it's-
would think.
oh, yeah.
So yeah,
Wow.
move on it or give it up.
would it be issued or does it have to be served at the right time?
Ooh.
Or I might
$1
say, you know
question.
what? Now is the time to take one of those vacations. They have vacations that put you on an island with no contact.
Mm.
And just be like, I'm going to take 3 weeks on this island. Good luck with process surfing.
I feel like your neighborhood people could hide in. Are you like way out in is that just in my head that you're out in the middle of nowhere?
No. I mean, somebody who I won't name yet managed to not serve me properly, but have somebody drop something on my porch. So I'm not that hard to serve.
Findable.
But
You're fine.
I mean, maybe one day I'll move off to the woods and just if I ever achieve my goal of being the pro bono lawyer, my follow up for what I'd love to do with that is move to a property on the woods and come out wearing like a suit that I've intentionally grown moss on and just show up as this figure nobody sees other than.
Do we want to do we want to share the feed of OnlyFans, seeing as we're waiting for them to come back?
I've got it up there. It's little for
I hate
now.
to just be such a quick hit and run, but I'm gonna have to dip because I'm like ready to get started in Coburger. With the court.
Hey,
I don't know
we're
what's
back.
gonna happen, but I'm gonna start my stream and we'll kind of play.
Oh,
by
never
ear
mind.
how it
It's just the
goes.
crowd outside. There's the crowd outside.
You're gonna talk. You're gonna talk
my
about
source-
Coburger.
My source just told me.
I
that
know.
there
I'm
might
actually
be a
going to talk
verdict.
about Coburger today.
Yeah.
Could be a verdict, people.
I've hit
Could
the
be a
verdict.
verdict.
It's 209. It's 209 on the East Coast. Let's do that 227, baby.
She almost did 27.
27
Oh,
verdict, baby.
27
Let's go.
verdict.
227 not
Andrea,
guilty verdict.
Thanks for coming.
Thanks for letting me jump in. I'll play it by ear. Maybe I'll pop back in, guys. We'll see.
It was really nice to meet you, Andrea.
Mess of a
I-
day. Yeah, you
Big
too.
fan.
Take care.
Thanks for swinging by. So I meant to highlight the one that said 227 and I hit the wrong eek. It
It's all
could
right.
be a note. I'm trying to find.
We have some 227 merch ready to go just in case.
Dude, it is packed out there. It is a sea of pink shirts in front of the Registry of Deeds right now.
So
it is-
what are you watching?
I've never
I'll
seen that many
stick it
people.
up.
Law and Crime.
Okay.
It is wild. Like I've never seen that many people out there.
All right. Let's see.
Lots of pink, not a lot of blue. I see. I don't think I
never
see
is.
any.
Yeah, dude, I'm just to the point where I feel perfectly comfortable saying that it's just beyond stupidity if you were saying that Karen Reed is guilty. You're a
I
bad
feel pretty
person.
comfortable at this
There's
point.
something
that
wrong with you.
Every time
Mandy,
I
how do
see
I
a
fix
blue
this
face,
back to there? We go. No. That's close enough. I'll make it bigger.
you don't want their stream though, because then they'll strike you.
No, they don't do
yeah.
that as much anymore.
Yeah, no, Law and Crime hasn't given. They struck me about 3 years ago or 4 years ago.
I got a ding from Associated Press UK saying that covering the closing arguments was their footage, and I'm like, MFs, no, it isn't.
Wow.
So I've got that dispute running, and I'm waiting for them to actually properly respond and be like, nah.
Yeah. I mean, that's
That's
That
a
is-
lot of pink.
Yeah.
I was gonna say I think I see blue, but I think that's actually a uniformed officer. He's like, I'm only wearing blue because I've got to today.
Right.
so
Pink-
where I thought they weren't allowed. So they're allowed to wear pink in the buffer zone.
Yeah. No signs, I think. And like, yeah,
No
because, yeah.
signs.
I see a sign though. What?
I do too. Maybe it doesn't say anything about Karen.
Yeah.
Or maybe the cops are just like, whatever.
At this point, we don't care anymore.
Right. Right.
Maybe it's the juror arguing for a split verdict, or somebody arguing for a split verdict with a sign saying 2 in the pink, 1.
Oh.
Ronks is on one today, man.
Well, I have to say, and I've got OnlyFan watching too, guys. As soon as OnlyFan moves, I'll take us off the sea of pink. But I feel pretty confident. I don't know. I was going to say that it could be a verdict. All right. So if it's a verdict, I feel pretty confident that it might be. Well, I guess I can't freaking say. I mean, I'm only worried about the OUI. I was just going to say that it's not guilty, but then I was like, no, maybe it's guilty. I don't know what you guys think.
Maybe it's guilty on the top count across the board. We'll all be really sad.
No, not happening. Don't scare the people.
I am just hoping that at the end of the day, DePetro gets more jail time than Karen Reed. That's that would be the like absolute cherry on everything.
I am 100% concurring with you, Runks, on that. Absolutely.
people are still saying that John DePetro ran. Oh, I remember who that guy is. That's that guy that Aiden was fighting with outside
Yes.
one day.
Yes.
Yeah.
I put right over Runkle's face.
It's okay. I'm used to it.
The reporter? Or
Yeah,
someone
I
else?
guess.
All right.
I mean, he says he's a reporter, but he keeps like getting into fights with Aiden and so forth. It's yeah.
It's so funny. It's so funny. Just like Aiden just trolls him.
Well, and then NBC reports, Turtle Boy gets into confrontation, and you see the confrontation.
was some
Turtle Boy
bullshit.
sitting there doing a live stream, and DePedro is like yelling at him, and like and Turtle
Doing-
Boy's just sitting there like,
Doing absolutely nothing.
I'm telling you, like the spin-off shows coming from Karen Reed
Mm.
are hilarious. So much fun. These characters, they're like fictional characters, but they're real. It's the most wildest thing. Look at Grant Smith Ellis. Can't believe it's a real guy.
I'd rather not.
I can't believe that's a real guy. Like I can't. It's so funny to me, and they all
That's Wendy Murphy's
much.
kid, right?
yeah.
He is
And
exactly what you'd expect somebody who's spent their entire life being educated on law
I
from
said
Wendy
the
Murphy to
same
be.
thing. I said the same thing. Like he is like as soon as I listened to Wendy Murphy on Court TV talking to Julie Grant, I was like, oh, that just explains Grant. I'm like, this guy gets a pass with me now. Like this is a perfect explanation.
So is there a counter color? Do the anti-free Karen Reed people wear blue, or is that a
Yes.
different?
Yeah.
Well, they do.
Yeah.
I
but
haven't seen any.
there
blue.
aren't any.
I saw a green shirt, but I mean, I haven't seen any blue. Is it possible that they like gave up when the jury questions came in, or they're like, you know what? It kind of doesn't seem like the car hit John O'Keefe. All right, so here comes I'll share this tab. Here comes Karen's mom. Here comes Karen.
20 hours. It's been 20 hours.
Well, here they come.
I really like that color that she has. What
Yeah,
color would you say that is? Like lilac?
baby
Or
blue.
baby,
I don't know.
yeah,
I'm the
something-
last one. I'm the last one to ask. I shouldn't even be talking. we
Mike,
need one-
Microdots is in chat and he's saying that this has to be it. Microdots is feeling anxious and predicting
bet.
it's the verdict.
Ooh, a little bit of anxiety.
Oh, Alan Jackson gave the.
The I love you.
I
Yeah.
think that's what it looked like. Yep.
Yeah, he was
Yeah.
asking
I
people
I
to
thought
stay
that was the
quiet.
negative.
I mean, this could be a verdict. So what? We should stick up a poll. Except I don't know how to do it. Somebody stick up a poll if we can do it. That would be either not guilty OUI, guilty OUI, or not a verdict but a question or a note.
I don't know how to do a poll on your channel, so
I'm
that's
telling
all you.
Mandy in the background that so they know. So because I think they know how to do it, except Mandy's not there. All right. Well, I'll just read out what you guys are all saying. What do you guys think? Not guilty on OUI, guilty on OUI, or not even a verdict?
I'm gonna say they're stuck on the verdict form. That's where I'm going. I think it's
Alright.
just a question. I don't think it's a verdict yet. I think the fact that there hasn't been any questions since yesterday just tells me that there's a question. Before I like that. It's just a guess. You guys would know better than I would.
I mean, we'd all know about the same, I think. And
I know what I
think-
hope, but
Yeah.
Right. I hope it's a verdict, obviously. If it's a verdict, then what is your guess? Guilty on OUI, not guilty on OUI.
my guess is guilty OUI, not guilty everything else. But that's my guess. I mean,
That's my best guess.
Yeah, me too.
My guess is hung on the OUI and not guilty. on
Don't
everything.
say that. That's not a verdict. That is called not a verdict.
I'm just saying this has been my position since yesterday morning, and I have no reason to believe otherwise at this point. It's just where I'm feeling it. I hope I'm wrong. Like I hope it's not guilty all the way down.
I hope it's a
But-
clean sweep for defense. That would be
Yeah.
and that would be just so delightful to watch. I want to see Brennan come out of the courtroom, and I want to see his interview. I want to
think
see
Brennan would
Lally.
hide.
And if Lally's interview, he should just be like, give him like a little shrug and a smirk,
Point
and
over there. I'm not with that guy, Arrow.
Dude, Lally in person is one of the most unimpressive people I've ever seen, dude. Like he's just not. Yeah, it's. When I see him, I almost feel sorry for him. He's just slumped, not confident, just defeated. Doesn't look like he wants to be there. You can just feel it when you're around him.
Turtle
it's
Boy on Twitter said the Reed team was told to come back by the clerk. When the jury has a question, they're told this. They were not told there was a jury question. That's what Turtle Boy said. Twitter Hollywood has.
Okay.
Typically, we're told there's a verdict, there's a question, one or the other. But if they have been told each time, jury's got a question, and this time they were just told to come back, that might be a verdict.
Either that, or we've decided to mess with the jury because we haven't done that in this trial yet. We want to kick someone off the jury because they're too pro Karen Reed. We haven't done that yet.
All right.
we're going to eliminate people who are pro acquittal until we get the verdict we want.
I am actually gonna jump off because there's somebody else's channel that wants me on over
Go
there.
for it. Go for it. We're
and
glad that we've had
You've got a cooler place. To be.
All right.
I wouldn't call it cooler, but I mean she's my homie and we've been kind of
Doing this together. It's all right.
collabing. Yeah. So and it feels like the right place to go. You know what I mean?
Fair.
All right.
But, man, this
I'm
was
just giving you grief,
amazing.
man.
I feel unworthy having been on this panel. You guys are brilliant and amazing, and this is probably easily one of my favorite panels I've ever been on. So thank you guys for having
Oh,
me.
well, thanks so
Seriously.
much for coming. We appreciate it.
And I'll be in touch for future stuff with all you guys. Actually,
Awesome.
if you guys are cool with that. But
Go ahead. Well, go hop on. Thank you.
All right.
Bye.
Love you guys.
Love you. Wow, I can't believe Bob's not here. Like, I just cannot believe that Bob's not here. He's like, he can get in on his cell phone from, like, if he's just like sitting. Oh, I thought I heard noise, but
You heard a dog. I should let the dogs in again because there's
there's a verdict likely, possibly. What are you doing?
But they should be in if there's a verdict. So I'll be right back.
Apparently, the news is reporting they believe there's a verdict. So that seems to be the scuttlebutt, as the Little Mermaid would say.
The question just becomes: did the not guilties on the? I'm just focusing on the OUIs. Did the guilties give way, or did the not guilties give way? Like, who gave in? And it might be 227. It's crazy.
Yeah, that'd be
If
pretty.
it somehow ends up to be 227, I don't even know what I would be thinking.
Yeah, no. Well, yeah, I have a shirt ready to go on the chance that it was a verdict announced at 227. I have
Could
the
you
merch
bet
ready.
$1 on that, on this whole betting thing? Is that a thing you could have picked the time?
I don't know, man. On the profit on that one, I don't know.
You could have won $1 million, $1 billion, picking the exact minute that a verdict comes in. Oh my goodness, this is crazy. Everybody's thinking it's a verdict. You got the use of different verbiage this time by the clerk. Somebody just put something in the chat that according to Sue O'Connell, a court officer walked by me with a medium-sized envelope with the back fastened closed. All right, people. Wait.
Yeah, that doesn't make sense.
That-
It like
right,
because
that
usually
could be the question.
yeah, usually the jury hands the verdict to the bailiff in open court when there's a verdict.
Right.
It, would,
so
it,
now,
it wouldn't be the verdict, presumably.
Right, now it's almost seeming like it could be a. Yeah, but they didn't. Do they usually put they might put them in envelopes? Yeah.
Yeah, there's usually an envelope for the verdict form,
All right. Well,
but it almost certainly wouldn't be in the position of a court officer.
the verdict
So,
wouldn't. Right.
No.
Right. That would be a question. Or the bailiff. She might be just calling the court officer. Oh Lord.
We're literally trying to tear leaf read what is in the envelope at this point. This is great.
This is great. 2:27 for those of you that don't know is the time of.
Here we
how
go.
long-
Something's happened. Let's do this. Thing's the volume on.
Yeah, let me make sure.
Yep. See, I'm glad I double checked.
Thank God.
All right. I appreciate you all getting back here. During the luncheon break, I received word from a court officer that the jury had knocked on the door, indicating that they had a verdict.
Oh,
Holy shit.
Before I could even summons everybody into court, shortly thereafter, they
minutes.
knocked again and said they didn't have a verdict.
oh my
So,
God.
I asked the court officer to tell them to put that verdict slip in an envelope and seal it, and to give it to us. Paul, do you have it?
Wait, so they do have a one verdict.
I don't know.
I haven't seen this. It's been sealed. I'm now going to seal it in the legal sense. So this is sealed. No one will have access to it. It will be preserved and made part of this record. I'm going to ask it to be marked for identification with the word jury, Chrissy, just to keep it separate and apart from everything else. So it's marked for ID with the word jury.
No, they need to ask. They need to find out, do they have a verdict on any counts? No. They've got, I feel like they have a fucking verdict on something. Oh my God. The 227 feeling of the first verdict.
So we do not have a verdict because, as we all know, there is no verdict until it is announced.
We
and
are all
recorded in
painfully
the
aware.
court. So we are still awaiting a verdict. Because it took a while to pull this together, I would ask that everybody remain in the building until the end of the day. So
Wow.
I'll see everybody later.
Wow.
Wait, what the fuck is happening?
They
Had a verdict and then they didn't have a verdict. And the first verdict that is not a verdict has been placed into a sealed envelope.
and
is
filed
sealed.
under seal.
Yeah. Yeah.
What does that mean?
All right, everybody. We'll just explain it to everyone again. So the jurors alerted the court staff they had a verdict. The jurors then alerted the court staff
Okay.
they did not have a verdict. The judge asked for whatever
What are you
sheet
doing, buddy?
that they used to come to a verdict and then change their mind on a verdict and put it under seal in a file that is also sealed, closed. And no one's looked at it. No one will look at it. It will be a part of the record should anyone need to look at it later.
Yeah. So my question is the jury, when they're back there, they only have one copy of the verdict form. So if they spoiled the copy that's currently in the envelope, at what point were they given a new copy and by whom, under what circumstances, and so forth? How did they have a verdict form now?
Did she just leave the bench? Is that what happened?
Yeah, she noped out. She's like, yeah, we noped out because
Okay.
Yeah.
I feel like that's all that's a very good question. She should have said on the record, counsel, I've provided them or I'm going to provide them. I'm about to provide them. I'm not going to have them come out and give it to them. I am going to have them come out and give it to them. What is happening?
What in the fuck, man? Oh my god! I don't.
What you-
I still don't understand it. So they knocked. They said we have a verdict. They then knock again and say, "Just kidding."
Right.
apparently,
But how did they get their hands on this envelope?
Well, then the judge asked them to take whatever sheet they used to come to a verdict and then uncome to a verdict, whatever they did when they came to a verdict, they took that one, even though they've changed their mind and it's not been accepted or any of that, it's in an envelope so that it's part of the record for later.
Well, for the second time in this trial, the text message has been deleted at 2:27.
Oh. Kurt?
What?
No.
No. What's your real name, Auntie Deb, or do I just call you Auntie Deb?
I'm Jimmy.
Jimmy, hi, I'm Allison.
Nice to meet you guys.
So what are you thinking?
I'm thinking that I was just getting a coffee and I heard rumblings of things going on. So I was like, shit, I gotta see this somewhere. Mandy sent me a link, so I'm like, let me just see what the fuck is going on here.
Yes.
And come to find out, another M. Night Shyamalanian twist in this goddamn fucking, oh, my blood pressure's not good.
That is an appropriate comparison because his movies are awful. So
yes. And she keeps trying to make this the Sixth Sense, and it's not. We can't see the dead people. We don't know what's going on, hon.
Right. I mean, I feel like it's time to that this should prompt a discussion between the lawyers and the judge about, do we follow up in some way with the jury? Do we ask them, have you reached a verdict on any of the counts? That's it. That's it. I mean, is that not appropriate at this point,
not.
Kurt?
Because they were
Oh, yeah.
trying to get to the truth, and they
I
don't
would
want
think
to-
so.
That's not what this is about. This isn't about the truth.
Yeah, I think it would be totally appropriate to maybe ask some clarifying questions or, see what's
Yes,
going on.
I
But
have
we're
some
not going to.
clarifying questions like what and the fuck.
Right. Oh my gosh. Oh my gosh. People are still asking for us to explain it. I mean,
how?
Yeah, well,
Right.
I mean, the legal explanation is that the jury is entitled to change their verdict, and any juror is entitled to change their verdict up to the moment it is read by the court. So usually,
even when they're polled, right?
and even when they're polled, because the question is usually some version of, was this and does this remain your verdict?
Right.
So like up to that moment, right, a juror can be like, oh no, I changed my mind. And sometimes juries are polled and they're like, no, we don't agree, or it has been known to happen. So from a legal
Also,
from a
there's
legal
like
posture, that's
hysterical
correct.
juror back there who felt like I caved, I gave in, and if that's
Yeah.
the case in my mind, it's someone who thinks she's guilty on an OUI and agreed to go guilty because she was pressured. That's what I think. I don't think the glarer of the jury and Jimmy, just so you know, Will, the glarer, had been with us, and he says he would have stayed dug in on not guilty, even on a DUI, even if it made it hung, even if he possibly, even if he understood the risk that could let them retry her on manslaughter. He was not going. It would be very hard to push him to feel forced to say, see, on the OUI. So with that juror in my mind, I feel like we could, and everybody, I'm speculating, that there's a juror back there who wanted guilty on an OUI, agreed because of pressure to say not guilty on an OUI, and then had like a, either a breakdown or a stood up and said, no, I can't do it, I'm not going to do it type of moment.
Could be.
What if you're writing this movie, Jimmy, what happened back there?
Oh God, what happened back there?
This is fictional.
They're all
Everybody.
trolling us. They're all trolling us.
Yeah, no, that's it. Yeah, they're definitely trolling us.
They're drinking. They're having a good. They're watching us, being like, let's see how much more we can make these fuckers freak out. Like they have you on screen. They're trolling us. This is Jury Duty season 2. This is what this is. we are the main character. And everyone
We are
else is
the main
actors.
characters. Ian, if you had to write the script of what really just happened, was it a juror pressure, change their mind? Just, we know it's fiction, we know it's speculation, go for it.
I suspect that a juror, like that they're at 11-1. A juror is like, okay, fine, I'll do it. And then when they, and then it's like, no, I'm not doing it. And
Right. But no guess which way that juror would have been going. Did they switch to a not guilty or did they switch to a guilty? On OUI, we're just assuming this is all in the OUI.
I don't know. I mean, for me, that's a coin toss.
And
honestly.
Kurt, chances this has nothing to do with just the OUI in your mind.
I mean, at this point, it's like wrong answers only is the only thing I'm thinking to myself. Like, what is going on in there? What's going on in there is one of the jurors wants to get in that last second Polymarket bet because they have the inside information. They want to make sure to get that bet registered so they can really cash out when they return the real verdict. That's what it is.
Oh Lord, we've been talking about that. Apparently, you can gamble on anything. We didn't know if you could gamble on the 127 deletion of the verdict, but I mean 227.
Speaking of which, Polymarket, for those of you who care, and by the way, once again, Polymarket is just a betting website. So these odds are just based on what people are willing to bet on. So that's how they're calculating that. To be found guilty of murder or the vehicular manslaughter DUI, 24% chance is what they're currently predicting. And those odds have gone up, incidentally, since earlier this morning. Yeah, it was down at 14%. So the probability of conviction, at least from them, has gone up to 24%. And
I bet they're basing that on time alone, in my estimation, but I have no idea.
And for
McCabe is back there betting all of it.
And for acquittal,
Guilty.
for acquittal across the board last night, it was 80%. Is now currently sitting at 51% to acquit across the board.
Wow, it went down that much.
That's a good feeling.
Yeah, which still leaves an implied 25% chance to hang or convict only on the DUI.
Right, if we're gonna trust so for that kind of betting, because I know nothing about what they do. Do they consult lawyers? Are lawyers actually following things in their update? Like,
who knows?
People bet.
Who knows? Same way people bet on anything. But prediction markets have, whether or not there's enough money in this prediction market for this to be true, I don't know. But prediction markets with sufficient capital in them have found to be pretty good tools. Like the prediction markets were more accurate with respect to, for example, the election than the mainstream media polling, just as to pick an example. So prediction markets can be a somewhat reliable indication. It's a whole like wisdom of crowds thing. Yeah.
Oh my God.
It's like if you ask enough people how many beans are in the jelly bar, their jar, their average will be really, really close to the right number. It's a thing.
Oh my goodness. Brass Tracks loves you, Auntie.
Love you, Brass Tracks.
Java Cat, I feel like I've been rickrolled.
Yes, very much so.
What is rickrolled?
We're no strangers to love. You know the rules. And so do I. Full commitment's what I'm thinking of. You wouldn't get this from any other guy. I was gonna tell you how I'm feeling.
Too early.
Wanna make you understand. Never wanna give you up. Never wanna let you down. Never wanna turn around and desert you. Say a lie. Never wanna say goodbye. Turn around. No, his name is Rick Ashley.
Oh.
And it was a YouTube prank.
Oh, it was a YouTube prank. See, I can get none of those references because I
know
like,
you don't. I've watched you before. You don't get a lot of references about things.
I don't do social media a lot. I don't like my friends would be like, "Have you seen the blah blah blah?" I'm like, "Oh, like it's their joy when they like get me for a night. They can like pull up YouTube or whatever and like show me things that everyone else has seen that I haven't seen."
Wait, I can do it better. 1 second. Never gonna give you up. Never gonna give you up.
In this stream.
Auto-tune. Oh my God. Oh, look at that. We got So Fucking Awesome, aka Rob. We now have a rehomed verdict to go with the dog. I got that by a friend of mine.
Yeah.
Started
poor
like
Chloe, poor Coda.
the Sofa King, and I use it all the time. Sofa King.
I have to hear that Coda's a transgender dog and ran away from Vermont to be its like true self. Because Brian Albert's not accepting. You know what I mean? So they're like, I can't be who I really want to be here. Like, saying I'm a monster, so they're like, I've already stopped.
You got
I'm not sure if
Kurt's
that's a voice
auto-tune.
changer or just a really awful connection.
Somehow Kurt's auto-tune voice changer went onto Jimmy's sound.
Let me fix my shit. Hold on.
It's like the press the Oh, I'll keep an eye for him when he comes back. And Bob's just sitting there silent.
We sometimes sing on my channel too. So if you like the singing, you can come hang with me. We do some singing.
Back from the thing.
Did you hear Did you hear Kurt and Jimmy's song? I tried to.
Yeah, it was amazing. I loved it. I thought it was phenomenal.
Your sound's no good either. You're out.
All right, later.
We'll see you soon. Now I need Mandy to make us look better. I hate when we're like the big cubes, but we can see, and Runkle's got the OnlyFan face.
I also had to answer the door because I ordered something for in the event of a verdict.
Oh no! He was ready to celebrate.
Possibly. Potter is also going completely crazy because there is some exceptional thunder going on here. And so when I let Potter in, he ran inside and danced on top of. I've got a laptop set up right there, and he was like, "I'm in a panic," and I'm like, "Oh god, dog." New verdict apparently.
I am appreciating some of the puns that Chad is coming up with. This verdict has now been rehomed.
Verdict.
Yes.
Brian
Now,
Higgins
we
is
don't have a verdict until we have a verdict in court.
Brian Higgins is no longer the only one with blue balls.
Verdict.
Wait, are you
Welcher
saying
already? Welcher probably
Verdict.
has them.
Have you heard something else, Mandy, or you're just saying that?
Verdict.
I can't.
Okay, we got you. Just stop.
I can't tell what she's doing.
I mean, people are saying that the verdict is in, but
again,
just yelling yes.
God, jurors still deliberating.
You can't be serious. Really? Seriously?
I mean,
We're
it's
doing
not
are we
surprising if
doing
they
this again?
had-
Are we doing this again? Seriously? Really?
I don't know.
If they do this to me twice, I am rage quitting. Oh no, the OnlyFan crashed. Oh no.
No.
Someone fix OnlyFan. Bring it back. Bring it back.
Back to Boston 10. It's coming. It's coming. It's coming.
Oh my goodness.
Yeah, Turtle Boys apparently tweeted that.
No one
So
can touch it until the jury comes back again.
Oh wait,
to
I don't
say
want this.
officially-
Turtle Boy tweeted it too?
apparently,
Oh Lord. All right. So now we have a real verdict. All right,
Uh-huh.
I'll put back on long crime because
I don't believe you.
she was like, it is too close to 227. Where one of the jurors is like, it's too close. We're gonna have to. All right, share. Do you guys see OnlyFan now?
Yes, thank you.
Okay.
Make sure that volume's on so we don't have that problem again.
Yeah.
Thank you. Have you seen Miss Mandy's shorts, by the way, where she does songs related to this trial? She's done some AI songs. She has a really great OnlyFans song on her channel.
So not the Mandy here, a different Miss Mandy.
Yeah. She's really she's got a great bopper of a song on her channel for OnlyFans.
Joe Flipperhead says that sealed envelope says NG. I guarantee
You
it.
better. I swear. What?
Something else will be turned in later. You watch. All right. I don't know. Oh, that's Mandy again. Mandy, you have no signal. You're like frozen again. She'll start screaming verdict. She's already.
Miss Shorty,
beyond.
not Miss Mandy. I said Miss Mandy. I apologize. Miss Shorty. Apologize.
Oh,
Wrong
Miss Shorty.
channel.
Oh, I've heard of Miss Shorty.
Yeah, she does. She has a great OnlyFans song. So sorry for wrong name.
No, it's So they said a verdict again.
Mm-hmm.
and I mean that might not be that surprising if they were 11-1, and then one person had had cold feet, and they bring them in, and then all 11 people yell at them again, and they're like, "All right, I'll do the thing."
Mandy, try to get Jimmy back.
Verdict means truth. What is the truth?
A false memory verdict at 227.
Mm-hmm.
Did they rehome to avoid the 227 not guilty? Oh Lord. 2 trials, 2 verdicts. Why not? I mean,
That's right.
right.
2 trials,
Lord.
2 trials, 1 verdict.
Rob,
Jurors have a false memory. I thought there was a
oh
verdict.
god,
I mean, maybe they did just mess up the sheet.
Until they actually poll the jury and all of them say yes, that's my verdict. I don't believe you.
Right. We're not. That's it. We're going through the whole polling before we accept this verdict. Chris says, did you read the story where Rick Ashley was rickrolled by a friend of his and was super confused. So rick rolling means you get rolled, like you get
It's just where
robbed.
it's just where you play that video. The fact that you don't know this is charming.
Okay. All right, I'm back to it. That's right. You guys said it was like a TikTok or whatever.
It's older than that. It's like a 10-year-old, if not older than that thing at this point. It's ancient by internet standards.
I'm pretty old, but yeah, I was like, I'm done. Not doing social media. I'm not watching people's stupid videos. I'm not. No. And I was often busy. Mickey says, there's never a damn dull moment. I'm still here in complete shock while also singing with you guys. Larisha emailed her dance party to Auntie Deb to Auntie Deb's song. We'll have to wait to see if he comes back. Sorry, never got his autograph. My nephew loves Auntie. Jimmy's probably like, your nephew loves me. Thanks. What's that movie with Pauly Shore as a juror? It feels like that.
Pretty sure it's called Jury Duty, is it not?
Oh yeah, that sounds right. Yep. At Defense Story Podcast, Sue just posted at 1:58. Court officers were looking for a clerk. At 2, word went out to bring the defense and prosecution back. All right.
She did ask him to stay in the building, so this should be right there.
Should be right there. This should not be, I hope Bob said gotcha after Bev reneged. A butt dial verdict to 227 insane. Yep, the deleted one. What next?
The verdict is a butt dial is a funny.
It is. Oh, my friend Cammie Brown. She was on here yesterday. She's in Boston. She says, I'm freaking out. I guess all of Massachusetts is. I mean, obviously, and all over, but you've got to know that they're more dug in since it is their tax dollars. Hard at work here. Hard at work. I mean, between the two trials, how much have taxpayers paid, do you think?
Well over $1 million.
Right.
Probably not at 2, but in that range.
Oh boy.
There might be some possibility of EDB. Can I share a link if I can get EDB on?
Yeah. That'd be amazing.
All right, let me do.
I don't think she does panels these days, but
No, she might for this because I think she's traveling.
traveling or
she's
something.
she's traveling, so she can't do her own.
Give it a try. Absolutely.
I can't even type. That's my friend who just texted me. That's who she watches with.
Oh, apparently she's gone live on her own channel.
Okay, well, never mind then. So much for that plan.
Yeah.
Oh well, it was worth a shot.
Right. It's they didn't leave the building. Aiden says verdict. She's re-looking at it.
Wow.
But now we've heard the verdict is back. The verdict is back.
That would have been cruel. It would have been super cruel if they had the verdict when I was at the.
I just realized I'm wearing blue, and now I feel like a jackass.
I mean, I am also wearing I don't have anything pink, so.
I mean, this was an issue this morning for both of us. Bob first had on a really baby pale pink shirt, and everyone's like, that's white, that's gray. He went through 2 button-ups before he found what really in real life looks more red than it is appearing pink. And this is sort of salmon-ish, but the only other pink thing I had was like a hot pink Express shirt from 1990. So this is actually my daughter's oversized t-shirt. Yep. Thanks, Melmo. We heard.
Somebody
Kurt was trying to get Emily. Kurt was trying to get Emily to come live with us because she's traveling. So our friend Cammy Babe text like she's dying, and I was like, I know she watches Emily. I'm like, oh, we're trying to see if Emily would come, and then it was like, never mind, Emily's live. This is taking a while.
I'm dying. I'm dying. What? I would be just my luck. That would be so apropos of life if I missed after covering the trial every single day to miss the verdict. Oh my
So
God.
do we know, is Aiden back in the courtroom?
Yeah, I'm emotionally eating and I'm starving.
Aiden is texting saying that Karen Reed is giving hugs to her team of interns and lawyers are hugging the parents. So
Wow.
seems like it.
Wow.
Alan Jackson apparently is pacing.
All right, so you guys, you all of us know what it feels like after you've been told they've reached a verdict as the attorney.
Oh, I thought you meant once we had a verdict, no verdict. I'm like, no, never been told that.
No, none of us know that. But like this kind of like this dead zone between after they told you there's a verdict and when you're kind of sitting there waiting with your client, waiting for the jury to come in, waiting for that, like that feeling.
I spend a lot of time talking to my client during that and telling them things like, okay, so I need you to like chill out because, I mean, especially for something like this, you probably don't want her going, yeah, in your face, like that, something like that. You just want her to, and I tell clients like, just nod respectfully, smile to whoever, but you don't need to, you don't need to like rub anyone's nose in it. Just, yeah.
See, I don't like law and crimes.
Jurors still deliberating.
Right.
after
No, we gotta
false
put up.
alarm verdict.
No, we got to put.
Are they? I don't know.
Who's the genius? Why aren't you going Boston 10? They've been our ride or dies.
All right, because I wanted the wait, is this Boston? No, that's law and crime. And this is Boston 10. Let me see. Boston 10. They don't have the OnlyFans up.
Oh, really?
Yeah, I don't know what they're doing.
No. I don't know. Shit in the bed. I did.
Did they hire on Amber Heard?
And they have verdict reached in Reed murder trial.
Yeah, Boston 10. That's what I'm looking at here, but
Oh.
it's outside the courthouse.
Other business, they were here.
I mean, should I share
Yeah,
that?
you don't want to play that because they'll hit you with a.
Yeah.
Okay, share this tab instead. We'll go back to OnlyFans. But I want to
God.
update our thing to say, allegedly,
Allegedly, the verdict is in.
second verdict seems might be in. All right, that's what we got. Second verdict might be in.
We've had
I-
first verdict, but what second verdict?
Yeah,
Yeah, I'm
exactly.
doing allegedly the second maybe verdict is in.
All right, so now I'm back to and Jimmy is back with us.
I'm at Starbucks. I'm hiding at Starbucks because I heard the verdict is in, and I need to be with people to watch this. I have to, so I kind of have to be quiet and a little bit appropriate because.
Yeah. We'll see
Get
if
us
you
ready for
we'll-
whatever our next layout will be when we make the screen big.
So what's going on? What's going on?
We
Now
think
there's
we
a
have a
real
verdict,
verdict.
maybe.
Maybe.
What do you mean? What the fuck is that? What do you mean?
Well, we already had one false verdict, so who knows? Did you miss that
Kurt,
from?
you don't-
Did you miss that from like 30 minutes ago?
No, I was in my car having a friggin' miscarriage.
He was here with us. He was here with us. So Aiden has said the verdict is in, right? Kurt, is that what he reported?
Anyone else shaking? Anyone else shaking?
Yeah, I was just telling everybody, like, what it feels like when you're a lawyer, kind of in this.
I just
period
lost you.
of
I just lost
time.
the audio. I just lost it.
You can't
Can
hear
you hear
us?
me?
You.
We can hear you.
I can't hear you.
We can hear you.
Shit, I can't hear you. Fuck. Hold on.
Okay, that's
That's awesome. Oh Lord, I can't hear you. Shit.
Awesome.
The audio wasn't very good anyway. So,
Oh Lord, I can't hear you. Shit.
and now
Oh,
I'm hearing feedback.
No,
Yeah,
that's me.
Bob.
That's me. I was copying the link.
I muted him. He's muted.
Excellent.
Oh Lord. Oh, they updated their thing. Oh, I think he's back. Hold on.
I don't believe it.
Can you hear us?
Oh, I can't
Jimmy?
hear you guys. Hold on.
He still can't hear us.
Audio. Microphone. Fuck.
All right. Live now. You
Okay.
don't
Is it working
hear
now?
us? Verse is
Yes.
in.
Maybe. Hello.
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 We can hear you. Can you hear us?
No. Okay,
We
great.
hear you.
We can hear you.
Let's not do this for Verdict Watch, please.
yeah.
He's muted himself. We've got him muted until he can hear us, and then he can unmute. He's just.
Oh man.
Oh Lord.
I'm good.
Yes.
Okay.
All right.
I'm in the corner. Okay.
Man.
I'm like,
You're coming in real hot too.
what's that? What's that? What does that mean?
Out.
What does that
He
mean?
had too much coffee.
Well, dude, it's a big fucking day. It's the biggest day of my life.
Oh man, this is a big day.
I gotta pee. I haven't peed in like 3 hours because I can't. I feel like if I pee, the world's gonna end.
Do not
Hell
take
yeah.
the stream into the bathroom, sir. There is we don't not need a stream on a stream. It's
Stream on a stream.
Dual streaming.
Bring a new meaning to dual streaming.
Oh man, this is a lot. This is
Yes,
a lot.
Yeah, I can't move. I'm standing in one spot. If it gets busy, they're fucked because I'm not moving.
This is a lot, man.
Ellie Starr says it's gummy time in Colorado. Insanity in the membrane anxiety.
I have a feeling for her, it's always gummy time.
Mm.
Mm.
God. It's
Bob,
wild.
you gotta. you're
Bob,
on
is
the
that
phone
you
again.
making noise again?
No, it's got to be Jimmy.
You can take me off.
No, I'll
Thank you.
just mute you. It was Jimmy.
So something came through at 1:53. Court guards just brought in a first aid kit and an AED to the side room.
It's
What?
because there's a couple of older parents. They're just being precautionary.
Wow.
All right, so right, people, just bear in mind that no one should know the verdict yet. So as Ian is saying, they are being precautionary.
And I'm sure that because they don't know the verdict here, they've got all of the security to get Karen Reed safely out of the building, regardless of where she's going. They're going to have, because I mean, they've got to be concerned that somebody out there, might do something stupid or whatever else. So, I suspect they're on all hands on deck on the security right now.
Yeah, I'm looking at on Boston 10. They've got a dual stream of OnlyFans and the outside. I can share this tab.
Yeah, share it with
now,
us. Listen.
You guys, do you think if she's found guilty on the OUI standalone that Bev would take her into custody?
No.
Yes, I do.
No.
Wow.
No.
I think she would.
No. No, not even she would stoop to that level.
That right. I'm like, dude, it's a misdemeanor. Like she's out on bond. I'm like,
That would
I don't
be
know.
outrageous to take.
That
her
would
in
be
on
unbelievable.
that would be
On a
unbelievable.
first offense DUI, give
How
me
many
a break.
unbelievable things have happened in the past 2 weeks?
this. Oh, look, people are really they're like,
Wow. This is a minute. This is a moment in time, man. Like, wow, this is crazy.
His presence is strong.
I mean, I could be wrong, but I don't really feel like if it were guilty, that there's really a strong chance of rioting. But
I mean,
I can't
there
imagine
is
this
a
crowd
possibility of
riot.
rioting. There's a possibility of somebody taking a shot at her. There's a possibility of all sorts of things.
I
You really
suppose.
think that someone would do that?
Yes.
Yeah.
Who knows? Yeah, I mean, can't put anything past anybody these days.
That's fair.
I mean, you've seen some of the crazies on.
Yeah,
on
I
this
mean,
one,
and
so-
it's like the fact of the matter is we live in a world gone mad. You know, I mean, this like we're in strange times indeed.
That is a pretty
Have
big
you,
crowd outside, man.
Yeah.
I mean, I've gotten death threats. So, I mean, they're hilarious death threats because they're like, you know, I'm in the States and I'm like, okay, cool. Y'all bring your guns across the border and
Good luck with that.
we'll just see who wins the quick draw competition on that one.
Oh man.
Also, if you could let me know when you'd be coming so I could load the flamethrower, it would be really appreciated.
I have to go get water, but I don't know if I can do it.
I mean, I want to get up and change my shirt, but I know the second I do that I'm going to miss the whole thing. That's my
All
problem.
right, maybe we
Right.
both should run because I'm going to go get a drink, Kurt.
Oh man, you're on the clock. 1,000, 2. It was ballsy. It was ballsy. It's how I felt when I was stuck in rural Elburn, Illinois, at the hitting lesson. Man, oh man, man. Man, oh man, oh man.
Yes, and for the people who
Told you.
still inclined
Told
to
you.
send me death threats, keep in mind I find most of them hilarious.
You missed not the perfect time. Allie, you better hurry up. She's on the bench.
Allie might also be on the bench right now, so
Oh my God. Oh my God. Oh my God.
Is the audio on the stream?
Oh my God. Is the audio?
Is the audio on?
Yep.
What's the? It is.
No, it's not.
Nope.
Okay, we can hear her now.
yeah, having it muted is like the ultimate.
What a nightmare that would be.
Mr. Foreman, on docket number 2282 CR 117001, murder in the second degree, what say you? Is the defendant at the bar guilty or not guilty? Not guilty. So say you, Mr. Foreman? So say you? No. Do you agree? Yes. Do all of you agree? Thank you. 002, what say you? Is the defendant at the bar not guilty or guilty? Not guilty. Is not guilty or guilty about that charge or any lesser included charge?
What?
Specifically, number 5, operating under the influence of liquor by operating a motor vehicle with
Guilty.
blood alcohol level of 0.08 or greater. Correct? Yes. So say you, Mr. Foreman? So say you all?
They made the right call on the
003, what say
OUI
you? The
inclusion.
defendant at the bar leaving the scene after accident resulting in death. Defendant not guilty or guilty?
There you go.
Mr. Foreman?
Oh, you hear outside.
Jurors, hearken your verdict as the court records it. You, upon your oath, say the defendant on 001 is not guilty, on 002 is guilty of operating in the influence of liquor, and 003 not guilty. Thank you.
Wow.
There you go.
Jurors, everybody
Wow.
please be seated.
The most expensive OUI of all time.
No doubt.
Time.
Send you back to
Um,
Mrs. Lee. I'd like to come back and talk to her a little bit afterwards. Thank you very much.
All right.
Wow.
Wow.
What a glorious day for Karen Reed.
Wow.
After all this, man.
Oh, look at the tears. Wow,
Holy
you
shit,
hear them
man.
outside.
Acquitted in the murder of her boyfriend, John O'Queef.
Queef? Who's that?
Switched.
I don't know.
It was Boston 10.
New boyfriend. Who dis?
I switched.
Holy shit.
regarding the
Holy
charges that you have been
shit.
found not guilty will be sealed by the Commissioner of Probation by the court unless you notify the Commissioner of Probation in writing within 10 days that you do not want these records sealed. To request that these records not be sealed, you may use the Request Not to Seal form, which is posted on the trial court's website on mass.gov. I cannot accept the form here in court. You must submit it to the Commissioner of Probation at the address provided on the form. Please be aware that if the records regarding the charges which you have been found not guilty are sealed, you will be unable to access the sealed record of the not guilty dispositions or any other records regarding those charges. If you want copies of any documents regarding those charges before the records are sealed, you should request copies from the court within 10 days. Do you understand? Thank you.
All right, so we need a date for sentencing. Can we do it next week?
It's not taking her in.
Well, she hasn't said. I hope she doesn't.
Okay.
Sidebar.
Sidebar. What the hell you need that for?
They might have a stipulated punishment. They might have
Right.
talked it out.
That's
They
possible.
might just say, "Hey, we've agreed that a $100 fine is appropriate if that's all she gets."
Mandy, stop.
Yeah, please,
Wait,
no.
I don't think they do that in the I've never, Kurt, have you ever had, after a verdict comes in, that the parties agreed to the sentence?
All right, so Ms. Giannetti, you ready to go forward today as well?
There you
Yeah,
go.
they're
Doing
ready to go.
doing immediate
What's the Commonwealth's
sentencing.
recommendation?
Immediate sentencing.
Moves to sentencing, we recommend a probation 1 year 24D program.
Yep, that's standard.
That
That's
everybody
standard.
else gets on their first time OUI.
Good for Brennan. I'm going to give him props for that.
So I'm happy to do it. All right, thank you all.
Oh my God.
Solid props
That's it.
to Brennan. And
Document
you know what? Good for the
002,
judge.
unless you include an offense of operating under the influence, 1 year probation.
Good for the judge.
The 24D program. Thank you.
Wow. Yeah. Props to
Goodbye.
Brennan.
Goodbye, indeed.
Wow.
Oh, gosh. That is so touching.
That's amazing. Holy shit. Wow.
You got your life back.
Suck it, pro Karen. Suck it, pro conviction people.
Yeah. Go fuck yourselves.
I mean,
Oh
the
my
right,
God.
the actual full right outcome. And I'm sure.
What did she get? 24 months or 12
No.
months?
No, it's a 24D
1
program.
year
It's a special
probation.
program.
Yeah, 24D
I
program.
don't know what that is, but whatever.
I'm going to give Brennan serious props for it.
Yeah.
Like 100% for.
You can unmute yourself, Jimmy. You're muted still.
Wow.
Well, we can't hear you though.
I'd love to see the crowd outside. Is there a feed that shows the crowd outside?
All right, let me see.
Yeah, they're going
Nope.
nuts.
Here we go.
I'm sure they are.
I'll keep
Wow. Yeah, we want to see it when she walks out. It's going to be pretty explosive.
I'm sure that Court TV will switch over to that at some point, but this is good for now, the dual stream. Wow, you could hear them cheering so loud in the courthouse. It was like a thunderstorm out there.
Apparently, according to Turtle Boy, the crowd was instructed not to react. Apparently, that didn't work.
There's Aiden. There's Aiden.
Yeah. Wow.
Yeah.
Wow.
Let's hear. I'll turn the sound on.
Allowed to leave. She is a free woman. She is
Can't hear it.
Wow.
All right. She's. I can't imagine the feeling for this family, for Karen Reed. And yes, it's so unfortunate for the O'Keefe family because many of them may very well think this is the person who committed the offense. But I feel like you sit through that trial and you have to understand how the jury came back the way they came back. And I wonder if secretly they do question it.
They should be mad. Like, even if they think that Karen Reed is 100% guilty, they should be mad at the police.
Yes.
And I know they're going to come out and they're going to make a statement against Karen Reed. They're going to make a statement against her defense team, all of those things. But they should be furious at the police because either the police allowed guilty parties to go away uncharged, or they did such a sloppy investigation that it was impossible to, determine And that's who they should be mad at. And
Are you guys hearing this? You're not.
I'm hearing it. It's amazing.
Yeah.
Team quite yet, and I do want to point out
When she walks out, it's going to be epic.
Bedlam.
Are you guys not hearing this?
I'm hearing it.
Hear it.
Yep.
My guess is they will be allowed to go out.
Just you're probably going to eat a strike if you're not careful about playing it. So just.
Wow.
She is free.
Right?
I have a whole bunch of people on Twitter who I have to chirp right now.
Tell them I said this.
What TVU are you?
Wow.
They're showing a different. Austin Penn's showing like something different. But
What TVU is it? Who's the podium?
Mandy, can you cover the law and crime?
I think I can put up the law and crime border.
I just cleared the rest of my day.
Wow. This is amazing.
I mean, that's
I'm not even kidding. I cleared the rest of my day so that I can do this.
that sense of
amazing
catharsis
day.
is real. I can't even begin to imagine how she's feeling.
Oh my God.
Not guilty, Dad.
Wow.
That is amazing.
Oh, he's coming out.
It only took 20 hours, well, in 2 years.
Not guilty on everything but the OUI. Everything but the DUI. Oh, he closed the door.
2 years, 20 hours, 2 verdicts, 24D program, 227. Suck on it, everybody.
Oh man.
There you go.
Chance for chance.
That's right.
There you
Not
go.
free Karen Reed. Karen Reed's free. That's right. And I agree with you.
Say that is, I was losing faith in the system, and
Yeah.
But yeah, as you said, Runkle, kudos to Brennan for
I give him
just
serious props. He could have come in and asked for.
could have been a
2
dick.
years.
Could have been a dick, and it's just like doesn't matter.
No, but it is. It says something after all that to at least.
One moment of ethics. Yay.
Yeah. Wow.
Melanie says Karen Reed has always been factually innocent. Suck it, Brennan. At least Lally was able to convince some people. I'm relieved for her. What does that say out there? Corrupted CPD and MSP.
Something.
Should I turn this up?
Turtle Boy is noting that he can't actually stream right now because everything's too loud.
Yeah.
Also,
all those phones sucking off the tower.
Yeah, that too. I was a little surprised by just like how fast the verdict was read. I mean, it was just like so quick.
Yeah, it was very quick. MSP needs a reboot.
Take the super jet down. I can't see.
Oh, I'm sorry.
Oh, there's Ian. Hi, Ian.
I was looking at the other screen. I wasn't on the. Hey, DePietro, you think this is funny? Loser.
Now they've got to turn around and charge DePedro because we need to know: will DePedro get a higher sentence than Jeremy?
I turned the volume down a little bit until she comes out.
Well, I know a few people are going to be having a rager tonight.
Everyone will be drunk driving in Canton tonight.
Yeah. Can's the DUIs are gonna be epic tonight. Gonna be big money night for Canton.
I'll tell you one person who won't be driving drunk.
The thing is, I would be shocked if she wasn't put on a plane to somewhere the hell else.
Yep.
This is not a safe town for her to hang out in.
Not today.
Yeah. She should have. I would have asked, actually, in the terms of my probation, that I'm free to leave the state.
Even if they
fair.
don't have her leaving the state, just like, I mean, I quite likely would have had a, like a cabin in the forest somewhere. Just ready to
hold
go.
up somewhere. Hold up somewhere.
And yes,
Wow.
Self Wiggins guilty on the OUI. She got a year probation, which is the sort of default standard for somebody. And I will give Brennan credit. That is a reasonable thing to do.
Yeah.
He thought about it. He was like, I've already taken enough shit.
It's very clear to me they talked about it beforehand.
Yeah.
Like in this time, they said, hey, it's looking like she might get the OUI. What are you doing? Like, where are you at on that, Brennan? And I'm betting he said, you know what? If it's just the OUI, I don't care. Like, that's it. Seeing a request in chat to go through the verdicts.
To go through
the
the
simple
verdict?
thing is not guilty on everything except
the
the
OUI.
OUI.
Yep.
Lesser included.
Yep. Not guilty murder 2, not guilty manslaughter, not guilty leaving the scene, and then guilty of standalone OUI. For that, she got 12 months probation and what is it called? The D24 program?
D24. Yeah. And Christy, you can bet the attorneys and Karen are going to speak when they come out. I feel pretty confident about that, but you never know. Meek says, I'm so happy Karen can breathe now. Words cannot express how happy I am. Second Hook says, I'll just read it instead of put them up. I didn't see John's family there. I wasn't looking now that we mention it, but what's the story there? God bless Kate and her, Karen, maybe, and her team of outstanding lawyers. Becca Wise says, this is huge for anyone who has ever been unfairly charged, tried, and convicted, and even convicted. Things changed as we shed a light in dark places of our justice system and demand accountability from leadership. Yeah.
Wow.
Karen is free. Danielle Lewis says, Karen is free. Thank you, Allie and Bob, for your coverage. Our friend Cammie Brown, who you were with us yesterday, she just texted me that she teared up. Let's see, because now I lost the text. He said, I teared up at her legal team's reaction. Morrissey resigned.
Wow.
Yeah.
So the 24D program apparently allows her to maintain a driver's license, I'm seeing.
Nice.
Wow. That's
potentially. It requires her to attend for 90 minutes per week for 16 weeks for counseling, self-help, a victims forum, and an alcohol program exit interview is what I'm seeing on. So
sure beats prison.
Oh, 100%.
Wow. God. What she must feel right now. What she must feel. The relief. Oh, my
apparently,
God.
she doesn't even have to install, like, there's not necessarily a requirement for an alcohol interlock.
Nice.
Yeah.
That's interesting.
So, I mean, in theory, she could, once she gets all the paperwork done, if she can, meet the standards for the for being able to drive. She's able to drive home.
Nice.
That is amazing. Amazing.
I mean,
so,
it's just such a shame that we see with our eyes how much has to be done to fight the beast that is the government. Like, this is not doable to any normal, average person, not even normal and average. She got so lucky that these lawyers wanted to continue to fight, and that I mean, this is not what happened. Every other case, someone's in jail for the rest of their life.
It takes a lot. It takes a lot to beat a case like this. Just
we all just
Apparently, it took like $3 million.
Yeah, I mean, and a team of lawyers that tried the second case on the arm.
Oh, I mean, the amount of money it would take to hire this team.
Yeah, no joke. Lots.
This is like, I'm just gonna say, OJ's defense team, they called the Dream Team. I actually think that Karen Read had a better team. I think that the Dream Team qualification has been taken away from OJ and has gone to Karen Read's team.
I agree.
The amount of money it would take to pay these lawyers, Mr. Jackson, Mr. Yannetti, Mr. Alessi, Mr. Wolf, all of that, like, to pay this team would be multiple millions of dollars.
Yeah. I mean, that would have been
Like per
at least
hour,
$2 million just there.
like per hour alone. Just
per hour of them.
like what, 5,000 combinand?
I think that right. I was thinking right, 500,000 each lawyer just for this second trial, and that's that's understating.
I mean, I've got legal shit going on right now. For a Supreme Court appearance, I fundraised a little over 50,000 Canadian.
Wow.
And that may not end up being. We'll have to see.
Yeah, I mean, and like to your point, Ian, like OJ's team, there was no continuity. Like these lawyers were truly a team. They worked together in a way that OJ, like, you just had a lot of names with OJ. They brought guys in.
Oh yeah, but this was like watching an engine.
Yes.
Every lawyer is a different piston moving in, a precisely timed sequence.
Yes.
And they work together like no team I've ever. Because I've been on defense teams before, and it's hard to work together in synchronicity because
it is.
We're used to being independent, solo, sharks in the water kind of thing, and now you've suddenly got to. Everything's got to synchronize.
Yeah.
I am astounded, and I don't know that we will ever see a team quite like this one. It is. But, I mean, just think about this. If you were not in Karen Read's shoes, where, and we got to give tremendous credit to Incarnate, Turtle Boy.
Yeah.
Because he brought attention. He
Yeah,
made a lot
absolutely,
of this
100%.
happen.
100%.
I want to give tremendous credit to Yannetti, because Yannetti was the first guy with his feet on the ground. Jackson did a tremendous job in terms of, I mean, he did a lot of the sort of, he's kind of the face of the A-team on this one, if that makes sense. You've got Alessi, who is brilliant at dealing with the scientific and the very difficult arguments sometimes. And, Ms. Little, we didn't get to see as much of, but she came out and she was obviously doing a lot of work behind the scenes as well. I would love to hear, honestly, Ms. Little, if you're watching any of these things, I would love to hear, like, because, I mean, she didn't get to speak as much, but you can see she's working hard in that courtroom.
Oh, yeah.
Oh, yeah.
Because when everyone else is talking or whatever, you can see she's sitting there, she's working. This was such a good team, and they were backstopped by a whole bunch of students whose names we don't know and we may never know. But I mean, all of those students had a chance to participate in something that is monumental. It's for the ages. It's a, I mean, if you're one of those students, this is going on your CV, right? Like this 100%. And if you're a defense firm out there and one of these students comes to you and is like, I want to work for you, fucking hire them.
Yeah.
Right.
Like
100%.
I mean, every one of these students, if they don't have a guaranteed, seat where they're not just being like, hey, here's a chair, but where they're being offered like a premium rate because this is clearly somebody who's above and beyond, then that's also an injustice, right? Like,
wow.
Yeah.
If they need a new intern, I'm available.
I don't think, does anyone know with getting one conviction that takes malicious prosecution off the table, or the other counts possible?
I don't know for sure.
Kurt was talking about that earlier. I don't know if you had tipped out,
Yeah.
you kind of like dipped into that concept of whether or not
Yeah.
it's going to preclude her from doing it.
So this
the one question I have, and this is an appellate thing, and I assume if she appeals the OUI, does that put the manslaughter back on the table?
No.
I assume not.
No, right. I thought for a second yesterday, and I was like, no, because it is an implicit acquittal of each of the charges ahead. So double jeopardy would attach to the other ones.
Yep.
Yeah.
If it was a plea deal on a lesser included, then yeah.
Yeah.
I mean, I also just, I mean, I'm rambling because I'm a little overcome here. This is a bit of an emotional thing. I was just, I was watching this and I was worried that I was watching an injustice, unfolding again.
Right.
Yeah.
And, but I mean, I also just want to give my tremendous thanks to each and every person on the team.
Yes.
Because it's clear that they did not just rule on emotion. Brennan came in on his close and he made the emotion pitch. Whereas the defense, in the one case where the defense is pitching the science, the defense is here going, the collision never happened. And I'm glad that they listened to that. And they clearly took their responsibilities seriously. They spent several days on this. They have given up weeks of their life on this. They have, and I'm sure that there were some difficult arguments in the back. I'm sure that there were some moments of, tension between jurors.
Yep. And I'm thankful for those people who wanted to say no, those people that felt like Will, wanted to buckle down and still say not guilty on everything, even in OUI. Thank goodness for you jurors who changed your mind, who might feel like, I didn't want to cave. I wanted to stand up for myself. I wanted to stay firm. You did the right thing. Karen Reed thanks you. The whole world thanks you.
Yeah.
So don't doubt yourself, whichever jurors are out there, because clearly that's what was going on back there.
Yeah, because we could say definitively now that's what they were hung up on. That's what the battle was. I mean, clearly. So
Yeah, I don't think she's likely to appeal because the probation.
Yeah.
No chance.
Yeah.
I don't
no chance.
Yeah. Why? Why?
I mean, the thing is if I was,
I wouldn't.
Yeah. No, I wouldn't.
I might offer the appeal for free, but
Heaven forbid I win and they send it back for resentencing. You know what I mean?
They
Yeah,
are
that's
the
the thing.
ones who requested. They're
The
the,
thing
ones who
is-
requested the OUI charge. I don't
I
even
gotta
know.
ask a U.S. thing: can they appeal conviction only and not sentence?
No, you can appeal either one. Well, no, not in that sense.
Because I mean,
Only appeal the sentence if it's. I mean, it's got to be.
if it was
abuse of
here,
discretion.
like if this was a Canadian case and I got this result, I could see going, I would like to appeal the conviction only. And I don't think, and the prosecution would be in a difficult spot for appealing the sentence because
No,
they
you
agree-
can do that. You can conceal conviction only and not raise any issue with the sentence itself.
But I mean, I'm sure at this point in her life, she just wants to move on.
Yep.
She admitted she was too intoxicated to go on the highway. If you wouldn't have done the highway, then that means your driving was somehow, some way impaired.
The standard, I looked it up, like the Massachusetts standard is you don't have to be a bad driver. It's just if your intoxication is to the point where it interferes with your driving to some extent. And so this is something that trips up, people when they get up on the stand, because the prosecutor will say, well, do you think your reaction speed might have been like just a little bit slower? And they'll say yes. And it's like,
you're
you're done. You're cooked.
Right.
You just agreed to it on the stand.
Right. So
You're
if,
done.
if she said, I wouldn't have driven on the highway in that condition, then she just said her driving was somehow affected.
Yeah.
I do have one question. I'm not sure if anyone knows the answer to. When at the end, the clerk said you have 10 days to send a note to somebody to seal something. What are we sealing?
Sealed. I think
verdict.
No, I think the whole. I could go back and look, but I heard it at Aiden Carney's when he got found not guilty. I think even everything is sealed unless you want it unsealed. So like the fact that this even happened to you is sealed unless you request it to be unsealed.
And the thing is I can't see why she would want it sealed because, like, you Google her, you're gonna see this, right? And they noted that if she has it sealed, that she's not going to be able to pull a record of her acquittal.
So then she'll send that notice, or her lawyers will.
Oh, I mean, Christ! If I was her, I'd have that framed on my wall, and I'd have a copy, like I'd have like a stack of copies for any time I have to apply for a job, that you can just stick that in there, right? This is, yeah.
What are they doing? Did they sneak out a back door?
Wow, man, they're
Probably.
gathering themselves. They're probably. Weeping,
they're probably
hugging.
There's probably people crying back there, right?
100%.
Sure. Scared Valley podcast said people all over one today, not just Karen.
Yep.
The justice system won.
Sus Bavaria said, I'm sitting in Germany crying because I'm so happy for her. Wow.
I mean, this was a huge win for the justice system in this country and people's faith in it, that it works or that it can work. I mean, it was huge. It's a huge day. The defense bar, man, a huge
it's so
day.
huge, but it's also a little bit deflating because the chances of someone else getting this powerhouse team, this is what it takes, though, guys. This is what it takes. So does it work? Is it restored? It's like, yeah, it's restored, but then reality sets in that no one else can get this. This can't be recreated. It didn't work once, for God's sakes. I mean, it was a hung jury. That's something, but
yeah.
Like, is Mandy going to try to actually chime in, or
can you hear me?
We can.
Yeah.
Okay, I just wanted to clarify. They did say John O'Keefe.
Yes.
right?
Yes.
They did.
Yes. 100%.
That man will live in infamy for that.
Yeah, that was Boston 10.
That is a fucking travesty within itself.
It really is.
Especially for that guy's career.
Right.
I mean, I'm just gonna say this is why the mainstream media is kind of losing coverage, because they couldn't get somebody to actually look at the pronunciation of the name before they're doing the coverage. They've dropped somebody in to be like, look, there's a whole bunch of people who have an opinion.
You work
and
in this,
I don't know shit about the case.
You work in this market and you don't know the name O'Keefe?
They were probably listening to Defense Diaries and caught on to Runkle's little innuendos he's been dropping all out.
Thanks, Ian.
Yeah.
Should somebody came up? Should we? Aiden's live. Should we stream a little?
Oh, hell yes.
Let's see what he's doing.
Oh, hell yes.
We'll keep an eye on if there's going to be a presser. We'll
I'll
jump
get
back to it. Yeah, pull Aiden up, and we'll chat with them. We'll celebrate. Man, what a day!
What do we do? What do we do now? What do we do now?
I mean, the thing is,
Why you gotta
I've
bring
been
me down,
looking
Kurt?
forward
Why
to
you
doing
bring me
other
down?
coverage because, yeah. You
Is
just
that
muted it.
now? That looks old.
You've also got the volume on super low.
All right. Maybe this isn't right.
There you go. Maybe the one. Yeah. There you go.
Thank you, Mr. Chair.
Oh Jesus!
Watch
This
this
is it. He doesn't have a signal.
Karen Reed. Shame on
The network's probably a bit. The network. Yeah, the network's a bit overwhelmed, so we've got a potato.
Continue to believe this. Farce that John O'Keefe was hit by a car. John O'Keefe was not hit by a car. John O'Keefe went and said Brian Alberts got the shit kicked out of him and a dog bit him. And then they threw him on the lawn like trash. And in his closing, he had the audacity to suggest a Karen Reed problem for using an analogy about a buffalo on a prairie.
Yeah.
They treated him
That pissed me off.
like trash day on Tuesday. That's the way they treated John O'Keefe. Don't have a word and Brennan ever again. Ever. I hope he follows him ever like the loser he is. That's what he is, a loser. So we're still out here. I have not had a chance to see the Reed family yet. As soon as the verdict was read and the sentence was put in, they immediately whisked us out. I didn't get a chance to hug the Reed family like I wanted to. But I was able to kind of do this thing with Reed, with Janet Reed, with Karen Reed. And so I'd like to see them completely. I mean, that'd be cool. Where's Kelly? Where's Kelly? Okay. I'm going to go down near the cars. We're going to go down to...
Yeah, go somewhere where you have a signal.
Oh no! Like go to a parking lot, like an underground covered parking lot. And,
Right. Blast off into space. Engineers know you can do it.
Yeah. I'd love to see the equations on that one.
Right.
Canton cover up 1. Now we're up to part. Can't cover up part 520. Not guilty. That's it. That's the whole thing. Not guilty. Not guilty. Not guilty. There we go. That's the next. That's the final installment of the Canton cover. AM Live. We have 40,000 people right now on my stream. Holy shit. Yeah, we have Kelly Reed here. This is Bill Reed's first cousin. Yes, Kelly has been here.
Oh, so that's Kelly Reed that's been on our stream.
Going to all court hearings. You know, she loves the family. Her and I become friends throughout this process. It looks like we're in some anticipation here, folks.
All right, looks like it's coming out.
Here, flip it to where we can see it.
That's a lot of pink, baby.
Oh man, there she is. Here, go to Boston 10.
I did.
There and Karen Reed holding her right hand over her heart.
Wow.
To the crowd. The other times that they've left the courthouse over the last few days, it's been with silence. They've been encouraging the crowd.
You're making the sign of the devil.
I love you.
This time, this is a victory walk.
love
She has been
you.
acquitted of all of the murder charges in this case, convicted only of a lesser included charge of operating a vehicle under the influence. This crowd has waited a long time to hear from her. Let's listen in as well.
Number one is I could not be standing here without these amazing supporters who have supported me and my team financially and more importantly, emotionally for almost 4 years. And the second thing I want to say is no one has fought harder for justice for John O'Keefe than I have.
She's not
and my
wrong.
team.
She's going to get criticized for it, but she's not wrong.
Thank the jury. Thank the jury, Karen.
And her dad is sitting here looking like an absolute badass.
Yeah.
What does it say about justice? I'm going to leave it. I'm going to leave it to Karen. Her dad has a comment. Let her dad.
Yes, I want to hear from her dad.
Me too.
I want to acknowledge
Look at that. They're losing their shit.
of our daughter Karen. The support. the support of the entire Reed extended family. I want to acknowledge the greatest team.
Yes.
Our first one that we found was David Yannetti.
Yeah.
We added Alan Jackson and Liza Little. Bob Alessi, you know about. All right. It was a fantastic team, but we needed them all to defeat this. We thank everybody for their support from the heart. We love you all of the content providers who help spread the word. Thank you so much. God bless you all.
Hey, we got some love, boys.
We don't. The thing is, I don't need a shout out or anything. It's nice that he throws it in there, but
are the lawyers not going to talk?
There, David Yannetti.
I'm just so happy to see the that we had a result here.
Wow.
Mr. Reed.
Wow.
Lally Brennan, you want to say any comments? Over some thoughts?
I'd love
You know what? If I'm Brennan at this point, you know what I do? I get up and I say, it was the Commonwealth's responsibility to put this in front of a jury. The jury has made the decision.
Yep.
They have come to a result. It is a just result because that is the basis of our system. The jury evaluated all of the evidence. They evaluated a case that I fought as hard as I could fight. But you are innocent until proven guilty in our country, and Karen Reed is innocent.
Yep.
That is the reason we have a system of trial by jury, and then walk on into the into the sunset. And I mean, if Brennan actually made a comment like that, I'd give him respect. I don't think he's gonna. I think he's gonna either just no comment his way out of there, or he's going to, say something like, "We disagree with the result." The prosecution should never be disagreeing with the result of a jury. They put on their best case, and that's their job. Right? You put on your best case, and the jury decides legally. So,
right. See if they're talking anymore.
People are aware of what's happening. I gotta go.
What's the message? I got you, sir. I'm right behind you. I'm right behind you. I got you. All right, you.
They got everybody.
Wow. Yeah, they out. They're gonna bring Karen to an undisclosed location and open a bottle of champagne or 5 and celebrate a great day for justice. Man. Wow.
Christ, at this point, if I was in Massachusetts, I'd be volunteering to wherever she is. I'll sit in a car with a shotgun to make sure nothing goes down. Because I mean, I'm already seeing people online basically going, and making not quite overt threats, but the subtle threats, and I'm like, ooh.
Are you seeing subtle threats already?
Oh yeah, I'm seeing one way or another, Karen Reed will get hers and that kind of shit, and I'm like, yep. So
forever mindful or forever MJ-ful. So the way David cried when hearing the verdict, as well as the rest of the lawyers, they had their hearts in this. OMG, what a team. What a great group of individuals. Thank you for making history.
Man.
It was a lot. And it's, as much as as much as I want to be on a high and be like, the system can work, I just keep coming back to, for this one person, for this one time, because all things aligned, that she was able to have supporters that helped her, lawyers that helped her, family that helped her,
Coffin Dapper just posted half an hour ago saying, I hope she gets the maximum of 2.5 years. It's like, well, by the time you posted that, she'd already gotten probation. So sucks to be you, Coffin Dapper.
Yeah, she had to turn. If you'll notice, she turned off the comments.
Yeah, well, that's kind of her go-to.
Yeah,
I'm also gonna have to dip in 15 minutes because I've got what is it? I agreed to go on and do an interview with Law and Crime.
Nice.
And I'm sure they were like, where do you think the jury's at? Well, I've got an opinion.
In the evening of February 9th, 2004, almost 18 years ago, Maura Murray crashed her car on Route 112 in Haverhill, New Hampshire, never to be seen again.
The mysterious disappearance of Maura Murray is a story that's been told hundreds of times by strangers. But absent in the story you've heard are the voices of those who knew Maura, those closest to the investigation. Not anymore. I'm her sister, Julie, and from media pressure, this noise and reveal who Maura really was with exclusive interviews.
It's terribly frustrating. Fred Murray has been frustrated since the day his daughter disappeared.
Wrong button.
No, I don't even have anything Maury Murray anywhere near my computer. I stopped sharing my screen. I tried to reshare a different screen.
The way that was shared, it seems like it was a direct upload to your backend.
Yeah, well,
someone
it's
clicked
a
the
video
backend.
clip. Yeah, it's a video.
So
clip.
someone on your backend clicked the play that video clip button.
Yeah, it had to have been. And Mandy's not even here. It had to have been you, babe.
I didn't, babe. I touched.
Guilty.
Okay, I mean,
We need another trial. We're going to spend $1 million on this. We're going to hire the Aperture guys, and they're going to paint themselves. I don't know. Well, I guess they might have to paint themselves pink this time, rather than the particular choice of blue paint. So,
Man, what a day! What a day!
we got a
Wow.
lot of supers to go through, babe.
Yeah,
A lot of supers to go through, babe.
yeah.
I noticed it says comments 10,000. There's a few chats today.
Yeah.
333 super chats. You guys are doing pretty good. I have to at some point read the super chats that came in on my channel too.
Yeah, we will. Everything that came
Wait,
through.
are they up here? Because I'll
No, because
definitely-
I'm not sharing that way. I'm the way I'm doing this. I'm not streaming it through StreamYard. I'm just capturing the entire window and streaming it in an OBS. We're doing it. We're doing it down and dirty style.
Yeah.
So you have supers that you have to answer as well.
Oh yeah.
All right. Well, do you want to read one of yours?
Let's see. I have to pull them up. Which where are they? Hold on. Was not ready for that.
I'm just saying. I'll
$4.99 from Robbie M. After all they've been put through to get to this point, the DUI OUI conviction is minute at most. Even the IUI conviction is still a victory for. I agree.
Yes.
It is absolutely a victory.
Absolutely.
Victory.
Oh yeah, and for whatever it's worth, that does mean she loses her federal firearms rights, so she can't celebrate by going shooting. That's very sad.
Is that
And you can't go visit Ian.
I have. Well,
I don't know whether it means that or
I
not.
actually have a hard time getting across the Canadian border.
That's my
which is
understanding.
unfortunate because otherwise, if she came here, I would say
Now what are we doing?
stop clicking buttons.
I didn't do a damn thing.
But,
There's something in your. I didn't do a damn hit thing. She's holding up the remote in her hand.
No, that's babe.
Otherwise, I would say, if the U.S. won't let you play with guns, come on up here. I've got guns. We can go shooting. I've got a World War II Luger. We can go shoot that.
So wait, is that statewide? Is that federal? I'm unaware.
Yeah, 18 USC 928G.
Every
4.
state conviction of a DUI.
Well, no, because in this particular case, it's any sentence in which the crime is capable of being more than 1 year, and she was convicted to a crime that has a maximum sentence of 2.5, which qualifies.
Can I just also say that is some absolute bullshit? That the U.S. should, like Canada, doesn't take away your firearm ability because you.
But
got
you can't even enter the country from the United States if misdemeanor DUI conviction.
I mean, she should be able to get her gun rights back. Like 100%.
Well, yeah, she can petition the Attorney General for returning of her rights because they actually are doing that now. They weren't restoring rights for like 40 years, but they actually restored a couple pieces of rights recently. So she can petition the AG.
That's like saying if you're convicted of drinking alcohol, period. Like, how is it any different that you drove means you can't have a gun, but you drink and you can have a gun, but you just can't drink and drive and have a gun?
I don't know.
Is it
I don't invent these rules. I'm just here to tell you what the rules are.
Wow. Well, the therapist said at 8:30 this morning, why did the defense ask for OUI as a separate charge instead of a lesser included?
They had to.
The defense can't ask for a separate charge. That has to be an indictment brought by the prosecution. Are they betting the jury won't convict on the lesser, since that would mean guilty on full count 2? No, they were betting that they would convict on that. They felt the need to convict on something, and that would bring this case to a close, and their gamble paid off. It took a while, but it paid off. Boston Colleen says, do you guys think the media coverage is so intense that the FBI will feel it necessary to pursue the real story when Karen is acquitted?
No.
Nope.
FBI doesn't care.
Nope. What do you got for us on civil law?
In terms of what?
I don't know if you want to. I want to make sure you've got time to read in your supers. If you.
I mean, I'll do them later if I need to or something. But LSR for $10 said finally over. Thanks for the quality coverage on civil. And by the way, just want to say thanks for all the people that were tuning into me today. I really appreciate it. Really appreciate everyone's politeness and courtesy in the chat. We had a really good chat over there today. So a lot of fun today. And it is validating to me having so many people be there. It's like, you feel like you're doing something right. So having people tune in was very uplifting. So thank you for all that.
Yes.
Thank you, both of you, for joining us. This was amazing.
Yeah.
And you're on Court TV, you said tonight, or long time?
Long time, I think. And I also want to give a shout to Trooper Proctor, who I understand is right now collecting John DePetro's tail light and sprinkling him over some other crime scene.
Oh no, never gonna get a conviction then. Oh no.
Where are they gonna find snow today? I hear it's like 100 degrees. That's gonna be challenging.
Well, no, it'll be the humidity level.
Oh, okay. It was buried under the humidity. I see.
Sure, that agree with you 100% on your police work there, Lo.
Drive down like OJ style. That's what they're airing right now.
But shout out also to the FBI for saving this by providing us with ARCA and stuff like that. So they did some good stuff.
Where it came from.
Yeah, I'll give this little audio clip.
You ask for miracles, do you? I give you the FBI.
Yeah, man, what a day. Yeah, I am so thankful that both of you came and hung today. Hung today, and
I'm just glad that the jury didn't hang today.
Right.
Tell me about it, man. Like, that would have been just a nightmare scenario. So it's always fulfilling when you have a day like this. It's kind of like you're living vicariously through that team, that defense team, if you've been on that side of the bar, because you know what that feeling's like.
They hung for like 20 hours, which is longer than Brennan hangs.
Yeah. Because he's got that little blue arm.
Yes.
I love it.
Well, guys,
I mean, if Welcher gets fired, how's he going to afford blue paint?
It's gonna be tough.
He goes through a bucket of that stuff a day.
He could get a job at many kindergartens across the state.
Also, I'd like to congratulate Burgess, who right about now is probably getting that notice of termination. I hope you have a great career
I think it's
ahead of
probably gonna
you.
be 3 months.
Yeah.
The school replied to, said, please don't even don't even try to come to our school anymore. We don't like it seeming like it takes 18 years to get a degree.
I think it's going to be like 3 months, and then they will say, we have decided to go in a different direction, or more likely they'll pull him into a meeting. At the end of that meeting, he will submit a resignation letter, and they will say, we offer our congratulations to Mr. Burgess, who has decided to pursue other opportunities in food service or aluminum can collection. And
lunch lady. So, all right, you guys plug your channels right now. I demand it. I know that we've been throwing them up in the chat, but tell everybody where they can find you if, for whatever godforsaken reason, they don't already sub your channels.
Well, I'll start because I promised my chat that when the verdict was announced, we would do a merch giveaway. So now seems like a good time if anyone wants to head over there. So we're gonna do 8 giveaways at $20 of merch, and that's in celebration of me passing 150,000 subscribers like 2 days ago. So yeah.
Well done.
So in honor of that, I'm giving away 8 times 20, which for the purposes of this exercise is 150. And we're going to do that over at my channel. And you can follow me at Uncivil Law. It's the cool place to hang with all the cool kids. We cover a lot of cases over there. We also cover a lot of Supreme Court stuff, and I'm behind. There was like 5 cases on Thursday from last week. There was a big case out of Tennessee today dealing with Dealing with gender affirming care. Tennessee banning gender affirming care came down from the Supreme Court today that I have to cover. So some controversial cases sometimes, covering a lot of cases. So you can check us out over there at Uncivil Law. And for the moment, I'm looking forward to not doing streaming every single day. So that's great.
Oh man,
Subscribe if you haven't already. Let's get Kurt up to the 200,000 subscribers.
Let's go.
All right. Well, thanks, Kurt.
And
go do your giveaway.
All right, we'll do. Thanks.
Bye.
Thanks,
Kurt.
And you can track me down. I'm at Runkle of the Bailey. If you put in.
All right, guys. How you doing? We're going to do a giveaway. It's going to be fun. Yeah, I think we'll do the 8 times 20 thing. That sounds good. Let's find some clips that we can use so that you can enter. Hold on. Let's see. I need to set this up. Give me a second. Talk amongst yourselves while I set this up. And we'll do one thing that you only have to enter once, and then we'll just do 8 draws because that makes sense. I have to get rid of that little thing that's on my screen. So you only have to enter one time, and 8 people will win because I'll do 8 draws, and that will be good. Excellent. All right, so let's see. Let's see what looks good. Oh, this is perfect. All right, so now I have to set up a bot to look for the thing that you type into chat. Let's see. I go over to Nightbot so I can set it up so it can listen for the thing. Continue talking amongst yourselves. How do I sign in? I know. I just want to sign into the bot. Okay, great. All right, so I need to set up keyword. Great. All right, do that. Great. All right, and then the name of this is going to be This is a lot of effort to go through. Lol. All right. Cool. Great. Why are there entries in the giveaway already? That doesn't make any sense. Reset entries. Yes, would I like to reset entries? Yes, I would. Yeah. Great. All right. Oh, Lord. I'm a competent streamer, I swear.
Hi, Evie. I'm a ton of fun. I'm a fun guy. Let me eat your fucking ass. Evie's on her laptop, pissed off again. Scrolling through clips like this motherfucker sin. Sipping her tea, typing fast as hell. Doing background checks like she's building a cell. She's got tabs open like a Fed's only sting. Searching for dirt while Nick's doing his thing. He's live streaming, laughing, taking shots with bro. She's like, this bastard needs to get exposed. Nick's in your fucking head, rent free, no joke. While you're writing blogs, he's lighting up smoke. He don't even name you, don't even care. But you stalk his feed like he's breathing your air. Go take a nap, go touch some grass. You look like Twitter gave your brain whiplash. You dropped a Substack like it's gospel law. Trying to cancel Nick with a dramatic how. You quote case law like you're dropping bombs. But the whole damn vibe screams mad.com. You got no jokes, no laughs, just rage. A 1,000,000-word essay just to set the stage. You said he's vile, a menace, a clown. But it's you writing novels just to take him down. Nick's in your fucking brain like a squatter on crack. He's making dad jokes, you're planning attacks. You tweet accountability in all caps, but girl, nobody buys the shit you sold. He's cracking up, his fans throw tips. You're sitting in the dark with chewed up lips. You've got folders named Nick with receipts and stats, trying to take him down like it's Mortal Kombat. You say you're helping truth, bringing justice in waves, but you dig through live streams like you're raiding graves. Could've chilled out, had a wine, watched a flick. Instead you're obsessed with roasting this prick. You're writing think pieces, line by line, while Nick's out living rent free in your spine. Nick's in your fucking head like a VIP ghost, throwing up middle fingers while you're doing the most. You call him toxic, call him trash, but he don't respond, and that's what makes you crash. So here's your crown, queen of the feud, scrolling his clips in a badass mood. You ain't taking him down, he's 10 steps ahead, cause Nick Ricciano lives fucking rent free in your head. Evie, let me eat your ass. John's dead. I'm a ton of fun, I'm a fun guy.
Oh, Suno, your digital delight. Always there to